Może. Szanowni Państwo, szanowni goście, arbitraż jest dyscypliną rozstrzygania sporów, która przetrwała wieki. Przetrwała okresy bardzo trudnych, historycznych momentów, okupacji, zaborów. Obecnie musimy się zmierzyć z nowymi problemami, a mianowicie z epidemią wywołaną wirusem COVID-19. Już w ubiegłym roku podjęliśmy próbę zorganizowania konferencji w inny sposób, bardziej nowoczesny, w sposób online. Obecnie w dniu dzisiejszym również tą próbę podjęliśmy. Jest to już 14. konferencja Arbitraż i mediacja w teorii i praktyce. Dzięki nowoczesnym technikom komunikowania się możemy zaprosić do grona nie tylko wybitnych przedstawicieli arbitrażu i mediacji z Polski, ale również z liczących się ośrodków arbitrażu i mediacji z krajów Europy Środkowo-Wschodniej, ale i z innych państw jak Chiny, Singapur, sułtanat Brunei, Stany Zjednoczone. To dzięki pomocy wielu współpracowników i ludziom zaangażowanych możemy tę konferencję kontynuować. Chciałem również Państwa poinformować, że nasze wysiłki zostały docenione przez najwyższe władze państwowe. Honorowym patronem nad naszą konferencją został objęty przez pana prezydenta Rzeczypospolitej Polskiej. Dziękujemy również innym osobom, które z nami współpracują. Dziękujemy panu senatorowi Libickiemu. Bardzo dziękujemy panu staroście Wilkońskiemu, staroście nowotomyskiemu, który przez wiele lat nasze inicjatywy wspiera. Proszę Państwa, oprócz tych akcentów prawniczych i nie tylko prawniczych, arbitrażowych i mediacyjnych, chciałem zwrócić uwagę, że konferencja ma też wydźwięk ponadregionalny, kulturowy. Jak Państwo widzicie, uświetnił tą konferencję występ zespołu Lwowianka, który promuje naszą kulturę w regionie, a w tej chwili za granicą. Dziękuję serdecznie wszystkim za uwagę i teraz proszę o odczytanie listu z kancelarii pana prezydenta Rzeczypospolitej.
Warszawa, 6 maja 2021 roku. Szanowny Panie Prezesie, w imieniu Prezydenta Rzeczypospolitej Polskiej Andrzeja Dudy dziękuję Panu Prezesowi za skierowane do Pana Prezydenta zaproszenie do objęcia patronatu honorowego na 14. edycję konferencji z cyklu Arbitraż i mediacja w teorii i praktyce. Czy COVID-19 spowodował odhumanizowanie alternatywnych metod rozwiązywania sporów, która odbędzie się online 14 maja 2021 roku. Z przyjemnością informuję o objęciu nad tą wartościową społecznie inicjatywą patronatu honorowego prezydenta Rzeczypospolitej Polskiej Andrzeja Dudy. Państwa przedsięwzięcie od lat z sukcesem propaganduje alternatywne formy rozwiązywania konfliktów oraz popularyzuje wiedzę na temat sądownictwa polubownego. Majowe wydarzenie z udziałem polskich i zagranicznych teoretyków i praktyków zajmujących się zagadnieniami ADR będzie z pewnością znakomitą okazją do debaty na temat wpływów pandemii COVID-19 na arbitraż i mediację w kraju i na świecie. Życzę Panu Prezesowi oraz wszystkim osobom zaangażowanym w przygotowanie konferencji wielu ciekawych dyskusji oraz satysfakcji z jej udanego przebiegu, a także dalszej pomyślnej działalności sądu arbitrażowego przy Nowotomyskiej Izbie Gospodarczej. Z szacunkiem, Wojciech Kolarski.
Poszło.
Szanowni Państwo, bardzo się cieszę, że chociaż w ten nietypowy sposób, ale mogę wziąć po raz kolejny udział w konferencji Arbitraż i Mediacja w teorii i praktyce. Na początek chciałem bardzo podziękować za zaproszenie do tego specyficznego wzięcia udziału w konferencji, tym razem panu Włodzimierzowi Brychowi, bez którego ta konferencja się nie odbyłaby i która się zresztą od wielu lat odbywa w Nowym Tomyślu, w moim okręgu wyborczym. Wiem od pana Włodzimierza Brycha, że w sposób szczególny ta konferencja w czasie pandemii się rozrosła, że skala jej międzynarodowa przeszła najśmielsze oczekiwania. Okazało się, to paradoks, że coś, co jest pewnym kłopotem dla nas wszystkich, akurat jeśli chodzi o tę konferencję o arbitrażu i mediacji, przyczyniło się do jej rozwoju. To jest bardzo ciekawe zresztą, bo myślę, że jak wiele sfer naszego życia w ostatnim czasie przeniosło się do sfery wirtualnej, być może to jest jakaś wskazówka co do tego, jakimi drogami wiedza o arbitrażu i mediacji ma się roznosić, bo nie jest jeszcze, jak wiadomo, ta wiedza tak dostępna szeroko, jakbyśmy tego chcieli i jak warto by było, aby ludzie w sporach z tych narzędzi, które daje arbitraż i mediacja, mogli korzystać. Bardzo się cieszę, że po raz kolejny ta inicjatywa jest inicjatywą pana Brycha i Nowotomyskiej Izby Gospodarczej. To pokazuje, że duże i ważne wydarzenia o charakterze, już możemy powiedzieć, światowym mogą dzisiaj, także dzięki technice internetowej, ale nie tylko, bo przypomnę, że poprzednie konferencje odbywały się z licznym osobistym udziałem gości zagranicznych, że mogą się odbywać wcale nie w największych ośrodkach, wcale nie w miastach wojewódzkich, w stolicach województw. Mogą się odbywać tam, gdzie po prostu są ludzie z pomysłem i determinacją, aby rzeczy ważne na skalę europejską i światową przeprowadzać. Wreszcie na koniec chcę bardzo jasno powiedzieć, że musimy wszyscy, także ja, jeśli Państwo uznacie, że w jakiś sposób będę tej sprawie przydatny, popularyzować arbitraż i mediację. Zwłaszcza teraz, kiedy szczególnie w Polsce jest tyle wątpliwości co do drogi sądowej. Tyle wątpliwości z jednej strony wynikającej z przedłużania się postępowań, z tego, że sądy są zatkane sprawami obywateli, a z drugiej strony także dlatego, że dzisiaj wskutek tego, co dzieje się, jeśli chodzi o tak zwaną reformę wymiaru sprawiedliwości, są również wątpliwości, i to szerokie w różnych kręgach społeczeństwa, co do tego, czy sądy w Polsce są dzisiaj, czy mogą być niezawisłe i niezależne, w związku z tym sędziowie niezawiśli, a sądy niezależne, w związku z tym, co rządzący planują, jeśli chodzi o tak zwaną reformę wymiaru sprawiedliwości. I także z tego powodu, moim zdaniem, znaczenie mediacji i arbitrażu będzie rosło. Wszystkim Państwu życzę udanych obrad i mam nadzieję, że chociaż testujemy tą nową drogę internetową, to jednak kiedy nasze życie wróci chociaż trochę do poprzedniego stanu, będziemy mogli się spotkać po raz kolejny osobiście w Nowym Tomyślu, na co bardzo liczę. Bardzo serdecznie dziękuję za zaproszenie.
Szanowni Państwo, cieszę się, że po raz kolejny, mimo nadal panującej na świecie epidemii koronawirusa, dołożyliście wszelkich starań, aby wspólnie porozmawiać o mediacji i arbitrażu. Jestem zaszczycony możliwością objęcia patronatem imprezy stanowiącej jedno z ważniejszych wydarzeń związanych z ADR w Polsce. Uczestnictwo tak wielu osób w konferencji z cyklu Arbitraż i mediacja w teorii i praktyce, w tym wybitnych teoretyków i praktyków arbitrażu i mediacji z kraju i z zagranicy, świadczy o wysokiej renomie tego wydarzenia. W stosunkach między przedsiębiorcami konflikty są nieuniknione. Te poważniejsze często mają swój finał w sądzie, jednak nie dla wszystkich dochodzenie swoich praw w ten sposób jest korzystne. Proces sądowy to długa i kosztowna procedura, a w obrocie gospodarczym ważne jest nie tylko szybkie rozwiązanie sporu, ale także w miarę możliwości zachowanie dobrych stosunków między stronami konfliktu. W takiej sytuacji sprawdzają się alternatywne sposoby rozwiązywania antagonizmów, takie jak mediacja lub arbitraż. Zapewne zgodzą się Państwo, że istotą alternatywnych metod rozwiązywania konfliktów i sporów, w tym mediacji, jest nie tylko załatwienie sporu jako zjawiska prawnego. Rola mediatora nie polega na narzucaniu rozwiązań czy ocenianiu stron, ale na umożliwieniu dyskusji i moderowaniu jej. To właśnie dzięki mediatorom stwarzane są warunki do poprawienia komunikacji, wzajemnego zrozumienia i dojścia do konsensusu obu stron. Wykorzystując nowatorskie metody organizowania zdalnych konferencji, przed komputerami, w domach czy w biurach zasiadło zacne grono aktywnych ludzi, dla których praca na rzecz drugiego człowieka nie ogranicza się do zawodowych czynności w ramach wykonywanych obowiązków. Wręcz przeciwnie, Państwa zaangażowanie w popularyzację mediacji jest często niedoceniane, traktowane z pewnym dystansem czy wręcz niezrozumieniem bądź lekceważeniem. Za ten Państwa wkład w tworzenie dobrych warunków dla kształtowania pozytywnych przekonań, że sprawiedliwość nie musi być ani bezduszna, ani obca dla zwykłych obywateli, pragnę gorąco podziękować w imieniu wszystkich, którzy mogli i będą mogli w przyszłości skorzystać z tak pojmowanej roli wymiaru sprawiedliwości. Życzę nie tylko owocnych obrad, lecz także wszystkiego najlepszego i wiele satysfakcji w Państwa życiu osobistym i zawodowym. Wyrażam ogromną nadzieję, że w przyszłym roku dane będzie nam spotkać się w stolicy powiatu nowotomyskiego oraz jak dawniej wymienić swoje poglądy i przemyślenia nie przed kamerą, ale w sali konferencyjnej, jak to bywało dotychczas.
Panie Pawle.
Good morning, good afternoon, or good evening, wherever you are. But it seems that this conference is truly international, and due to the virtual possibilities of connections with all of you, with the participants, we can have participant speakers and people who just participate and listen to the specific presentations from all over the world. My name is Paweł Pietkiewicz. I was requested to make a short introduction into the section that is going to be devoted to arbitration. And it seems that the issue of this specific conference is very valid. It's very important for today's practice, of arbitration. What we experience right now, the coronavirus pandemic, is something unexpected, something unusual, something we're not really ready to cope with. And for that reason, that influenced all of our lives, all of our business, and the way we act, the way we work, the way we lead our lives. And obviously that also impacted very much arbitration. And there's a huge question how coronavirus pandemic affected the arbitration and what is going to be the result of that. What is going to leave this experience for the arbitration for future. Now, obviously, as I said before, the coronavirus experience did not leave arbitration untouched. And it seems to me, and I think this would be visible from the specific presentations of each of the speakers, that the pandemic, that coronavirus, influenced arbitration specifically. Why so? Because arbitration, to a big extent, is very much relying on your communication, on a very direct and very say personal communication, both between the counsel and its client, between counsel and witnesses, between counsel and expert witnesses, between the arbitrators and the parties, and obviously between the counsels of both sides. Now, it's not only valid for all this time that is preparatory for the hearing, but it seems to me that it's all very much exacerbated in the hearing itself, because hearing is the most, I may say, intellectually intensive part of the proceedings, and this is where the personal and direct communication between the parties and arbitrators, between the arbitrators and the fact witnesses and expert witnesses is very important. And as you all know, the hearing is of that kind that it's not only I say somehow summarizes all this work for the preparatory work for the presentation of the case, but is also very dynamic, and to a big extent the way the hearing goes, it may very much influence the final word, how the word is being phrased, and basically I would say in a very simple words, who wins. Therefore, it seems that the influence of coronavirus is significant for arbitration. Now, the issue that came up for that reason is whether, because during this coronavirus experience, we are very much devoid of this experience of being able to directly and personally communicate with each other, whether this really dehumanized the arbitration or not. And this is a very big question. And then not only this question is valid for today, but that question is also valid for future, how this will impact the development of arbitration in future. Now, what we're going to see or going to hear today from various different participants and speakers, and then obviously we can have this discussion after the presentations, is the question of dehumanization of the arbitration process itself. We would see whether the current means of communications and the sheer issue that arbitration went virtual to a big extent, whether this really impacted the way the arbitration is being held, is being run, and whether this very much influenced the decision-making process. A very interesting presentation would hear about the artificial intelligence and how this may supposedly, as a result of coronavirus, impact very much arbitration proceedings. I think to some extent that issue was already raised by Senator Mr. Libicki, who said that due to coronavirus, we're able to meet ourselves over the virtual connections and have a discussion between various different countries and different participants from all over the world. And I think to a big extent that experience of coronavirus also exacerbates the possible usage of artificial intelligence in future. We would also see the perspective of the coronavirus influence on arbitration from various different jurisdictions, and this is going to be also interesting, and this is going to be more like concentrated or specific issues from or problems or solutions from various jurisdictions and how they cope with it. Now, we're going to hear the reputable practitioners, we're going to hear renowned academicians, we're going to hear the presidents of the arbitration courts from various different locations. It seems that we have an amazing and very interesting collection of speakers today who would present various different subjects that eventually may be discussed by all of us at the end of the conference, at the end of the event. I wouldn't be bothering you anymore. Now we would start the specific presentations of each of the speakers, and the discussion will be held at the end of both sections on arbitration and on mediation. And I think that's it from me. I hope you will enjoy the hearing, and I think this is going to be very interesting to see the presentations and views from all over the world. Thank you.
A very good morning. Welcome to our conference. COVID-19 has brought about changes all of a sudden arbitrators have had to learn different systems, Microsoft Teams, Zoom, Skype, and review attachments in their laptops, share the screen, mute and unmute themselves, raise their hand when asking questions, turning on and off the camera when it's needed, and finally move from a virtual room to a virtual council room. All of these factors seem to point to a new arbitration reality. All that has become a novelty over the past 1 year is slowly becoming the new norm, the new normal. Not all, however, have learned the tricks of the trade. The eldest seem to be having the biggest difficulties, and we are losing the experience of so many arbitrators who cannot come to terms with the new normal. The theme of our conference departs from the praising of the changes because of the COVID-19 pandemic. Has the pandemic dehumanized ADR proceedings? Online proceedings were not the preferred format of arbitrators and lawyers. It is problematic to conclude matters which began before the COVID-19 reality. We can, in fact, marvel at the closing of the distance, the savings we make in terms of money and time. We don't need to travel long distances and find accommodation in a hotel to conclude a proceeding. I've had a number of international cases, arbitration cases. I also participated in an on-site inspection via a drone. Has this new normal become the norm for us and for the posterity? Are we going to do everything online? And here we have reflections of philosophical, historical, and futurological aspect. How is it? Why is it that we think about the future as an augmented present? When the 20th century was looked upon, it was seen as a century of dirigible balloons, of telegraph lines, and steam engines. However, in the mid-20th century, the future started to be seen as the exploration of outer space, the serial production of space rockets, and vacations on the moon. Nothing has happened of this sort. So can we really believe that online ADR is going to stay with us forever? Is it better than traditional solutions? Frankly, I am not so sure. In order to stir the atmosphere of our debate, I'd like to pose a few provocative questions. My concern, my doubts are due to purely technical reasons or technical glitches that we can have. You can find online a lot of footage that ridicules online proceedings. Somebody may doze off in front of the screen. Some lawyer and when he entered the proceedings, a cat appeared rather than a human being. Well, it was really a hit of the YouTube for a time. In Austria, we had a situation where the arbitrator was rolling his eyes during the proceedings. After the arbitral award was issued, the wronged party, so to speak, appealed against the award, saying that the arbitrator was showing his bias towards one of the parties. And this reminded me of another history of a sleeping arbitrator in Germany who allegedly dozed off during the proceedings, and the party which was dissatisfied with the award wanted to appeal it, and the court processing the appeal said that if the arbitrator slept during the proceedings and the party did not raise any objections, then it is now too late to appeal against the award. Online broadcasts definitely create more possibilities for such unwanted gestures, mimicry, facial expressions, and so on and so forth. I believe it's extremely important to be credible in the image we get. It's important also the background against which the witness or the party is shown is also important. Very recently, I spoke with an expert witness who introduced himself against the background of some waterfall in a jungle. I asked whether he was on vacation, and he simply said that no, it's his background. Simply, well, you can have different backgrounds, but unfortunately, you need to be mindful of the seriousness of it. Also, we had a prosecuting attorney who was interviewed by a reporter, and the prosecutor appeared on the screen against the background of showing the interior of some American legal library. All of us who have worked in the United States know what kind of books you can find there and in what order. Each of these books is about $100, $200, or $300, and there are no books like that in any Polish library and in such sets. And the prosecuting attorney did not see these books in person. She may not be able to learn to know English to be reading this. And is this decoration of her private apartment strengthened her message, the message that she wanted to convey? There are many other pitfalls of online broadcasts, of online proceedings, the technical ones that arise from the delayed reaction of our devices. Usually the sound precedes the visual. My lecture is going to be recorded. We have full sync between my recording and the visual and the sound and the audio. And if I spoke live, you are bound to first hear me and then to see my mouth moving. This often happens, and this may cause certain problems. Let me refer to our own experience. Last year, during our conference, I was abroad and I was watching our conference on the screen, and at one point I saw our president, Włodzimierz Bych. I thought it was a great moment to share a reflection that entered my head. I caught my phone, I called Mr. Bych, and I told him everything. Everything was okay. I watched the screen, and 2 minutes later, I noticed on the screen that Mr. Bych was taking a phone, standing on his desk, and I saw that he was talking with someone, and I realized by the duration of the phone call, I realized that he was talking with me. So what actually happened 2 minutes earlier, I saw 2 minutes later. You may say that this is a funny matter, but supposing we had a third party that interferes between the sound and the image, interferes and modifies. The Winter Olympic Games in Sochi were broadcast live, apparently, and millions of viewers believed that they were watching live sports events. Also, the journalists that were commenting the games from their studios. However, the hosts delayed the broadcast by a few minutes, so the viewers participating in the event live, participating in the event in the say hockey stadiums, they saw everything live, but TV viewers saw it a few moments ago. Probably nobody would have noticed this had it not been for polls, because at one point we saw during one event a map of Poland, and on this map we have the Kaliningrad Oblast, part of the Russian Federation, and this provoked a lot of laughter in the stands among the Polish audiences. However, nobody saw this in the world because the image of this broadcast was modified, and the map of Poland was shown without this part of Russia. So if you can modify what is said and recorded, don't you think that arbitration proceedings are at risk? Big Brother is watching you. We should know from George Orwell that we are being watched. We live among cameras, among CCTV cameras, police drones that patrol the city from up there. Donald Trump his phones were tapped. His statements were manipulated. So a question arises whether international arbitration is becoming safer after it left the closed arbitration rooms, and is it safer now when we have no confidential talks between the arbitrators during coffee breaks or during joint dinners or breakfasts in the hotels? Nobody will send a spy drone or will interfere with the documents of an arbitration proceeding related to one outstanding invoice. But can we be sure that this will not happen when it comes to disputes about the boundaries, state boundaries, about disputes related to the armaments industry or national economy issues? Don't you think that an online proceeding and the microphones and cameras, don't you think that we cannot be, say, intercepted, that the audio and the video cannot be intercepted? Also, what happens between us, the parties, and the representatives of the parties? Do you think that our communication is safe? How about if we deal ad hoc? Can we guarantee to the parties that we are not being, that our conversations are not intercepted by intelligence services? Online arbitration also poses another set of problems, unprecedented set of problems. Quite recently, I participated in a discussion over an award. My colleagues, arbitrators, actually were at loggerheads. Actually, this is because the arbitrators were relying on a hard copy of a document and then on an electronic copy of the document taken from the cloud. And it turns out that one of the documents did not have one line, which was crucial for us to agree upon an award. As to our youngest colleagues, I would like to express my paternal concern about online arbitration. If you hone your skills and become skilled in online arbitration, are you going to be able to function well in the traditional format of arbitration when the fracking virus stops being a threat? I can hear from my friends in the business environment that more and more often in online transactions it is harder and harder to negotiate the terms and conditions. Entrepreneurs complain that through the screen they do not feel the emotions of the other party. They do not know whether the opposing party is calling their bluff or whether they are trying to pull their leg. You cannot feel and sense that through the video and audio. English barristers concur with that, saying that the most important element during the cross-examination is the silence. The silence that falls between the question being asked and the answer being given. This silence is very valuable if I can use the word. The voice quavering, a shadow of doubt expressed through this show to a seasoned arbitrator, judge, or barrister whether the party or witness only make believe that they don't remember something or whether they really don't believe something. I believe myself that the best screen of the best computer will not dispel all the doubts. And a few words to our mediators. A year ago we had wonderful presentations from our mediators who shared their experience with online mediation. All of us benefited tremendously from these reflections. I am thankful for these reflections. However, today my task is to provoke discussion, which may somehow not be in line with the praises we hear about the situation about the online mediation. Let me ask you a simple question. Is it possible to conclude a sincere settlement of a deal without a handshake? Sincere conciliation without a handshake, because it's a different thing from a settlement, mediation settlement. You can sign a settlement just to get rid of the problem, but can we really deal with true, genuine conciliation? We have a Polish movie. It is a history of two peasant families that have quarreled for centuries. They are separated by a fence that is the stage of all disputes. However, when something important happens, the neighbors reconcile, and the key word here is come up to the fence. And this is something I would like you to think about. Would the two neighbors reconcile if they called to each other, come up to Skype? I wish you a great reception of our today's conference, and I wish you a fruitful debate. Thank you so much.
Dziękuję.
Dzień dobry Państwu. It is a great honor and pleasure to meet you at another conference in Nowy Tomyśl. Naturally, I deplore the fact that we can only meet virtually. However, I would like to thank the organizers for remembering about me and for re-inviting me. My task is to answer the question related to the title of my presentation. Well, the answer to this question is far from easy, because the use of artificial intelligence in alternative dispute resolution in civil cases has a number of advantages and threats. Optimistically, we should start with the opportunities, because COVID-19 has shown to us that the application of artificial intelligence, as well as other simpler solutions that allow us to communicate over long distances, not only affects the costs of proceedings and gets rid of geographical distances, which generate the biggest amount of costs and problems, also in terms of time management of the proceedings, but also the fact that the proceeding is no longer tied to a specific location has an important impact on the pandemic situation and on the health of the participants. One other opportunity is the improvement of communication between the parties. One of the advantages of ADR in civil cases with the help of artificial intelligence is that it helps abolish linguistic barriers. AI can, in real time, make transcriptions of texts of even large size documents, and also have online and real-time translations of what's going on in the virtual room, mediation room, and this makes the parties, this gets rid of the problems of the parties communicating through interpreters, which costs money. However, is this communication really faultless? Well, I would like to talk about this with respect to risks. One other undeniable advantage of using AI is that AI learning during the following proceedings is capable of conducting a tremendous analysis of comparative material. We know the standing point of the doctrine on a given issue. AI, if we allow it to access databases and sources, AI will indicate to us different sources and resources. If anyone in a common court has applied or been in a similar case, AI will help us and guide us to these cases. This does not only refer to sources, to the documents that can be used for people resolving disputes, but it can also be helpful in the analysis of the factual state. Often, as an arbitrator, I have a problem that I receive thousands of pages of worth of documents and invoices, and the analysis of the factual state is one thing, and the other thing is my fight, my struggle with the invoices and the calculation of how much a party owes to another party, together with interest. AI can replace the human being by making a fast and error-free analysis of what the parties owe to one another in light of the documents fed to AI. And in this way, it helps the arbitrator or the mediator. Another issue which makes AI worthwhile is that it can perfectly well analyze subjective aspects of proceedings. Please remember that we often wonder whether the mediator is going to be objective, and also we wonder whether the arbitrator is going to be impartial. AI can unemotionally, impassionately, on the basis of data fed to it, which can comprise not only the past of the arbitrator as to the arbitral awards offered, but also analysis of the statements made online or available online. AI can do two things. On the one hand, eliminate an arbitrator who should not appear in a given case because, for instance, they are prejudiced, they are biased, or they have a fixed a fixed statement, a fixed angle on some categories of cases. On the other hand, they can analyze their professional experience and know-how, which can be seen in the arbitrator's statements available online. As a consequence, we deal with unprecedented optimization of the selection of persons who are to solve a given or resolve a given dispute with the participation of the parties. One other issue is assistance during the resolution of disputes. AI can work out alternative solutions which to its mind can help the parties, are satisfactory to the parties. They are in line with the law in place and with the principle of being right. And these alternative solutions can be shown by AI to the arbitrators or mediators, and they can in turn much faster react and show to the parties which direction can be taken. Furthermore, it is obvious that AI can also work out standard elements of dispute resolution, such as the calculations I mentioned before. The fundamental question is, how about the justice system? Ladies and gentlemen, the justice system has many faces, and if we looked at electronic proceedings, at the very beginning, some very simple studies were made concerning the amount of time spent on proceedings by judges, and statistically it turned out that a judge devotes only 2 minutes to a given proceeding of a simple nature. Well, is it a face of justice? Yes, but in writ of payment proceedings, where sometimes we have a one-sentence denial which invalidates the writ of payment. Here we cannot treat artificial intelligence as absolute infallible, and we should not treat we should not believe we should believe that there should be mechanisms in place that can remove such errors on the part of AI. So, speaking about advantages, we have objectivism, time, and money involved. How about the risks? AI can handle big data, but it cannot take 2 steps. It cannot perform skills which are capable, which a human being of 2 years is capable of doing. And this is something that can be a risk to all civil disputes where we need to analyze human motivation, where we need to analyze human emotions. For example, look at family disputes. Another problem is that AI itself cannot really restore the emotions, feelings, and human behavior, and it cannot read them, interpret them correctly, because basing AI on the current level of its development on the analysis of facial expressions is fallible, because apart from extreme emotions, which can be uniformly and unequivocally read, all the intermediate emotions are not as readable for AI. Let me only tell you that we can cry because of happiness, joy, and anger. Artificial intelligence is going to have problems identifying why we cry. Studies which were conducted not in ADR but in common courts with respect to American case law and as well as to the case law of the European Court of Human Rights have shown that the resolutions proposed by people and by AI, the ratio of correspondence is close to 80%. So, ladies and gentlemen, a question still remains whether people made a mistake or whether AI cannot really trace the nuances, some tiny issues in the factual state, which makes AI unable to have a 100% correspondence with human resolutions. This is the question we cannot answer yet. I said that one of the advantages of AI is that it can help make communication faster, because it can handle natural language in real time. However, AI may not be able to handle idiomatic expressions, metaphors, different puns and shortcuts which we have in our discourse. So, and also human beings are not only capable of saying words which are in truth, which are aligned with their intentions. AI cannot really relate to suprasegmental features of your utterance. It cannot relate to irony. One other fundamental risk which is involved in us, a psychological obstacle, a psychological barrier. Human beings do not want to trust a machine. We do not want to put our lives into the hands, so to speak, of the machine. AI developers try to get rid of this obstacle, and one of the things that is being done to increase human trust, is to make AI more human-like, also in terms of shape. So you can have, for example, a machine that looks like an attractive woman that takes part in the mediation proceedings. Is it really effective in the removal of barriers? Well, I don't think so, because we all want to know that everything depends on us. And I believe at the end of the day, and still at the back of our minds, is a thought that the machine is yet beyond our control. So once again, to sum up the risks, some imperfections of AI in the analysis of emotions, motivations, and also a question mark whether the machine can fully relate and account for what the party wanted to convey. And one other risk is us, ourselves, who are not yet able to trust the machine that is capable of self-learning, but still has a lot of deficiencies. So I don't have an unequivocal answer to the question whether AI is a chance, is an opportunity, or a threat. I believe the answer is within us, whether we are able to apply it correctly, whether we are able to turn to exclude those categories of civil cases where AI should not take place. For example, family issues I mentioned before, where the human mediator or arbitrator would be a better choice. This, however, does not change the fact that we will not halt the development of artificial intelligence. We need to live with it, and we also need to cope with it, or begin to cope with it. Thank you so much for your attention.
From San Francisco, California, I extend warm greetings to all of you in this year's version of the series Arbitration and Mediation in Theory and Practice. I understand that this year's program aims to take a close look at the situation of arbitration and ADR under the conditions of the ongoing pandemic. Therefore, the provocative title of this conference, as I understand it, is COVID-19, Does It Contribute to Dehumanization of Alternative Dispute Resolution? Yes, this is a provocative question. The reality is that we have become rather dependent on technology due to the pandemic, which has led to travel restrictions, quarantine requirements, restrictions on people gathering together, and health warnings throughout the world. For international arbitration and ADR, the practical impact of this is the limitation of parties and their lawyers from physically meeting in person and from traveling for international procedures. My work as arbitrator focuses on matters relating to China and Hong Kong and the U.S. where I've practiced for over 40 years. I currently reside in San Francisco. So the procedures that I handle are cross-border, or you might say cross-ocean. It is safe to say that the vast majority of procedures, including meetings, conferences, and hearings, that I have handled over the past year with parties from China and Hong Kong have been handled virtually with the aid of technical platforms that make virtual meetings possible. My hearings and meetings that are scheduled up to the fall of this year are all planned to take place virtually. It is helpful in these circumstances that the arbitral tribunal and counsel are mindful of the potential pitfalls and problems with virtual platforms. The parties normally will work out a virtual hearing protocol, taking care to address any special issues where procedures need to be clarified in advance. And also, we normally would engage a professional third-party technology provider who will normally carry out a test procedure in advance so that all participants can be familiar with the technology program, know how to properly use it, and to confirm that their equipment is compatible. We do everything we can to iron out the wrinkles in advance of the procedure. My general experience, and this is the good news, is that technology has functioned well, and the experiences have been fairly smooth where we handled meetings and hearings with virtual platforms. The problems where they occurred most often involved witnesses who did not have compatible equipment or who were not lucky enough to have a stable internet connection so that there were interruptions actually in the witness examination. That's a typical problem, I will say. There is concern about the negative impact of online communications as compared with meetings in person, and the question of whether parties and their counsel will somehow be impacted negatively in any way with the use of a virtual platform. My experience on this point is that as professionals become more accustomed to virtual meetings and hearings, they come to feel quite comfortable with this format. There are fewer distractions in the viewpoint of some people. They feel that they can be more focused with a virtual platform. That's what some people feel, as compared to the environment where people are meeting in person in a larger place. For witnesses who do not frequently participate in ADR procedures, it may be challenging for them to be made to feel more comfortable, to understand the procedures when they participate from a distance. That's an issue, something that participants need to prepare for in advance in order to address any problem that might create. I'd like to mention flexibility with the virtual platform, because I think that flexibility could have both positive and negative impacts when we go about holding meetings and hearings with a virtual platform. On the positive side, the ability of parties and their counsel to participate in international sessions has helped them, when they do it virtually, to save cost and to save time and to expand their availability by not having to travel physically. With cost and distance obstacles removed, this can enable and empower a larger scope of people to actively participate in sessions for the dispute resolution procedure. I would say that is a positive. On the other side, with the removal of geographic and spatial obstacles, we have the question of temporal issues and the possibility of conducting sessions 24/7, literally at all times on all days. Do we really want that? It has become easy to meet no matter where everybody is located, and so therefore we've been faced with the issue of time zones and the impact of time zones, how every participant can participate during a time zone that is convenient for them. What impact does it have on people who participate in the very early hours of the day, or those who are left to participate in the very late hours, or even those who consider participating during moments when normally they would not be awake? What is the impact of that? Is it dehumanizing? I think these are questions we need to think about. One of the negotiating points when parties agree on a virtual meeting protocol is how to accommodate the different time zones of each party. Another factor is the human limitation. How many total hours of computer viewing is physically tolerable before it becomes difficult? Is it dehumanizing to exceed that comfort zone? In my experience, time differences between parties in different locations does have an impact. It may lead to extending the hearing over a greater number of days in order to make up for the fact that there are fewer hours in each day which accommodate all of the participants. The other possibility is that some people may compromise their own convenience and participate during hours which really are not convenient for them, which could introduce potential disadvantages and may feel dehumanizing. Another point that I've thought about is our normal desire in ADR to encourage the parties to make efforts to get together and to find a way to resolve their own disputes peacefully. Where the parties are physically in the same place, such that everybody is in the same hearing room, focusing together on what's involved in their dispute, there may be better opportunity for them to decide to get together and really try to find a way to work out their dispute without having to go through all of the formal procedures that are available in the ADR protocol. I've seen parties meet and resolve their differences during lunch and coffee breaks, during hearings, where they all are in one place focusing on the dispute together. Does this use of a virtual platform without a physical place together diminish the possibility of parties being able to come together in that manner? If it is an obstacle to humanizing the dispute resolution process, it calls for creativity to bridge whatever is missing when we are together virtually. Without question, we are facing relatively new problems in a new environment with a wide use of virtual platforms that is taking place today. The level of creativity and resourcefulness that has gone into continuing dispute resolution procedures with the aid of virtual platforms, in spite of the obstacles resulting from COVID-19 and in spite of the uncertainties of a relatively new technology, is impressive. I wish all of you good health and much success as we continue to learn how to thrive and succeed in all circumstances. Thank you for this opportunity to participate.
Good morning. I'm Inna Yemelyanova, Vice President of the International Court of Arbitration at the Ukrainian Chamber of Commerce and Industry in Kiev. I would like to welcome all the participants of the conference, and I would like to thank the organizers and directly to Mr. President of the Court of Arbitration, Mr. Vladimir Bych, for inviting me to participate. Dear colleagues, the topic of our today's conference is very topical, you can say. The world has been faced with a threat that has continued since 2020, and we hadn't been prepared for that. All of this has affected our lives as well as international arbitration. Naturally, arbitration has had to adapt to the new reality. And how has international arbitration been able to adjust during the pandemic conditions, during the lockdown conditions, to the new reality? In order to answer this question, I suggest that we trace back our steps a few years ago, and I would like to recall the way of development and some of the innovation that was introduced into international arbitration. And this probably will help us answer the question why we were so quickly able to adjust to the new conditions. Over the past decades, the world has very quickly changed and has demanded from us changes and the creation of new and efficient measures. International trade gained momentum. Business and investors, all of this demanded a high level of efficiency, and entrepreneurs had to face these challenges. Business investors also demanded a quick and efficient resolution of disputes, of the maximum efficiency of management of these cases in dispute resolution. Investors also wanted to have a maximum guarantee of enforceability, a minimum risk of the settlements of arbitral awards being rescinded, and in answer to these demands of business, arbitration changed and introduced into its regulations ever new provisions. These are expedited procedures. This is also the possibility of resolving cases on the basis of documentation without hearing the witnesses and cross-examination. These are online procedure through video conferencing, and there are a number of other measures that need to be introduced to provide the confidentiality of the proceedings. So all of these measures have allowed arbitration to, you may say, smoothly move or smoothly brave all the challenges that it was faced with. This was, you may say, an acid test, an audit for arbitration to measure, to evaluate all of the processes, all of the business processes, to evaluate the organization of hearings, and to make conclusions about what and to draw conclusions about what we can do in the future to make arbitration efficient. Comparing with judicial proceedings, arbitration was, I would say, had an easier task. The procedures are more flexible. The parties can manage the procedure. They can discuss and agree upon something that is different from the rules and regulations, and this allowed us to quickly adjust to the new situation in comparison to common courts. Obviously, the common courts go by the book. They need to comply with the codes, with the appropriate laws. There are procedures which are very precise. Common courts have to adopt procedures to manage the processes, the judicial process. In arbitration, we had an easier situation. I would say that arbitration courts have been able to adjust to the new reality, also allowing for the exchange of documents online for online proceedings, and we also need to think, even if we spoke about certain bonus of arbitration through video conferencing. Now we can also say that because common courts have also introduced video conferencing and online judicial proceedings. So we need to seek ever new tools to show the edge of arbitration proceedings to our clients. I believe that the pandemic and some of the limitations, apart from the advantages, undeniable advantages I spoke about, have actually generated a number of other issues. I will mention some of them, and we need to find answers to them. What about the panel of arbitration judges, of arbitrators, if one of the party is against online hearings? What should the arbiters do if one of the parties does not offer its position on online or offline hearings? This makes the arbiters, the panel of arbiters, face the question whether they can make the decisions themselves, and how can they later, without taking into consideration the opinion of one party, how will a common court treat these proceedings if one party appeals and raises the following question? My statement, my position was not taken into account. I was unable to, we were unable to proceed offline. We were forced to proceed online. However, jurisprudence will definitely show its arbitration conducive position. I want to say that all the innovations existed also before, but our clients were pretty reluctant to use them. Our clients did not very willingly agree to online proceedings. In our arbitration, we also were faced with that. I spoke with some of my colleagues who also recalled that the parties preferred actually to proceed offline, to make their statements offline, and they believed that this would be a more efficient way of protection, even though they were faced with a choice, and this was not a very vast choice. They were limited to choosing either the postponement of proceedings, and actually we know that these postponements, given that we work from lockdown to lockdown, could be protracted, or they could also make advantage of video conferencing, and they could agree to online proceedings. The parties actually saw the edge of these video conferencing and of the video conferences and online proceedings. This is cost effective, you may say, and the representatives or councils are additionally able to assign international arbitrators. First of all, international arbitrators could, in their tight schedule, find some place for hearing the case. They didn't need to fly from one place to another. This also reduces the costs of arbitration proceedings. In the case of Ukrainian arbitration, very often where all the three arbitrators from the panel are representatives represent different countries, different states, and they organize the whole procedure in online procedure. The secretariats, the clerical staff can also very efficiently administer all that. Apart from that, we have other difficulties which are linked to, for example, the first hearing, when you need to identify when you need to ID the parties, when you need to answer all the questions posed by the parties. To what extent is the hearing of a witness efficient? Because we see the witness only on the screen of our computer. We do not know whether they are not helped in their testimony by a third party. So the same applies to cross-examination. All of these problems do exist, and we have already managed to overcome some of them. Some of them are still to be resolved. Many arbitration institutions have already put in place certain regulations on online arbitration proceedings. They are not obligatory. They are not mandatory. They are optional. Obviously, the panel, the arbitrators know which procedure to choose, having heard the parties. However, we need to be aware of that. As to the electronic exchange of documents, we are very actively involved in that, and the parties to arbitration proceedings use that as well. Arbitrators, well, as to the communication between arbitrators and the parties through this electronic exchange of documents, this is very efficient. The secretariats also manage the process very, very nicely. A few words about Our arbitration, the arbitration I represent, has it managed to overcome these problems painlessly, effortlessly. Again, I am very positive about it. Let me give you a few facts and figures. First of all, with a spike in the number of cases last year, we had around 30% more cases than in the preceding year. We had 341 cases to be resolved. In our court, we managed to be as quick during the procedure as previously. 90%. We managed to hear as many as 90% of the cases on time. Additionally, as I mentioned before, we were able to extend the geography of the proceedings. We increased significantly the number of foreign arbitrators, of international arbitrators. We only had very few appeals to the proceedings, and you may say that this is no more than 1% of the cases. We are actually proud of the statistics. And we were helped by the quick measures we put in place in the spring of last year. We put in place new measures of e-administration in the autumn of 2020. We introduced a certain number of changes to the rules and regulations. These changes relate, for example, to the shift to the electronic documentation. Second of all, we also have the right to manage the process and to define how to proceed with the proceedings, offline, online, or in a hybrid manner, as well as the composition of the arbitration panel. We hear the opinions of the parties, but ultimately, at the end of the day, we assign the arbitrators. Another issue is related to the new digital format of ADR. We are seeking new platforms. We are testing the features of those new platforms, and I believe that by the end of this year we are going to introduce new platforms for hearing and cross-examination. I guess we might be moving away from Zoom, Skype, or Teams. We would like to move to another platform, to a specially dedicated platform that will provide us with a number of opportunities. We will also be able to check the identity of the parties and their representatives. To sum up, I believe that arbitration in the vast majority of cases has managed to overcome the challenges it was faced with, and I do hope that in the future, given that we will all be subject to the inoculation programs, I believe that COVID-19 will soon become a part of our past, and that all of these measures we have introduced into arbitration will stay with us. And I believe that the parties will also be satisfied, because I believe they have already felt the edge, they have felt the advantages of online proceedings related to, say, cost effectiveness. For example, you cut the overheads, you cut the travel costs of the arbitrators. you cut the costs of travel of parties' representatives. And this is also business. When you spend less money, it's better for your company. And here, I believe in this very difficult time, when we go through this rough patch, we also, well, pinch our pennies, you can say, and we want to find ways to economize on a number of issues. And I believe we will continue in this way. I believe we are going to optimize our processes to be competitive, to satisfy all the needs in order to simply respond to all the challenges of the present day. And this acid test we have been subject to, that is administration, hearing, cross-examination, all the digitalization processes. I believe we have acquired a new perspective on our work, on our internal procedures, on our rules and regulations, and I believe this is also going to provide an impetus for us to work even better. And at the end, I would like to thank you all for kind attention, and I wish you all a nice conference. Thank you.
Крепкого здоровья и плодотворной дискуссии. До новых встреч. Спасибо.
Dear ladies and gentlemen, my name is Maria. I am the representative of the Belarusian office of Grata International Law Firm. We are grateful for the opportunity to be a participant in the annual arbitration forum. In particular, we would like to know the importance and timelines of the chosen topic. Beyond all doubt, the use of antiseptics and medical masks, as well as holding events in the online format, has become a part of our daily priority. We can find the influence of COVID-19 even in the sphere of alternative dispute resolution. Thus, we would like to speak with you about some general aspects of ADR in Belarus and the impact of COVID-19 on arbitration in Belarus. ADR in Belarus classically consists of arbitration and mediation. The main permanent arbitration institution is the International Arbitration Court at the BLCCI. For convenience, I will call it the ISC. It was established on the 11th of April 1994. For a long time, this arbitration institution remained the only permanent arbitration body in Belarus. We also have other arbitration institutions, for example, the International Arbitration Court, Chamber of Arbitrators at the Union of Lawyers. It was established in 2010. However, they have only a few cases under consideration. To consider disputes which may arise between the parties of the stock exchange deal made at the exchange trading of the Belarusian Universal Commodity Exchange, a separate permanent arbitration body has been created. That is the Arbitration Commission of GCC, Belarusian Universal Commodity Exchange. In addition to commercial, there are other types of arbitration in the Republic of Belarus. To resolve a collective labor dispute, a labor arbitration can be established. It can be done by concluding the agreement between the employers, association of employers, and employees represented by trade union. Labor arbitration is a temporary acting body. In other words, it is created to consider only a specific collective labor dispute. There is also a sports arbitration court at the Belarusian Republic Union of Lawyers, and in 2015, the arbitration court in the field of information technology and intellectual property was created. What's for statistics? For 2010, the International Arbitration Court at the BLCCI has accepted for hearing 86 claims, including 2 counterclaims, adjudged to 74 claims, including 2 counterclaims. Towards adjudged cases, the claims were filed earlier in 2019 and 2010. The plaintiffs were mainly residents of Belarus. Among foreign plaintiffs were residents of Latvia, Lithuania, Italy, Austria, and Germany. On the other hand, the respondents were mostly non-residents, among them mainly residents of the Russian Federation, further of the Latvia, Germany, and Italy. Statistics on new accepted claims are slightly different. Residents of Russian Federation have appeared among the foreign plaintiffs. Residents of Poland, the United States, and the Czech Republic appeared among the respondents. Now let's speak about the impact of the COVID-19 on arbitration proceedings in 2010, as in the case of the IAC at the BRCCI. In 2010, the IAC introduced the practice of remote arbitrating. How does it look like? The panel of arbitrators was located in different places. It means outside the IAC building. However, representatives of the parties were in the IAC building, but in different rooms. Sometimes the panel of arbitrators allowed the representatives to be outside the IAC building. For example, if there was a difficulty in the appearance of a representative in Minsk at the hearing. Additionally, the Zoom program was used. We should note that the IAC rules don't specify such remote arbitrating. On the one hand, it allows the panel of arbitrators to respond flexibly to specific situations and circumstances. On the other hand, if the representatives of the party didn't participate in the adjudication of cases by the IAC in 2010, they can't foreknow in what order the case can or will be considered. Let's consider some aspects of remote arbitrating in the IAC. Verification and authentication. Since the representatives of the parties are in the IAC building, the IAC employees have the opportunity to preliminarily check the identity documents, as a rule it is a passport, and documents confirming the authority, as a rule it is a power of attorney. Submission of documents and other written evidence. Same as before, the party should provide its written position, written evidence in original in written form, and in required amount. If there are 3 arbitrators, the 5 copies are required. 3 to the arbitrators, 1 to the opposite party, 1 to the archive of the court. For efficiency, it is allowed to provide scans of documents via email or show them on the screen during the meeting. But finally, the documents should be submitted to the court in the original or the form of a certified copy. However, according to the arbitrators, there is an issue with examining a controversial document. For example, stamps, signatures in the originals or of the contract or CMR invoices. In arbitration opinion, it would be correct to study the documents directly. When solving a case remotely, such problems can lead to delaying of a proceeding. However, in practice, the problems with examining the written evidence rarely arise in the IAC. Basically, delays of a proceeding appears due to improper execution of powers of the party, lack of information about the proper notification of the party, especially when the party deliberately avoids receiving notification, inadequate preparation of the representatives of the parties for the meeting, for example, lack of factual and legal reasoning, lack of necessary documents, and so on. Speeches of the party, communication with arbitrators. When considering the case remotely, the speech of the parties, communication with the arbitrators is quickly compatible with a normally working internet. Sometimes there are some technical issues when several people start talking at the same time and nobody can be heard. Therefore, there is a need for strict regulation of the order of speeches. What are the disadvantages of remote arbitrating? Firstly, it is ensuring the confidentiality of the consideration of the case. As usual, the panel of arbitrators doesn't allow audio or video recording of the proceeding. The case is not considered openly. Thus, the presence of unauthorized persons at the proceeding is allowed only with the consent of the both parties and the panel of arbitrators. For remote arbitrating, there is a risk that a representative of the party or arbitrator itself will record the process of arbitration, and the persons who are not representatives of the party will be present on the premises during the consideration of the case. Secondly, when making a decision on a case, of course, the written position of the parties, the evidence, and their assessment are of primary importance for the arbitrators. However, in practice, arbitrators also pay attention to the representatives, their behavior, their appearance. It forms a psychological portrait and may influence the arbitrator's inner conviction. As noted by arbitrators, it may be legally unimportant for the case, but important for the assessment of the good faith of the representatives of the parties. When considering case remotely, arbitrators have less opportunity to pay attention to these circumstances and feel the representatives. It isn't a disadvantage, but it is a reality. On the other hand, it means that the representatives have less opportunity to increase their power of conviction due to appearance, facial expressions, and behavior. This means that the consideration of the case itself becomes more based on the assessment of the parties, the written position, and submitted documents. The third disadvantage named by the arbitrators is difficulties in communications between arbitrators. Earlier, it was possible to solve some issues conclusively. For example, when considering the petitions of the parties, the arbitrators could share their opinion by nods of the head, hands, signs, notes, etc. Today, for this purpose, a technical solution is required. For example, an internal chat, arrangement of breaks for communication without the representatives of the parties. To conclude, in our opinion, on the whole, the introduction of the practice of remote arbitrating is positive. This essentially saves the time of the arbitrators and the representatives of the parties. However, the regulation of the procedure is required to be clear to professional and non-professional representatives of the parties. Thirdly, remote proceeding of cases may be inconvenient. It mainly connected with the issues of examining the written documents, the need for personal communication between the arbitrators, as well as communication between the arbitrators and the parties. So, thank you for your attention. Be healthy and have a nice day.
Szanowni Państwo, mam na imię Weronika Pawłowska i jestem radcą prawnym Kancelarii Prawnej Artsinger Law Offices w Mińsku Białoruskim. Bardzo mi miło dzisiaj brać udział w międzynarodowej konferencji z cyklu Arbitraż i Mediacja w teorii i praktyce. Tematem konferencji w tym roku jest odhumanizowanie alternatywnych metod rozwiązywania sporów z powodu COVID. I tak mi się wydaje, że to jest dobry moment, żeby podyskutować na temat sztucznej inteligencji w arbitrażu oraz o tym, kiedy roboty zabiorą nam pracę arbitrażową. Zaczniemy od tego, czym w ogóle jest sztuczna inteligencja. Sztuczna inteligencja w języku angielskim Artificial Intelligence or AI to jest technologia, która jest związana z konstruowaniem maszyn i programów komputerowych zdolnych do realizacji funkcji umysłu i ludzkich zmysłów. To jest zdolność maszyn do wskazywania ludzkich umiejętności, takich jak rozumowanie, uczenie się i kreatywność. Sztuczna inteligencja to nie tylko roboty i cyfrowa przyszłość. Ona jest teraz wykorzystywana w codziennym życiu. Przykładem wykorzystania są spersonalizowane rekomendacje podczas zakupów online oraz rekomendacje, gdy wybieramy film w serwisie Netflix. Wyszukiwanie w internecie, cyfrowi asystenci, samochody, nawigacja i bezpieczeństwa, opieka zdrowia i analiz dużych ilości danych to jest krótka lista dziedzin, w których jest wykorzystana sztuczna inteligencja. Jeśli Państwo się boją robotów, ale ma smartfon czy Alexę, to Państwo powinni przestać się bać, bo ma sztuczną inteligencję w domu. To samo dotyczy samochodów. Unia Europejska pracuje nad uregulowaniem sztucznej inteligencji. Istnieją dwa dokumenty w tej dziedzinie, które powinniśmy wziąć pod uwagę, mówiąc o sztucznej inteligencji. To wytyczne w zakresie etyki dotyczące godnej zaufania sztucznej inteligencji, wydane 8 kwietnia 2019 roku i Biała Księga w sprawie sztucznej inteligencji, wydana 19 lutego 2020 roku. Wytyczne ustanawia, że godna sztuczna inteligencja musi być po pierwsze zgodną z prawem, po drugie etyczną i po trzecie solidną. Też ustawione są 7 kluczowych wymogów do sztucznej inteligencji. To przewodnia i nadzorcza rola człowieka, techniczna solidność i bezpieczeństwo, ochrona prywatności i zarządzanie danymi, przejrzystość, różnorodność, niedyskryminacja i sprawiedliwość, dobrostan społeczny i środowiskowy i odpowiedzialność. Zwracam Państwa uwagę do ochrony prywatności i zarządzania danymi. To dotyczy jakości i integralności danych oraz dostępu do danych. To może być problem w arbitrażu międzynarodowym, w szczególności w komercyjnym, gdy dane nie są dostępne publicznie. To może negatywnie wpływać na jakość baz danych i decyzje programu komputerowego. Też przejrzystość jest ważną. To takie zwykłe dla nas w społeczności arbitrażowej pojęcie – przejrzystość. Możemy mieć wielki problem tu ze sztuczną inteligencją, dlatego że możliwości wytłumaczenia sztucznej inteligencji zostają ograniczone. Czekamy na to, że Unia Europejska w 2021 roku wyda regulację, jakiś akt prawny dotyczący sztucznej inteligencji, który być może ustanowi inne wymagania. Jednak należy pamiętać, że celem sztucznej inteligencji w ogóle nie jest zastępowanie ludzi. Ona pomaga ludziom umieć pracę żmudną albo zbyt skomplikowaną. W takim razie, jakie są zastosowania sztucznej inteligencji w arbitrażu? To zależy od baz danych i poziomu rozwoju technologii. Na przykład sztuczna inteligencja może być wykorzystana po pierwsze przy wyborze arbitra, po drugie w analizie stanu prawnego, kodowaniu predykcyjnym i przygotowaniu dokumentów procesowych oraz po trzecie jako arbiter. Po pierwsze, wybór arbitra jest niezwykle ważny w arbitrażu. Dlatego prawniki zawsze prowadzą szeroko zakrojone badania kandydatury arbitrów. Natomiast program komputerowy jest lepszy niż młodszy prawnik w dziedzinie analizy dużych ilości danych. W sytuacji, kiedy mamy takie bazy danych jak Arbitration Intelligence oraz Global Arbitration Review Arbitrate Research Tool, które dotyczą kluczowych cech procesu podejmowania decyzji przez danego arbitra, wybór arbitra dla konkretnego sporu przez sztuczną inteligencję będzie szybki i doskonały. Program komputerowy może doskonale zrobić analizę doświadczenia kandydatury arbitra w arbitrażu międzynarodowym oraz go znajomości prawa materialnego, zasady arbitrażowej, pola spornego i umiejętności zarządzania sprawami. Po drugie, kiedy mówimy o analizie stanu prawnego, kodowaniu predykcyjnym i przygotowaniu dokumentów procesowych, to dokładność sztucznej inteligencji w analizie danych nie budzi wątpliwości. Potwierdza to badanie Case Crunch, według którego sztuczna inteligencja jest o 24 punkty procentowe dokładniejsza od prawników w przewidywaniu wyników spraw. Też interesujące jest badanie LowGeeks, według którego dokładność sztucznej inteligencji w analizie NDA czy umów o zachowaniu poufności przewyższa dokładność prawnika o 9 punktów procentowych. Rola sztucznej inteligencji mogłaby sprowadzać się do badania przepisów prawnych, analizowania pism i dowodów złożonych przez strony, przygotowywania projektów dokumentów procesowych, na przykład pozwu i odpowiedzi na pozw. Po trzecie, najbardziej kontrowersyjnym tematem jest wykorzystanie sztucznej inteligencji jako arbitra w postępowaniu arbitrażowym w procesie podejmowania decyzji merytorycznych. Autonomia woli stron w kształtowaniu reguł postępowania arbitrażowego jest fundamentalną zasadą arbitrażu międzynarodowego. Regulaminy wielu instytucji arbitrażowych, jako ICC oraz LCA, nie wskazują, że arbitrem musi być człowiek. Prawne ograniczenia pojawiają się na poziomie prawa arbitrażowego krajowego. Na przykład artykuł 1180 Kodeksu Postępowania Cywilnego wskazuje, że arbitrem może być tylko osoba fizyczna. W prawie białoruskim jest identyczny przepis. Dlatego, żeby wyrok się zostawał ważnym, strony muszą wybrać inne miejsce postępowania niż Polska czy Białoruś. Też, gdy sztuczna inteligencja jest wykorzystana w procesie podejmowania decyzji merytorycznych, powstaje pytanie zasadą osobistego wykonywania funkcji arbitra oraz nieuprawnionym delegowaniem funkcji arbitrów do sztucznej inteligencji. Tu znów powstaje inne pytanie przejrzystości i technicznej możliwości wytłumaczenia wyroku wydanego przez sztuczną inteligencję. Być może taki program jak Arbilex będzie w przyszłości w stanie zapełniania takiego wytłumaczenia. To wszystko w ogóle znaczy, że technologie, w szczególności sztuczna inteligencja, dają prawnikom do myślenia. Postęp technologiczny w arbitrażu jest nieunikniony. Dlatego zobaczymy, co będzie dalej. Dziękuję bardzo za uwagę.
Dear Mr. Blake, my friends in Poland and online, how are you? I'm honored to be invited to attend this year's conference in this special way. And it's a pleasure to meet you online. As we all know, the COVID-19 pandemic has severely affected arbitration proceedings from the past year. Tribunals, parties and councils are facing greater challenges to mitigate the adverse effects of the pandemic, such as delay of arbitral proceedings and obstacles to initiate new arbitration cases. Those negative consequences make it more critical than ever that we give due consideration to long-term case management techniques to make arbitration fair and efficient. Today, I would like to share China international economic and trade arbitration's practice in response to the difficulties, which has gained good effects in CTAC cases. I hope it can inspire more ideas and discussions to promote arbitration at this special time. On 28 April 2020, CTAC issued guidelines on proceedings with arbitration actively and properly during the COVID-19 pandemic in order to provide detailed guidelines to participants to conduct arbitration effectively during the pandemic. Generally speaking, the guidelines lay emphasis on tribunals' extensive procedural discretion granted by CTAC arbitration rules, as well as good faith of the parties. It covers most of the procedural issues that may be affected by the pandemic, from case filing to arbitration award. The key highlight is that the guidelines highly recommend online arbitration services. It encourages parties to conduct arbitration remotely by using CTAC online case filing system and agreeing on electronic submission. It also encourages the tribunals to decide on virtual hearing on a case-by-case basis. I would like to introduce you the online case filing system first. Since 1st January 2019, CTAC online case filing system has been put into use to improve the efficiency of the case filing procedures. It responds quickly to parties' arbitration applications. Through the online case filing system, parties are able to communicate with case managers online and can check the filing process at any time they want. This system is well accepted by parties and played an important role after the outbreak of the pandemic. As statistics shows, last year, CTAC accepted 819 cases through the online case filing system, with an increase of 628 cases compared with 2019. This year, from January to February, CTAC has already accepted 102 cases online, accounting for a year-on-year increase of 213%. As for virtual hearing, CTAC developed its intelligent hearing platform last year, allowing the tribunal to hear the case online. The platform is an exclusive system that's specifically tailored for arbitration procedures, which is unique with plenty of twists. Firstly, it is not a public system and cannot be accessed without the keywords provided by CTAC. Besides, the platform directly connects with the database of the relevant authorities, so that before each domestic online oral hearing, the identification of the participants will be verified and confirmed. The security and confidentiality of the arbitration proceedings can be guaranteed for sure. It is also equipped with the technology to convert spoken word to text, so that the transcript of the oral hearing can be produced simultaneously. More importantly, the platform can realize the effect of the physical hearing to a great extent. It supports the function of uploading, downloading, and simultaneous electronic display of evidence at any time by any party. Checking and sending the hearing transcript can also be realized through the platform, which is the first of its kind in Chinese arbitration institutions. Under the operation of the tribunal or the case manager, other participants in the same hearing room can be isolated from the hearing, so that back-to-back mediation can be realized easily as well. CTAC has already had disputes that were settled by mediation conducted through its smart online hearing platform. What's more, the English version of the platform has already been put into use. It can make foreign parties participate in CTAC arbitration procedures remotely. Ever since the application of the online hearing platform, more than 400 virtual hearings have been conducted, which greatly alleviated the delay of the procedures caused by the pandemic. With CTAC's online dispute resolution system, parties may save a lot of costs in terms of economic costs. Parties do not need to expend money on travel to file cases, attend physical oral hearings, print and send paper documents, as well as the arbitrator's fees on travel and accommodation. In terms of time costs, virtual hearings are much more convenient than arranging physical hearings, especially for cases with busy arbitrators or foreign participants. Since the cost for arbitration is reduced, it could be a direction for arbitration institutions to reform its fee schedule. Such reform can allow parties to solve their disputes faster with less expenses. And I believe that it can also promote the popularization of arbitration. It is also worth noting that CTAC takes advantage of its strong network of multiple subcommissions at home and abroad, making the oral hearings held in more flexible manners. With the combination of online and offline, participants such as parties, counsels, witnesses, arbitrators, case managers in different locations can join the hearing simultaneously in different CTAC subcommissions. Since the entire procedure can be assisted by CTAC case managers, they can assist to check the identity of the participants and witness the testimony of witnesses, protecting the confidentiality of commercial arbitration to the maximum extent. It is also one of the advantages that other Chinese arbitration institutions are not able to provide. However, new techniques and challenges go together. For instance, the defects of virtual hearing still remain to be improved. We cannot verify the identity of foreign participants through the hearing platform. In cases where witness is involved, we cannot make sure that he testifies in a proper environment and is not affected by other elements. Besides, virtual hearing is over-reliant on the stability of network. Where parties' network is not stable enough, the virtual hearing can hardly proceed smoothly. Another issue worth discussing is that virtual hearing is not clearly available in arbitration rules or applicable law as that in exit arbitration rules. In fact, in most of cases, the applied arbitration rules and applicable laws are silent on this issue, and the decision on virtual hearing is made under the broad discretion of the arbitral tribunal. So my question is, does the tribunal have the power to decide that the oral hearing be conducted online, even if one party expressly objects? In other words, does the virtual hearing need to be carried out on the consensus of both parties? We all know in international arbitration, if the consensus of the parties is the precondition of virtual hearing, many cases may not go to the oral hearing stage for a long time during the pandemic. Obviously, the virtual hearing is playing and will continue to play a significant role in the field of dispute resolution. I believe that an important work to do next is to reform the legislations and make clear the availability of virtual hearing in arbitration. The solutions to those problems still need our discussion and exploration. But right now, the online arbitration services, to a great extent, can satisfy the needs of the parties to participate in arbitration remotely in this special time. In CETA cases, even physical hearing is now restored. Some parties and tribunals still prefer to conduct hearing through the smart online platform. I see it as a need and tendency to normalize the online hearings. Generally speaking, online dispute resolution is the future mode of arbitration. CTAC will continue to pay relentless efforts in exploring online disputes resolution service and making good preparation to provide high-quality online service in the new era of digital economy. Thank you.
Good afternoon, ladies and gentlemen. Thank you, Mr. Virginius Birch, President of the Court of Arbitration of the Novi Tomislav Chamber of Commerce, for inviting me to give this paper. My assigned topic is vast increased use of technology and artificial intelligence in international arbitration pose a threat to arbitration practitioners. Most arbitrations which use software do not use software which fully utilize the true capabilities of artificial intelligence. Indeed, the traditional software that is being applied right now in arbitration is mainly focused on efficiency and streamlining the arbitration process itself. For example, Novus Arbicum provides a full solution for arbitration case management. Opus 2 provides case management and a hearing presentation platform. Machine learning for disclosure has been taking place for quite a while now in international arbitration. The software recommend assists in e-disclosure and data analysis. Nuix extracts knowledge from unstructured data. This is still not true artificial intelligence. There are new software that have been released over the last year or two in the market, which take it up one notch. You have algorithms that are now able to challenge the domain of what was traditionally human expert witnesses in the fields of quantum delay analysis and valuation. You have software such as text foresight that is able to assist the decision-making process of lawyers who are selecting strategies on how to deal with both immigration and tax cases. Such software is able to analyze thousands of previous judgments to allow the lawyers to understand how certain judges might rule on a set of facts about a taxpayer's affairs. It has an accuracy rate of 90%, and as such, it does help in strategies for the lawyer as to how to present the case. The software named Litigate, it's a learning algorithm, is able to review arguments put forward by opposing parties, is able to suggest counter arguments and recommend procedural steps that might be taken in high court actions. Artificial intelligence has long been used in cross-border investigations. It's been used to review, they can review information from different sources ranging from mobile phone apps to emails and down to scanned documents. The software is able to spot keywords and sequences in data. It can analyze information and it can assemble a set of conclusions for the reader. So there is no doubt that there has been a shift towards more intelligent, more independent and autonomous algorithms which are being developed. The software called LawGeeks is a contract review software which can go through many documents, and it is able to even approve a contract on the spot for signing. So this software, LawGeeks, trained on tens of thousands of non-disclosure agreements, and it uses machine learning technologies. Now, how fast was it? 20 experienced lawyers were pitted against LawGeeks algorithm, and the challenge was focused on reviewing non-disclosure agreements. It took the 20 lawyers an average of 92 minutes to review 5 non-disclosure agreements. It took the algorithm 26 seconds to review the same 5 non-disclosure agreements. So it's fast, but how accurate was it? one might ask. Well, the accuracy level for the human lawyers was 85%, and the accuracy level for the algorithm was 94%. So one can see that such software can displace lawyers who are doing more repetitive type of work, basically. Now, the question that has been posed time and again is, what about the possibility of robots or machines taking over from humans as arbitrators? Because artificial intelligence can replicate the key attributes of any particular arbitrator. And the pros that are being made for the use of machine arbitrators or algorithms are, algorithms tend to be, well, they are independent, they are impartial. Algorithms are not biased in a human way. They do not have sympathy bias for a case or for a party. They remove the possibility of clerical errors. They remove the possibility of error on facts and law. But it is also said there are disadvantages in the use of artificial intelligence as robot arbitrators. So one of the discussions is, what about the possibility of cultural bias, legal cultural bias, depending on the programmer of the algorithm? Would it be more geared towards a civil law jurisdiction or more geared towards a common law jurisdiction, for example? And then there's the issue of language bias, because in many of these algorithms, they work with language recognition only in the English language. And much has been asked about whether such programs are rigid, or can they play the role of a flexible interpreter of law. A disadvantage for lawyers who are appearing before algorithm arbitrators, if that happens, would be you would not be able to look at the track record of the algorithm. And then what about the issue of a danger bias, issue-based bias by the algorithm? And the algorithm may not have learned new concepts, and it's stuck in applying old concepts and outdated learning. So these are the concerns that are raised from time to time. And are artificial intelligence algorithms able to apply civil law jurisprudence, such as can it apply principles of ex eque et bono principles? It would seem that there's more of an inclination towards the common law principles of case precedent rather than civil law jurisprudence. One of the cornerstones of international arbitration is confidentiality. But because machines, algorithms have to learn by looking at tens of thousands of awards in order for it to be able to mimic and learn from the human, would this not be a breach of confidentiality to have the arbitral awards kept in the memory system of the algorithm? And does artificial intelligence actually have reasoning, independent reasoning abilities, or is it just a mimic? It goes through the motion. And who inputs the data into such algorithms? What about the person who inputs the data? Is that person impartial? How does one deal with the impartial standard of the programmer of the algorithm? These are issues which have to be looked at very carefully, obviously. And when things go wrong, if there's a malfunction of the artificial intelligence algorithm, who then takes responsibility? Who would bear negligence? Would it be the developer who developed the system? If so, would the jurisdiction that would have proper jurisdiction, the country of proper jurisdiction, would that be the country where the software was developed, or would it be the country where the end user had used the software? So such questions will also have to be looked at. And what about the issue of the fact that our true artificial intelligence is able to self-learn? It learns from past experiences, past awards, and then it tries to self-learn. In such an instance, can the developer of the original algorithm be responsible if the artificial intelligence algorithm actually learns more than what it was originally programmed to be? So who sets these minimum quality standards for the artificial intelligence, and who controls and decides such quality standards? One of the biggest fears is that artificial intelligence algorithms will take away the work of junior lawyers who have to spend their early years doing research and cutting their teeth on more mundane work. Would younger lawyers then hesitate to take a different view if the algorithm, which is deemed to be extremely accurate, has come up with a certain view? And how about regulation? What if regulators insist on looking at databases for them to deal with regulatory issues? Again, wouldn't this affect the sacrosanct principle of confidentiality in arbitration? Because the regulators would then get their hands on thousands of awards which are not meant to be shared. And what happens if different regulators from different countries want to take jurisdiction over the artificial intelligence algorithm? So one can clearly see there are challenges that need to be overcome. But what is for sure is the ability to use artificial intelligence wisely has more pros than cons. Artificial intelligence can minimize research time and present new strategies which the human lawyers may not have thought of, or it may be different strategies to allow the human lawyers to develop their thoughts and build up new case theories. Artificial intelligence does not require sleep. It can function without any breaks. Artificial intelligence greatly cuts down the costs and overheads of law firms, resulting in savings to end users, clients of the law firms benefit as well. So there is a school of thought where human arbitrators and human practitioners in arbitration refuse to believe that artificial intelligence can take their place. So the view that is often proffered is that human lawyers prefer interacting with human arbitrators, and humans understand each other better, and advocacy skills also matter. Well, the time has not yet arrived where one can say that artificial intelligence will definitely present an existential threat to arbitration practitioners. No one can really predict the future in this respect. The development of artificial intelligence in international arbitration is continuing at a very fast pace, and all of us have been working on platforms during the last year and a half. The COVID-19 has changed many things. So there's more reliance on technological platforms and also artificial intelligence. So one has to think about this very clearly. It is therefore wise for us to master the use of artificial intelligence rather than ignore the development of artificial intelligence. It is indeed a useful tool for us to deploy in our daily practice in international arbitration. With that, I end my talk. Thank you very much.
Good day to all of you in Poland. My understanding of the theme of this conference is the question whether virtual hearings dehumanize the arbitral process. After more than a year of virtual hearings in different parts of the world, I think that most arbitration practitioners will agree that so long as technology does not fail the participants, especially for lack of bandwidth, virtual hearings are as good as, if not more effective than, physical hearings, except, arguably, for cross-examination. In the limited time available to me, I will make two broad points and recount one anecdote in support of my view. My first point is that we need to remember that video conferencing has been made available as a means of taking witness evidence for quite a long time before the era of COVID-19. It has been used in many national courts without any widely publicized cases of actual injustice caused by lack of face-to-face cross-examination. Quite apart from the technical difficulties in the reception of video conference testimony from different countries, there have been concerns about security and the integrity of the cross-examination process. However, long before COVID, major courts like England and Wales, Australia, Singapore, and the Dubai International Financial Center courts in Dubai have had in place established video conferencing procedures. It provided for practical measures to preserve the integrity of the cross-examination process. To take the courts of England and Wales as an example, even before COVID-19, there was already a protocol in place in the English Civil Procedure Rules, consisting of 21 practical rules about the way in which video conference evidence was to be taken. Security arrangements could be arranged so as to provide an independent party in the remote hearing room to ensure that no other persons would be in the same room to assist the witness with his presentation of evidence. In those days, a remote cross-examination process might occasionally raise questions whether the poor quality of video transmission would make it difficult for counsel and the tribunal at the main hearing to see and hear the witness clearly. However, conventional video conferencing has rapidly improved, both in quality of picture and sound, during the last 10 years when I was sitting as a judge in Dubai, and on quite a few occasions I heard witnesses give evidence by video conferencing. We were also able to use video conferencing for mediation, which is a large part of the DIFC's court work, since we had huge numbers of employment disputes where the relatively small amounts in question meant that they were classified as small claims, and this required the disputing parties to go through mandatory mediation before a judge before the case could actually be heard as a contested trial. In practice, the rate of success for our mediations was extremely high, at about an average rate of 90%. Sometimes, when one of the parties was not in Dubai, we had mediation by video conference over Skype for Business, where the quality of the picture was high and the sound reception was good enough for an exercise which often resulted in displays of human emotion, which is an important factor in the ultimate success of most mediations. My second point is that in commercial cases, cross-examination is much less important than in general litigation, where factual issues are critical to the decision and are hotly contested by conflicting oral testimonies, typically in criminal or tort or delictual cases such as traffic accidents or defamation, and civil cases where serious allegations of fraud or oral misrepresentations are the foundation of the disputes. However, the basic commercial agreements and documents showing how the dispute has arisen will be the primary source of a tribunal's understanding of where the respective legal obligations of the parties are to be found, and why the dispute arose and developed, as well as what damage was suffered as a result of the alleged wrong committed. In my own personal experience over the last 2 decades, I can remember relatively few commercial cases where cases were won or lost because of facts revealed in cross-examination. I have given lectures on this aspect of advocacy and arbitration, where I emphasize that the role of a good arbitration advocate is to guide the tribunal through the documents and develop his or her case, placing greater emphasis on the documents than the witness statements and cross-examination. If you're interested in my detailed views, you can read my essay on the topic, which I can send to anyone who emails me to ask for it. Or you can go to YouTube and look for the lecture I gave in Seoul, Korea in 2017. The lecture is called The Opening Statement, Is It More Important Than Cross-Examination? However, let me address the question of the effectiveness of video conferencing for cross-examination. With the advent of computer-assisted video conferencing, the technical quality of both sound and picture transmission has taken on a new dimension. Where there are local bandwidth shortages, the quality of sound and picture can be erratic. But in the vast majority of cases, technical support for video conference hearing has made the reception of video conference evidence much clearer and not far short of the atmosphere of a live courtroom or a hearing room. There will also be some lawyers who will complain that there is something lacking in the ability to cross-examine the witness in person, with the claim that they cannot get close enough to the witness to see the whites of his eyes. The reality is that with the computer-assisted video camera, everyone can see the face of a witness at a much closer range than in a courtroom or a hearing room, where counsel and witnesses are several meters apart. Let me tell you one story to illustrate this. Many years ago, using conventional video conferencing, I appeared as counsel in a case in Singapore, and my expert witness was located in the USA. The time difference was 13 hours, and our hearing started at the usual Singapore court time of 10 a.m. By the time the witness came on for the hearing, it was about 10 p.m. in the USA, and he had probably done a full day's work before coming to give evidence. My opponent was a fierce cross-examiner who had, prior to the hearing, objected to my expert giving evidence by video conferencing, arguing that he would not be able to, and I quote him, see the whites of the expert's eyes. Now, when my expert witness appeared on the video screen, counsel put difficult questions one after the other to my expert, and I could see the sweat coming out of my witness's face as I watched the video screen. What was clear to everyone was that the expert witness was taking large gulps of water from the glass which was placed directly in front of him. So everyone could see from the video picture that he was in difficulties. And my opponent, who had strongly opposed the use of video conferencing because, quote, he could not see the white of my expert's eyes, unquote, managed to demolish my witness completely, and I lost that case. So, with proper equipment and care taken over bandwidth, I would respectfully suggest that little is lost in terms of forensic effect by virtual hearings. And my conclusion is that cross-examining witnesses using modern computer-assisted technology is usually not less satisfactory than in a conventional courtroom or hearing room. Thank you for your attention.
Dear colleagues, the topic of my speech will be procedural force majeure and hardship notions in ADR on the example of the COVID-19 pandemic. I would like to start my speech with a quotation from an old English legal treatise leges Henrici I, laws of the King Henry I, which dates back to 12th century Anno Domini. The human race is dependent on a malign influence of the severe fate. Consequently, everyone should be merciful. I think that this is relevant to the topic of force majeure and hardship as an excuse from liability in certain exceptional cases. Another quotation for the beginning: procedural violations only occur when you win the case. This is one of the Murphy's laws for lawyers. So, because the topic of my speech today will be about procedure. Last year's conference, I dedicated the speech to substantive force majeure, also related to the pandemic, but today about procedure. Because not only performance of the commercial contract, but also the implementation of the chosen method of resolving a dispute may become impossible or excessively burdensome due to some unexpected circumstances, such as also the effect of restrictive measures during the pandemic. And this puts in question the civil legal concepts such as force majeure and hardship. Usually, they apply to substantive legal relations, such as failure to render services or to deliver goods due to some superior force which hinders these actions. However, arguably, these concepts should be applied also to procedural legal relations. Unlike in substantive law, the main purpose of the application of these concepts does not consist in avoiding liability for failure to perform somebody's duties, such as duties of one of the parties to the, say, arbitration agreement or duties of the arbitral tribunal. The main purpose of force majeure in procedural context is to authorize the dispute resolution provider to adapt the procedural form or time frame to the unforeseen and unforeseeable circumstances. First of all, arbitration rules indeed often contain provisions which imply force majeure event. They are not expressly in the arbitration rules, but they can be deduced from it, as I will show now. Indeed, there are situations in which a party becomes incapable to meet procedural timeframes for a cause of superior force. For example, a party fails to appear at the hearing or to obtain access to some crucial evidence due to travel or other restrictions. Current regulations on arbitration and other ADR do not contain legal notions of force majeure or hardship in procedural context, but both institutional arbitration rules and ad hoc arbitration rules do contain such concepts as sufficient cause or good cause for not doing something. For example, if the claimant presents a statement of claim with a delay, but shows a sufficient cause or good cause for such delay, then it follows from the many arbitration rules that normally this shall not result in terminating the proceedings by the arbitral tribunal. This directly follows from Article 31A of the ancestral arbitration rules, from Article 35 of the Stockholm Chamber of Commerce arbitration rules, and others. Of course, it is up to the tribunal to decide whether the cause is sufficient or insufficient, good or bad. Another example: if a party fails to appear at the hearing but shows a sufficient cause for such failure, then the hearing should normally be postponed by the arbitral tribunal. This is what follows from Article 30, paragraph 2 of the ancestral arbitration rules. And one more example, if a party is duly invited by the arbitral tribunal to produce some documents or other evidence, but fails to do so within the established period of time. However, this party shows a sufficient cause for such delay or failure, then the arbitral tribunal normally should not make the word on the evidence which are already before it, but instead should provide to this party some additional time. This follows, for example, from Article 30, paragraph 3 of the ancestral arbitration rules. And what is, in fact, a sufficient cause or a good cause for failure to do something? First of all, it's exactly some force majeure event, some extraordinary obstacle for the party to do what is expected from it to. Arbitration institutions and state courts, by the way, already expressly or sometimes impliedly rely on the concept of procedural force majeure. For example, Russian highest courts invoke procedural force majeure as an implied legal concept as early as in 2010, though not in relation to ADR. In particular, they explained that no compensation for violation of the right to timely legal proceedings or timely enforcement of the judgment shall be awarded if the excessive prolongation of the judicial proceedings or the enforcement of the judgment was caused solely by circumstances extraordinary or unavoidable under the given conditions, force majeure. So this was mentioned more than 10 years ago. And apart from that, currently the Russian Supreme Court explained in its case law reviews in April 2020 how the pandemic influences on running, restoring, and staying procedural time limits and limitation periods. This is, of course, an issue which has become acute in many jurisdictions. It should be noted that some arbitral institutions, such as the MCAS, International Commercial Arbitration Court, and the Russian Chamber of Commerce and Industry, prolonged the time limits for conducting arbitral proceedings due to the situation with the pandemic and the measures adopted to overcome it, from the end of March 2020 till the end of such situation and its consequences. So, in fact, the Presidium of the MCAS relied on this force majeure event, even if not expressly call it in such way. Third point which I want to make today is that avoidance or mitigating disruption of ADR proceedings may be established by using or implemented by using the concepts of force majeure and hardship. Arbitral or mediation proceedings may be disrupted due to insurmountable obstacles caused by force majeure events, as it happened with the COVID pandemic, which upsets the planned course of arbitral and other proceedings. Okay, if the parties remain cooperative after such event, the problem is relatively easy to resolve because they may agree upon a hearing by video conferencing, or they may agree upon modification of the proceedings in some other way. However, a real problem arises when one of the parties fails to cooperate and remains passive or insists on further prolongations of the proceedings, which in fact may cause that proceedings will be prolonged for many months, maybe years. As regards mediation, unfortunately, lack of cooperation from one of the parties is crucially detrimental for the proceedings because of the very nature of this dispute resolution method. It strongly relies on the parties' cooperation. However, fortunately, arbitration does not depend on the parties' cooperation to such an extent. Although arbitration regulations are silent about the authorities of the arbitral tribunal to modify the procedure on the ground of procedural force majeure or hardship, such authorities of the arbitrators are arguably impliedly present. They constitute constitute part of the so-called residual authorities of the arbitral tribunal. For instance, I should quote Article 19 of the Ancestral Model Law on International Commercial Arbitration, Determination of Rules of Procedure. Subject to the provisions of this law, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. But failure to such agreement, the arbitral tribunal may, subject to the provisions of this law, conduct arbitration in such manner as it considers appropriate. So, by entering into an arbitration agreement, the parties authorize the arbitral tribunal to take appropriate measures in the event of impediment to the planned course of proceedings, in particular to choose the form of the hearings and conferences within the case. For example, to conduct them by video instead of personal meetings, or even if this becomes impossible, then to conduct proceedings solely on documents. This certainly increases the importance of specialized online platforms, ensuring the communication of the parties to the arbitration proceedings and the confidentiality of the procedure. Well, de lege ferenda, arbitration and mediation rules ideally should expressly authorize the dispute resolution provider, arbitral tribunal, or mediator, as the case may be, to adapt the procedure to changed circumstances. According to an established principle of law, arbitration and mediation rules form part of the dispute resolution agreement concluded between the parties. Therefore, such provisions in the rule would become part of the parties' agreement, and this would reduce the risk of subsequent unenforceability of the arbitral award due to alleged procedural violation, due to change of the way how the proceedings will be conducted. The purpose of such steps, of course, consists in preserving legal certainty of procedural relations. Consequences, the last point I would like to make, consequences of procedural force majeure and hardship events. Force majeure and hardship events are similar in substantive and procedural relations in the way that they are extraordinary, unexpected, and irresistible. However, the differences between procedural and substantive force majeure and hardship concepts consists in the legal consequences of their application. The specific features of the arbitral proceedings do not allow them to be terminated despite the presence of force majeure circumstances. For arbitration based on an arbitration agreement, this follows from the principle of inadmissibility of unilateral withdrawal from the arbitration agreement, and secondly, from the fact that force majeure events affecting the arbitration may eventually pass, and so the arbitration agreement will become again feasible. Therefore, legal consequences of the application of procedural force majeure should generally not consist in the termination or suspension of obligations from the arbitration agreement and the applicable arbitration rules. These consequences should take place almost in ensuring the availability of the method for resolving a dispute by adapting the procedure to the changed circumstances. Legal concepts of force majeure and hardship should not normally excuse a party from fulfilling its agreement to arbitrate or mediate, or for the dispute resolution provider to refrain from administering ADR. Instead, it should constitute a ground to adapt the procedure to changed circumstances.
Good morning, dear colleagues. I'm a professor at Vilnius University and president of the biggest arbitration court in Lithuania, which is known as the Vilnius Commercial Court of Arbitration. And I was asked to speak today and to present to you the situation of arbitration in Lithuania. I would like to thank the organizers for inviting me to this conference, and I will do my job with pleasure. Firstly, I would like to say that the history of arbitration in Lithuania is a long history, is a long one, and actually I would like to prove by the book I have in my hands. This is the first handbook of Lithuanian civil proceedings. I can show it to you. This is written in Polish, 1826. This book is based on the third statute, and on page 78 we can find the following wording. Extraordinary courts include friendly courts or amicable courts whose principle is to solve any disputes between parties. So actually this can be the first mention of arbitration in Lithuania. So this is still the 16th century. We are still talking about the 16th century, which actually makes us proud of our arbitration record. I would like to say that during the partitions of the Commonwealth of Poland and Lithuania, Lithuania became part of Tsarist Russia. Until 1830, we had arbitration on the books. We had the third Lithuanian statute, and as of 1864, when Russia adopted a new law on civil procedure based on the French Code of Civil Procedure, arbitration as such was in place, and we had no problems with that. At the beginning of the 20th century, a similar situation, the relevant law was in place until 1920. After the Russian occupation in Lithuania for 50 years, the practice of arbitration was arbitration was only theoretical. There was no practice because actually there was no commerce, there was no free commerce, no free trade, because everything was state-owned. After 1990, when Lithuania regained its independence, we began to actively talk about arbitration, and in 1995 Lithuania ratified the New York Convention. In 1996 we adopted the first law on commercial arbitration, which is only one law, not unlike in many post-Soviet countries where we have two laws for national or for domestic and international disputes. We have only one law related to arbitration, and in 2012 it was amended. It was patterned on the model UNCITRAL law, and in 2020, as of 2012, Lithuania is very friendly towards arbitration. The very law stipulates that the source of arbitration law in Lithuania is the model UNCITRAL rules, and if we need our national domestic laws, we can apply the interpretation of the model law. Also, we have the fullest competence, and what makes us really pro-arbitration is the trust that we lavish the trust that is lavished on us in courts of general jurisdiction. The Supreme Court has frequently spoken very highly about arbitration as such. First of all, we have Themo Contractus principle. If there is an arbitration clause or arbitration agreement, all disputes can be proceeded through arbitration. Obviously, if we have an arbitration clause or an arbitration agreement, a settlement, this has to be executed and enforced, and the resolutions of the parties have to be respected. According to Themo Contractus principle, the first to decide on competences is arbitration, and only if arbitration if arbitrator says that they have no competence, then only then does a court of general jurisdiction acquire competence. There are only unique situations where it can be otherwise. This is all included in the New York Convention. Importantly, our Supreme Court has often stressed that the substantive control of arbitral awards is prohibited, and this is very good. We cannot monitor, we cannot audit the arbitration awards, even if they are very unjust, even if they are blatantly unjust, because we need to respect the will of the parties. To abstain from courts of general jurisdiction. And there is also one other ruling which was very important for arbitration in Lithuania. It was a ruling of our Supreme Court again, which was discussed in many countries. It was a dispute in Stugolno between Lithuania and Gazprom. When this arbitration in Stogol said that Lithuania has to collect all its claims in the courts of general jurisdiction in Lithuania against Gazprom, which are derived from the contract. And this ruling of the Supreme, went to the Supreme Court of Lithuania, and the Supreme Court said that, well, Lithuania is not incapacitated. If they signed this contract, then they have to comply with its provisions. I believe that Russia would never allow this to happen. This shows that we respect in Lithuania the autonomy of the parties. This actually produces very good results, because business is also more trustful towards arbitration. They believe that arbitration really defends you against the intervention of the state. So I can really be satisfied with arbitration, and as of today, the Republic of Lithuania is very pro-arbitration. Now, speaking about COVID, the pandemic, our big advantage is that we are completely independent of the state. Our procedure is not to be subject to parliamentary law, that we don't need any permits. The Lithuanian law determines the course of the arbitration procedure only very tentatively, and we are given a lot of leeway, a lot of discretion as to the procedures. Our rules and regulations allow us to proceed online without any problem. We've had this Arbis program for the past 4 years. We've been able to handle arbitration proceedings online. There is no problem with the use of Teams, Zoom, or other platforms to have a hearing. So as of today, we have no problem whatsoever with arbitration proceedings. All of them take place online, and I can say that I really see no issue with that. The arbitration system in Lithuania has fully adjusted to the new reality, to the new normal. Do we face any problems here? I personally see no major problems because our rules and regulations stipulate that if the parties file a claim through the Arbis system electronically, they pay 10% less of the costs. So this is 10% less than in-person arbitration. And this works. So finally, I can only reiterate that I'm really pleased with the development of arbitration in Lithuania. There might be some minor problems, but they do not in any way obstruct this development, and I can only wish that we keep the same conditions in Lithuania in the future, because it shows that the state respects the autonomy of the parties, the autonomy of the human being, and their ability to not to use the jurisdiction, of course, of general jurisdiction. I'm really thankful for this, for listening to my talk, and I do hope that we will be able to meet in person. Thank you and goodbye.
I fizycznie. Dziękuję i do widzenia.
Hello. Greetings from Istanbul, Turkey to Novi Tomishil. Chamber of Commerce, Mr. President. Distinguished organizers, dear colleagues, Professor Ergun Özunay and I thank you both for inviting us again this year to make a contribution to the conference, this time online from our homes. We take pride in joining you as every year, and this year we will be talking about some of the new developments in the field of especially mediation in Turkey. Turkey has recently not only signed but ratified the Singapore Mediation Convention, which is comparable to the 1958 New York Convention. But before I go into the details of that, I want to remind you of some of the major legal sources of arbitration and mediation in Turkey. In Turkey, there is an Act on International Arbitration, which is based on the model law, Ancestral model law, with some Swiss federal law influence. And this law was passed in 2001, so it's been about 20 years, and it is still, of course, in force. Domestic arbitration is now regulated by the Code of Civil Procedure, which is also new because the old Code of Civil Procedure was totally rewritten and entered into force in 2011, so 10 years after the Act on International Arbitration, and it features very similar rules on domestic arbitration. On top of that, we have the so-called MEHUC, in short, Act on International Private Law and Civil Procedure, which, among other things, enables foreign arbitral awards to be recognized and enforced in Turkey. But as the New York Convention, 1958 New York Convention, almost covers all of the planet, including Turkey, there is less need for the rules in MEHUC because most likely you can apply the New York Convention because the state concerned will be a party to the 1958 New York Convention. Turkey is also a party to ICSID, the Geneva Convention, and quite a few other related conventions. Now, the Mediation Act is from the year 2012, and it has been amended a number of times and is expected to be amended also soon. It features a registry for mediators. Only registered mediators can practice, and they need to be graduates of law schools, so only lawyers can become mediators. They need to take a mandatory mediation training and then take an exam, and if they pass the exam, then they will be registered. And then there are special courses that they can take to become specialized mediators, and more mandatory arbitration procedures require that the mediator is a specialized one in that given field, such as consumer, commercial, intellectual property, health law, energy law, construction law, and the like. The registry is kept by the Ministry of Justice, and more and more disputes are now becoming matter of a pre-trial mediation, the so-called mandatory mediation. Mandatory means that you have to show up when the mediator invites you to the first meeting. If you don't, then, well, if you never, of course, show up, that's the refusal to mediate, although it is a mandatory mediation dispute. Even if you win later on in litigation before the state courts, you are expected to pay all litigation costs and lawyers' fees. That is either to punish you or to scare you or to encourage you to try mediation. It started with labor law disputes, and eventually certain commercial law disputes were added to this mandatory disputes list, and more are expected to be added. Of course, this causes a problem for mediators to decide, because they are then appointed, most likely, because the two parties in dispute will hardly agree on finding a mediator to try mediation, especially if it's a mandatory one, as required by law, a pre-trial mediation. Then the so-called mediation bureaus of the Ministry of Justice will appoint one. And mediators who are willing to be appointed can register themselves as available and willing, and then they will be appointed. All mediators need to be registered, but not all mediators need to accept appointments from the mediation bureaus of the courthouses. And so this feature is quite unique in Turkey, and mediators are now expected to establish bureaus on their own, or of their own, and they are to be called centers, which is a fancy word because a center needs to have a few rooms and a certain number of people working, but the details are not yet regulated. So they are expected to work from the so-called mediation centers, or in those mediation centers where certain specifications are met. And they will most likely be companies. So this is probably going to be the next legislation regulating this. Now, going back to the mediation convention, the Singapore Convention, just to summarize some of its features, we know that not every settlement agreement is subject to the Singapore Mediation Convention. It has to be in writing, although flexible in its form. It has to be about a commercial dispute, it has to be of international nature, and it has to be reached after mediation. That's where the word mediation comes. So it's not just any agreement in between the parties regarding an international commercial dispute, but one that was reached after mediation. And that has to be confirmed, of course, by the mediator or mediators. And once those are met, those conditions are met, you can apply for the enforcement of that settlement agreement in another state, of course, provided that that other state is a party to the convention, Singapore Convention. In that case, most likely the courts of that other state will examine according to a checklist which is found in the convention to assess if the settlement agreement can be enforced. These are difficult to summarize, so I'll just probably read them to be on the safer side. The court will have to see if there is an issue regarding one of these, if there's a problem regarding one of these. Incapacity of a party to the settlement. The settlement agreement is null and void, inoperative, or incapable of being performed under the applicable law. For example, the settlement agreement is not binding, it is not final, or it has been subsequently modified. The obligations in the settlement agreement have been performed, or are not clear or comprehensible. Granting relief would be contrary to the terms of the settlement agreement, or there was a serious breach by the mediator in the course of the mediation, especially a severe procedural mistake or one that involved doubts or raised doubts regarding his or her impartiality and independence. And on top of these, if the state, which is expected to enforce the settlement agreement, finds that the settlement agreement was contrary to its public policy, of course this would be decided most likely by a court of that state, or that the subject matter of the dispute is not capable of settlement by mediation, then the request to enforce it will be rejected. The Convention also makes sure that there are not parallel applications or claims, one settlement agreement and another pending case before litigation or arbitration covering the same dispute. Those are, of course, problematic, and then the court would either wait for a while, adjourn the decision until it's clarified, or ask the party concerned to provide some kind of security, suitable security. Reservations can be made by the states, and briefly, the most common one might be that the state will not wish to be bound by enforcement of settlement agreements which it, as the state, signed, or an agency or some kind of entity affiliated with the state has signed as a party to the settlement agreement. So those may be excluded by a reservation. Moreover, a declaration can be made by the state asking additionally for the agreement of the parties to the settlement agreement to the application of the Singapore Mediation Convention. So the parties must have also agreed that the settlement agreement, their own settlement agreement, is subject to the Singapore Mediation Convention. Of course, if it becomes as popular as the 1958 New York Convention. It could simplify things. It could provide the parties an efficient, cheap, relatively cheap, and faster method of achieving their goal, enforcement, without having to extend it to an arbitral award by mediation or a court decision by litigation. Time will tell how many states will become parties to this Singapore Mediation Convention, as Turkey has, and we will see. But the idea is a civilized one, as far as we can see. Now I want to conclude my remarks regarding Med-Arb in Turkey. You can do a research on this because I'm running out of time, but İSTAK, IST for Istanbul, Arbitration Center, AC, İSTAK, has new rules, among others, regarding Med-Arb, which is a package deal, so to say, and some of the issues that may be of concern in this Med-Arb procedure are covered by the ancestral model law, the new model law on mediation, which is not to be confused with the Singapore Mediation Convention. Their solutions were adopted, and even with more detail, by the Med-Arb rules of İSTAK, and they expect these to be popular, hopefully. And next time we meet, I'll be able to report more. Thank you very much for your interest. Stay healthy, and see you next time, face to face. All the best.
Dear ladies and gentlemen, good morning. My name is Joanna Kiślińska-Garncarek. I'm a doctor of law and a counsel at Gessel Law Office. I'm glad that despite the restrictions related to the pandemic of this year, I will be able to present my presentation as part of the conference Arbitration and Mediation in Theory and Practice. It gladdens me to be able to exchange ideas with you in such non-standard form, but I do believe that this is also going to be very valuable. The topic of my presentation, as the overall topic of the conference, relates to the event that has changed, that has upended our private and professional life. As I was saying, I mean here the COVID-19 pandemic, which also affected judicial proceedings as well as arbitration proceedings. Video conferencing or online proceedings have become a reality, even though they were an exception in the past. Many arbitration institutions have adopted new rules and regulations to adjust to the new normal. We also have new ICC regulations which entered into force as of the 1st of January this year. In my presentation, I'm going to address another issue that is related to the conclusion of arbitration proceedings, i.e., I would like to address the possibility of an arbitral award in electronic format. My presentation is inspired by an article by Professor Welkalisz, published in Przegląd Prawa Handlowego Journal, and in an extended version in the Journal of International Arbitration. Considerations of arbitral awards should start with an analysis of a major provision, that is Article 1197 of the Code of Civil Procedure. This provision shows certain minimum requirements to be met by the arbitral award, both as to its form and content. According to Section 1 of this provision, the arbitral award should be made in writing and signed by the arbitrators that presided over it, over the case. If we have a panel of 3 or more arbitrators, a majority of them have to sign, and a justification has to be made as to the absence of the other signatures. This provision is very important because it's unquestionably binding, and none of the parties can change the conditions, even though the will of the parties always has primacy in arbitration proceedings. On the other hand, the content of the provision can be interpreted as follows, namely, the consequence of a lack of signature under the arbitral award. Actually, you can say that then the award does not exist in the legal sense, so unless, as long as the arbitrators do not sign the arbitral award, then it is non-existent in the legal sense. The provision of Article 1197 refers to 2 requirements, that is, the arbitral award has to be made in writing and it has to be signed. In the jurisprudence, we don't have many interpretations of this very provision. If they appear, if they emerge, the interpretation is rather conservative or traditional. Most often we hear that the provision of Article 1197 refers to the traditional form of signature, that is, the graphic sign entered under an arbitral award by the arbitrator, and there is no exclusion to this rule. Article 4 of the New York Convention is cited here, which speaks about recognition or enforcement of arbitral awards, and in section Article 4 it refers to a duly authorized copy of a document or a legalized original of the arbitral award. So this provision allegedly refers only to traditional signatures. However, now international literature on the subject stipulates that the fact that the New York Convention does not refer to e-format should be actually interpreted in favor of the most modern technologies that offer us the possibility of e-signing the arbitral award. So here we can have a discrepancy between what domestic authors write about the topic and what we can hear in international arbitration circles. This interpretation the latter interpretation is more liberal of both the Code of Civil Procedure as such and its Article 1197. It seems that the conservative interpretation does not give justice to the current possibilities offered us by technologies, especially when it comes to e-signatures. However, before I present to you the more liberal interpretation, which to my mind allows us to have an arbitral award, I need to explain to you what we mean by electronic signature. This notion has been used by me quite extensively. The notion of e-signature is not uniform. On the one hand, we can speak about an ordinary signature, and when we compare it to the legal activities that we know from the Code of Civil Procedure, these are data in electronic format added or logically tied with other data and used as a signature. A more advanced kind of signature is advanced signature. This is an e-signature, which should meet specific requirements indicated in Regulation number 910 of 2014, and by analogy to the Civil Code, this is a form with notarized signatures. This advanced signature has to meet 4 conditions. It has to be uniquely assigned to the signee. It has to allow the identification of the person. Thirdly, the data used by the person has to be in large probability under his or her own control, and it has to be linked with the data so that any later changes are recognizable. Still a more advanced electronic signature is what I call a notarized act, notarized qualified signature, which is used by a qualified device and is based on a qualified certificate. When examining all the characteristic features of all the 3 kinds of e-signatures, we could recognize that an arbitral award should be signed by an advanced or a qualified signature, and I believe that this is the possibility offered by the Code of Civil Procedure. Naturally, the interpretation of Article 1197 depends on the theory we adopt as to the juridical character of the arbitral award. Obviously, we can assume the litigation procedure or a more material law approach. However, in both cases, we can draw a similar conclusion that an arbitral award can be issued in electronic format. Starting from this interpretation or litigation theory, we should interpret the autonomic part 5 of the Code of Civil Procedure. Here, let me refer to Article 1162 of the Code, which refers to the arbitration clause. It should be made in writing, and section 2 of the article stipulates that this also allows the parties to make it in writing using remote means of communication, and this provision is definitely more broad than a traditional signature in writing on a written document. In a situation when we deal with an arbitral award, we need to have it signed, and we need to consider the interpretation of the term signature. What are the unique features of a signature which are important from the point of view of a court of arbitration? I believe here we refer to the ability to identify the signee. In this context, both e-signature, qualified and advanced, seem to be giving us this same certainty as in a traditional signature. In the case of the traditional signature, in case of doubt, we might always ask a writing expert, and in the case of e-signatures, we would refer to an IT specialist in case of doubt. As for the material law theory, we can also conclude that an arbitral award can be given in electronic format. Again, another article of the Civil Code, which actually equalizes the written form and electronic form. I'm referring here to the qualified signature. I referred to this more liberal interpretation of the provisions of Code of Civil Procedure is justified by a comparative analysis. First of all, the regulations that are adopted in then in different jurisdictions, and certain modifications that are adopted by arbitration institutions in their rules and regulations. For example, in Germany, Article 130b of the Code of Civil Procedure indicates directly that both a court of common jurisdiction, of general jurisdiction, and a court of arbitration can issue awards signed by an e-signature. Let me refer to an amendment of the LCAA Arbitral Tribunal. The last sentence of the amended Article 26.2 may be signed electronically in counterparts and assembled into a single instrument. It seems that this is the direction in favor of technologies, in favor of using the technological advancements we have at our disposal today. This is the direction that both the law of different countries and the practice of arbitration tribunals, especially when it comes to international arbitration, will go. The necessity to sign, to make traditional signatures can entail a lot of difficulties today, especially in international arbitration. It can unnecessarily prolong the proceedings, and that's why we should opt for the liberal interpretation of the provisions of the Code of Civil Procedure, which allows arbitral awards to be e-signed by means of a qualified or an advanced signature. Here, there is no need at this stage for the legislator to intervene, which, for example, took place in the German Code of Civil Procedure, because even today, when interpreting the Polish Code of Civil Procedure, we can surmise that we can e-sign arbitral awards, which is in keeping with the letter of the law. Ladies and gentlemen, I do believe that my presentation is going to be a subject to debate, a discussion during the Q&A session, and I do believe we will be able to meet during the next year's edition of the conference in a more standard in-person form. Thank you so much for your kind attention.
Bardzo. Ja mówię Państwu dzień dobry po raz pierwszy i zapraszam na rzeczywiście ten blok już poświęcony mediacji. Mediacja również wiele się nauczyła od pandemii COVID-19, łącznie z tym, że faktycznie wykorzystanie tej mediacji online rozpoczęło się w dużo większym zakresie niż wcześniej, co jednocześnie ujawniło dużo problemów, również problemów prawnych związanych właśnie z korzystaniem z mediacji w ramach postępowania sądowego, czy również w tej mediacji w pełni prywatnej, pozasądowej, a także sama kwestia tego, że już spory spowodowane albo takie, na które miała już wpływ pandemia COVID-19, także już trafiły do mediacji i trafiły do poszukiwania takiej ugody, która w bardzo chwiejnym otoczeniu prawnym jednak miała zapewnić to, żeby strony miały spór zakończony i często mogły również kontynuować współpracę, więc te kolejne wystąpienia pokażą Państwu te takie pierwsze refleksje i głębsze przemyślenia właśnie związane z tym, czego mogliśmy się nauczyć już po tych paru miesiącach trwania pandemii COVID-19 i jaki wpływ pandemia miała na mediację. Zapraszam na wystąpienia.
Hello, very good morning to all of you. I'm thankful for the invitation to this conference, the conference during which we will jointly reflect on whether the current coronavirus pandemic has dehumanized ADR. In this panel, whether it has dehumanized mediation as a method of amicable dispute resolution. Ladies and gents, in my speech called Mediation as a Human Rather Than Judicial Process, I actually provide an answer to this question. For me, neither the pandemic nor any other circumstance cannot dehumanize mediation, because mediation is a human process. Mediation is a process where the human person, the parties, their needs, emotions, and solutions are the most important aspects. This human aspect is stressed in the very definition of mediation, which is a solution, which is the resolution of disputes with the help of a third party, that is the mediator. The mediator interferes into the dispute in order to help the parties handle the dispute, handle the conflict situation. The mediator helps through hearing the parties, through understanding and recognizing their positions, and then makes the parties consider different solutions and find the acceptable ones so that they can hammer out the settlement. This is the aim of mediation, and from the point of view of mediation goals, this human aspect is of paramount importance. Prior to any mediation, I always ask the parties that approach me what they expect of mediation, what they would like mediation to do. I need to learn these goals as the mediator, because they might be very divergent. There is the general objective, that is the conclusion of a settlement or the avoidance of judicial proceedings if this is a pre-trial mediation. Very often, however, when we speak about aims and objectives, we also encounter the need for a calm and peaceful conversation between the parties. There is a need to understand the other party. This is very human. This is, you may say, very little legal. And also, mediation helps to achieve some closure, to explain and to start a new reality, to start a new phase. The parties need peace and quiet and stabilization. Very often, need for improving relations, for further cooperation arises. Parties who come to the mediator have collaborated in the past. Sometimes these are family members. They want to improve their relations in the future. These goals indicate that the human dimension, human aspect, human touch of mediation is very important. From the point of view of the goals of mediation, what is mediation supposed to achieve? Now let's have a look at the basic rules of mediation. They say that it's the parties who decide. It's the parties who have the upper hand. The party has an influence over what will happen. I need to consent to mediation. I need to accept the mediator. Nothing happens without my consent and my acceptance. my approval. I can resign from mediation. I can terminate the mediation process at any moment. It is my goodwill that prompts me to stay in the mediation room or not. On the other hand, mediation gives you a sense of security, a sense of safety and security. What I will propose stays in the mediation room. The mediator is bound by secrecy and has to be confidential about everything. Also, by law, I can negotiate, and the court will not be able to use whatever concessions we make during mediation in judicial proceedings. Another rule, the rule of impartiality, which tells you that I need to trust the mediator, the third party that is supposed to help us resolve conflict. The mediator has to be impartial, unbiased, and has to cater to my interests to an equal measure as to those of the other party. The mediator cannot side with either of the parties. I need to have trust, and I also need to trust his professional competence. I have an impact on who is going to be the mediator, because I can assign the mediator, or I can ask for the mediator to change if I realize or if I recognize that they do not care for my interests in the mediation process. And also the sense of safety and security. An impartial, unbiased mediator does not make an assessment, value judgments. This also builds my sense of security as a party. And the final rule of the four fundamental ones, the principle of neutrality. It says that the final outcome is hammered out by the parties. The parties are to suggest and then sign the solution which is not going to be imposed by the mediator as in judicial proceedings. The solution, the settlement is theirs. It is customized. It is tailor-made, you can say. And this is very important because no one leaves the room without making sure that they can approve of the provisions of the mediation settlement. The mediator does not impose anything, but works in the best interest of both parties. And all of this shows that it is the human person who is the most important aspect of mediation. This is, the role of the mediator. Let's have a look at this. The mediator is to assist the parties. It should walk the parties through the rough patches to the solution. There are many tasks that the mediator has to fulfill. Let me indicate 4 of them, which are of major importance in the context of what we speak about today, that is the human process. Communication comes first. Very often when we have family mediation, the parties say that they cannot talk with one another. They do not talk, they haven't talked for a long time, and that their communication does more harm than good. The mediator is to assist their communication. The role of the mediator is to make this conversation and communication different, constructive. The mediator helps the parties to listen to one another and to hear one another, not to make the same mistakes that they have committed before, not to generalize, not to accuse, and get rid of all those elements that do more harm than good. Another role of the mediator should help the parties handle their emotions. This is what we call the ventilation of emotions. You need to deflate the balloon by puncturing it with a needle. very often the parties are at gridlock. They cannot move forward, and the mediator helps them handle these emotions through active listening, through giving them the ability to express themselves freely, through allowing them to show emotions in a controlled fashion. This is an extremely important task, especially in family mediations, but also in labor disputes or even business mediations. These emotions sometimes run high. Another important role of the mediator, from the point of view of the human touch of mediation, there is the need, the necessity to reach to the ulterior motives of the parties, you can say, to the most profound needs of the parties. Now, you need to speak in a language of needs. You need to ask questions about what is it that you need? What is it that you deem important or most important? What is it that you can sort of give in, and what is it that you cannot really resign from? So we need to really reach to the bottom line of the conflict. We can again use the metaphor of the iceberg. The tip of the iceberg is only a seventh of the huge ice mass, and this is something we should bear in mind in order to hammer out a solution which is acceptable by all the parties. And one last task for the mediator is to build understanding. This is what I referred to before when I spoke about the expectations of the parties to mediation. Building confidence, building understanding is very important because it helps you reach a moment when the parties want to collaborate, when they really seek common solutions, when they do not want to impose solutions which benefit only them without recognizing the needs of the other party. The parties need to understand that that the other party does not want to destroy them, to deliberately harm them, or to wrong them even, but the motivation is dramatically different. Building understanding often involves that each of us participating in mediation have their concrete concerns and fears. They are uncertain about the final outcome. They are then uncertain about their situation. We need to highlight one more thing: the mediation outcome. I spoke about it in referring to neutrality. The outcome depends on the will of both parties. We do not need to respect anything on pain of death, you can say. This is a process, a human process, which we develop ourselves. We ourselves know what is best for us and also for the other party. The pandemic has turned the tables. The mediators and the parties have been faced with big challenges. Mediators who had never done online mediation had to prepare for this format, and the challenge of organizing direct meetings where you have to have social distance, where you need to social distance. Well, this is definitely a demanding time for mediation, so we need to adjust to the new normal, to the new reality. This is very difficult, no doubt, but it does not mean that we have dehumanized mediation, because the human being, the human person, is the most important aspect of mediation. If mediation were dehumanized, this would not be mediation, even if it's online. I grant you that this might be more difficult, but if we meet at table, these are not normal circumstances because we cannot shake hands. We know that this is a very tough situation. We can sense that. However, mediation is and will continue to be a human process. We need to focus on the parties to mediation proceedings. These are the most important aspects of mediation. Nothing will change the fact that we need to work on communication, on emotions management, and seek solutions which are acceptable to both parties. These are the core, these are the foundation stones of mediation. And the current pandemic, the current situation has increased the level of difficulty, but it has not dehumanized mediation, because the fact that the human person is the most important aspect of mediation is a given. And this is also something that I deem the most beautiful thing of mediation. The parties and the mediator make mediation very human. Mediation has to be friendly, has to be focused on the needs of all the persons participating in the mediation process. I'd like to thank you for your attention. I wish all the mediators perseverance, hang in there, and wait out this time. And I do hope we will be able to soon meet face to face and also shake hands, also with our parties. Again, to sum up, the human person is the most important aspect of mediation. It was a great honor for me to be here. Grażyna Górska, a mediator.
Było mi niezmiernie miło. Grażyna Górska, mediator. Dziękuję.
Hello, a very good morning to all of you. I'm thankful for the possibility, for the opportunity to show to you this very short presentation. Mediation online, what has the pandemic taught us? I will present to you this topic from the perspective of a mediator, basically in commercial matters. For the most part, these mediations are referred to by a court of general jurisdiction. I'm also deputy president of the Mediation Center at the National Bar. I would like to say that during the first lockdown, we started a huge project on online mediation. Together with Ms. President, we coordinated this project across Poland, and actually the number of mediations has increased. This was basically due to the number of cases that were backlogged in the courts of general jurisdiction. And in the first place, I would like to refer to the question, which is the topic of this year's conference. That is mediation threatened by dehumanization? During my presentation, I'm going to show to you examples from Polish law. This is because this is my jurisdiction, but I do realize that this is an international conference, so please treat these examples of Polish provisions as illustrative of certain problems that can be encountered not only in dispute resolution in Poland. In response to the question, in Polish law, under Polish law, mediators can sleep soundly because only natural persons can be mediators. We know that there are some consumer disputes where, on the basis of analysis of a huge number of data, of big data related to earlier procedures where certain patterns emerged and certain probable solutions can be applied. We do not have this possibility in Polish mediation. Now, moving on to mediation itself. How much online can we have in mediation? Also looking at Polish law in general. In contractual mediation, out-of-court mediation, on the basis of mediation agreements or a mediation clause, there is a lot of online mediation. The initiation can be online, and then the exchange of documents, the video conferencing, and so on and so forth. The conclusion of the settlement can be done by mail, by post, but I'd like to refer to it later because this is a tentative procedure. However, the final activities like the drafting of the protocol and the approval of the settlement has to be done in person. When it comes to court-referred mediation, here the exchange of documents and the procedure, the mediation procedure can be done online. I told you that the initiation of the mediation procedure calls for in-person activities. However, notification of an announcement of a referral to mediation does not need to be in writing, and both the jurisprudence and the practice of the parties shows that electronic mail is quite widely used. Email was also used a lot before the pandemic. However, it now is used far more often. And we know cases, and I know it from my own practice, that the court has notified the mediator by email, and the mediator can start contacting the parties to the dispute. I've also had cases where it was the parties that notified me that the referral to mediation was done, and the parties already wanted to initiate the mediation procedure. I would like to say that we can start these talks between the parties very soon. I would like to show to you that we need to exercise a little bit of caution when it comes to the mediation settlement. Under Polish civil law, Article 1917 of the Code of Civil Procedure does not show any specific manner of concluding a settlement, a mediation settlement. However, here when we talk about procedural law, it's recommended that parties to the dispute sign the settlement. I was once tempted to use the final sentence of this provision that we can have mediation also online. I'd like to refer you to Article 78 of the Civil Code, which stipulates that the copies of the mediation settlement be signed not only by both parties at the same time. The parties can exchange the documents. I can actually refer to or submit to the court a one copy of the mediation settlement signed by one party and the other copy by the other party, and the court recognizes these settlements. Now, let me refer you to the tools offered by online mediation. First of all, telephone call or video conferencing. We would not like to sort of denigrate mediation just because it is conducted online. We need to treat online meetings on a par with offline meetings, in-person meetings, and mediation certainly deserves the same degree of respect. Definitely, video conferencing offers us a wider spectrum of tools for us as mediators as well as for the parties. On the other hand, however, we need to indicate that all the different software that is used for online mediation allow for muting the participants, creating waiting rooms or separate rooms. So these individual meetings, even within general meetings, are possible. So we can actually move to different rooms to converse with one of the parties. However, we need to make sure that the parties do not make a recording of the proceedings. We cannot be 100% sure, but we should indicate to the parties on and off that these are confidential meetings and that they should not be recorded and made available to third parties. Let me say something about screen sharing. In many mediations conducted during the pandemic, we also could use of spreadsheets. I'm not myself an expert in Excel, but the parties are really expert at this, and they can show us data. They can share the screen and show the data they entered in the spreadsheet. The same is about document addition. During the mediation, all the parties can draft the settlement document instead of multiplying files exchanged by email. We can have one document which tracks down the history of the annotations of the changes, and this is very helpful for all of the parties and for the mediator. Not only during the mediation meeting, there are many other tools. Like in a regular mediation tool, we use flip chart, we use the whiteboard, we draw, we present different figures, graphs, and so on and so forth. They are also available in the software as thought maps, as virtual whiteboards. Sending files through in the cloud is also a way of using the cutting-edge technology for the purpose of mediation. Video conferencing helps us to communicate through a variety of channels. On the one hand, we see each other, we conduct conversation, but on the other hand, we can enter information in the chat box, we can ask questions, we can remind the party that the question has not been addressed, we can structure our conversation. So this multi-channel ways of communication helps us in the smooth running of the proceedings. Also, practice tells us that mediation cannot be limited to exchanging draft mediation settlements by email. I've had a number of cases where the parties have proposed to simply exchange at the very beginning settlement drafts. I believe this doesn't do full justice to mediation. I believe that the exchange of information and the fact that the parties should be able to present their perspective before they move on to discussing mediation settlement provisions has its value. And I don't think we should start with draft mediation provisions. And a few lessons that can be had from online mediation. First of all, we can say that the rebus sic stantibus clause is very popular nowadays. Just because it's indefinite, it's not very precise. We can avoid an unequivocal resolution of a dispute. Very often, even though the parties invoke this clause at the beginning, then during conversations it turns out that we can find a solution that we do not need to refer to this clause, and that a certain uncertainty and a certain indefiniteness also helps us to find consensual methods of dispute resolution. Finally, I would like to indicate something as preliminary settlements for the duration of mediation itself. For example, the pandemic has shown to us that gentlemen's agreements are in vogue, even though they are not written agreements between the parties. They do work and they are respected, and certain cases can be agreed on orally during the discussion for the duration of the mediation proceedings. The pandemic has also shown to us that mediation can comprehensively resolve a dispute between the parties. In my practice, I have often dealt with cases where we have mediation added to one case that was referred to a judicial proceeding. During conversations with the parties have expressed their will to have all their disputes to be settled during mediation, and all of them actually concluded with mediation settlements then submitted to courts. And actually this shows to us that the pandemic has shown to us that we should resolve certain disputes which are protracted, which have been going on for a long time. And here the mediation can be used as a remedy to all those situations. And finally, I would like to debunk a myth which I have encountered in my conversations with the parties, who claim that the value of the object in dispute is low, but if it was if it was the value of the object in dispute was bigger, then we would not be talking about mediation. Well, mediators will tell you that all disputes can be resolved in mediation, and I have seen cases where the value in dispute was very high. So let's not say that mediation is limited only to some cases. Actually, all cases do benefit from mediation, and it can efficiently conclude a dispute between the parties. And having said that, I would like to thank you very much for our today's meeting in this virtual format. And once again, I wish you all the best and the best of luck. Thank you.
Jeszcze raz życzyć Państwu wszystkiego dobrego. Dziękuję bardzo.
Good morning, ladies and gentlemen. I'm going to talk about online mediation, which today is a major part of mediation because next to in-person mediation, where we meet with the clients as mediators in a room, we can also lead mediation through video conferencing. This is an interesting form of procedure because it allows the clients to proceed remotely, which is why it is less time-consuming, and also it is more efficient for both the mediators and the parties. And there are no major differences with stationary mediation. Also, in online mediation, you can also conduct court mediation, that is, mediation referred to mediation by an injunction of the court, as well as contractual mediation that is conferred on the mediator by private clients. According to Article 183, Section 2, Paragraph 2 of the Code of Civil Procedure, mediation can be either contractual or mediation proceedings can be referred to by a court of law. The second sentence of this paragraph is very important because it says that mediation contract can also take the form of a motion for mediation when the other party agrees. This is of paramount importance, as this regulation makes it possible for us to conclude a mediation contract remotely. That is, this motion for mediation can also proceed through this contractual mediation without all the parties being present in one place at one time. Very important here is the provision of paragraph 183, section 3, paragraph 1, which stipulates that the mediation procedure is started when the mediator is served with a mediation motion and proof of the other party being served with it. So the party that would like to start mediation in this way is obliged to make a mediation motion, and then this motion has to be sent to the other party so that there has to be proof of the other party being served, and then the first party sends this mediation motion to the mediator with proof of the other party being served, and the mediator contacts the other party. If the other party agrees to mediation, we can start contractual mediation. So this is very important because we do not need all the parties to be in one room, which is a very important pattern for mediation. What does mediator know after being served with the mediation motion? I would like to focus on contractual mediation. The mediator contacts the parties to settle a timeline and the venue of the mediation proceedings. The venue will be the choice of a specific platform for video conferencing. And once the choice is made, then at an appropriate time and place, the first mediation proceeding takes place. The mediation proceeding that is called virtual, but from the point of view of the methodology of mediation proceedings, there are no major differences. For in-person and online mediation proceedings, we have the same method of proceedings. The mediator welcomes the parties, then asks the parties to identify themselves, to show the IDs, and the parties will show the IDs to the camera so that the mediator can read the data and can identify the parties, and then the procedure begins. The mediation procedure involves the exchange of party statements and the sharing of their expectations, and this is followed by building a resolution. This is very important because this resolution can be concluded in this manner. I will speak about it in a minute, but during this mediation procedure, we should respect mediation rules, one of the major of them being the rule of confidentiality. According to a specific provision of the Code of Civil Procedure, the mediator, the parties, and all those involved in mediation procedure are obliged to keep secret all the information that they receive during the mediation procedure. Another procedure is from another provision of the Code of Civil Procedure, according to which the mediation procedure is behind closed doors. This is a major element of mediation proceedings because no third party should be present in the room of the mediation proceedings, because we can have parties, we can have representatives of the parties, but no third parties. Because, as I was saying, here we have a confidentiality clause, and this is a very important matter. A question arises how to make sure that there are no third parties in the room, or that the principle of confidentiality is preserved. It is a good practice to ask the parties to make representations in this regard, so that the parties represent that in the room that they are present, there are no third parties, that they do not hear the conversations, and they also represent that they will hold in secrecy the content of the conversations and that they will not record the meetings. This declaration, this representation can be put orally and in another form. I think it would be interesting to build the protocol, to build the minutes, according to provision 183, signed 12, in a situation where the parties conclude a settlement before the mediator. This settlement is put in the protocol or is appended to it, and this regulation is very important, because the fact that the settlement does not need to be in the protocol but can be appended to it makes it possible to conclude the settlement remotely, and the mediator signs it and then signs the protocol, and then the parties sign it through the exchange of documents, and the mediator will describe these issues in the protocol. So this is a technical issue. The protocol, the mediation protocol, must indicate certain information according to a relevant provision of the Code of Civil Procedure. The mediation is put in the protocol, where you describe the name and place of the mediation procedure, the parties, the mediator, and the question is, what is the venue of the mediation if this mediation is remote? We need to think that this mediation is through video conferencing, and then has to be described in this matter. When it comes to online mediation, the analysis of provisions of the Code of Civil Procedure is possible to interpret that the provisions allow us to conduct online mediation, because for contractual mediation it can be done remotely. Settlement can also be concluded remotely through the exchange of documents between the parties, or through e-signatures, and the protocol as the place for conducting mediation. The system for video conferencing can be indicated. As you can see, mediation is an alternative to court proceedings, and here we are strengthened because we have an additional space that online mediation is an alternative to court procedures, because we can have virtual meetings, online mediation, which is very, very innovative. These are the major issues. I'm really thankful for your kind attention. Crises and emergencies, like this year's pandemic, no doubt are conducive to new solutions to streamline the administration of justice. They make us pose questions: how to facilitate citizens' access to the administration of justice, how to streamline the resolution of their conflicts. In the report, Mediation and the Jurisprudence in Italy, Giovanni Matteucci stressed that in 2009, when we had a financial crisis in Europe, we had a large number of civil proceedings in Italy, over 5,700,000 proceedings, and as you can imagine, these proceedings were prolonged and you had to wait for them for a long time, and this made Italians see the benefits of mediation. First, it was mandatory mediation. In 2013, it was opt-out mediation, but provisions were put in place to encourage justices to refer cases to mediation. The opt-out mediation introduced in 2013, that is obligatory information meetings pre-trial proceedings, is obligatory in Italy in around 10-15% of all cases, of all commercial cases. In the remaining 85% of civil and commercial cases, including family and labor disputes, we have the opt-in mediation model. That is, a case can be referred to mediation by a judge or by a mediation clause if it was part of the contract. Giovanni Matteucci, Dr. Giovanni Matteucci, in the report I indicated, shows that in Italy we can speak about a rise, a spike in mediation proceedings as of 2015, thanks to the judges that started to refer their cases to mediation proceedings. Giovanni Matteucci believes that in Italy the pioneers of promoting mediation are the justices themselves. The Italian example has shown to us that the time of crisis is good for the promotion of mediation. The Italian example has also demonstrated, but we can also draw upon the experience of other EU member states that have introduced mediation provisions, as well as the guidelines related to the European Commission documents on streamlining the administration of justice. All of this has indicated that it's the justices that play the key role in the promotion and development of mediation. One of the documents of the Commission for the efficiency of the administration of justice mentions the assurance to the parties to the dispute of access to mediation through the strengthening of the skills of the justices to refer cases to mediation. Research conducted in the Netherlands showed that the parties themselves rarely referred to mediation, and they would not have known, without the intervention of the justice, where to go to, and they were unaware of the advantages of mediation. It was the justice's decision that a given dispute can be resolved by mediation that made the parties decide to have their disputes referred to mediation. That's why the parties should have the right to mediation, which would be referred to by the judge that refers the case to mediation. Perhaps the time of the pandemic is a time where we should follow Justice Béatrice Brenner who says that the right to mediation should be awarded to any citizen, like the right to litigation, to a just judicial process. To her mind, this is the future of the administration of justice. Now, I believe that because of the pandemic, we have resorted more and more to online proceedings, and mediation is no different. However, the mediation online is not the same as mediation in a mediation room at a round table. We indicate a lack of a possibility of direct contact of the parties with each other and with the mediator, which makes the mediator's task even more difficult. The mediator has problems building trust and get to the root cause of the dispute. This, as a consequence, may diminish the chances for an amicable solution, for a settlement. A question arises: how can all these elements be replaced and make mediation successful? At what stage of conflict resolution should the parties be shown empathy, understanding, and where should we build trust? The answer is at the stage of the judge referring a case to mediation. The key to a successful mediation is a skillful and proper referral of the parties to mediation by the justice. It is a tall order to refer the parties to mediation at such a point where they are really motivated to conclude a settlement. Now, what are the tools that the justice can use to increase the motivation of the parties? First of all, this is direct communication by letter, a letter to the parties and to their representatives, together with a questionnaire that they need to fill out, and that will help the parties to identify whether mediation is the right and proper way of resolving the conflict. This letter should be sent at a pre-trial stage, when the justice recognizes that a given case has this mediation potential, and the justice should send a letter to the party. Ladies and gentlemen, have you thought about resolving your dispute via mediation? As the judge who is assigned to the case, believe that your case, your dispute, can be best resolved through mediation. In some jurisdictions of the European Union, such letters are signed by justices, and the last sentence often is that the justice which is assigned to recognize the case supports ADR and encourages their use. The parties, after having received this letter, the parties have indicated that they felt being selected, being really approached individually by the justice, and they were shown which method could be even more conducive to solving their dispute. And the same letter could be addressed to the representatives of the parties. Such a letter should stress the role of the representative in mediation, and the justice should also indicate that they recommend the resolution of the dispute through mediation. Again, a questionnaire should be appended to the letter. A questionnaire titled "Is mediation right for me?" where the party can indicate yes, no, or I don't know. And if there are more affirmative answers, this can indicate that a given case has this mediation potential. This questionnaire should be appended to the letter to the representative of the party. Another moment when the judge should attempt to refer cases to mediation is litigation itself, either online or offline. This is the moment where the parties, together with the justice, try to resolve which way is best to resolve their dispute. The judge should test the parties' ability or capability of negotiation through hypothetical and open questions. Questions that would suggest to the other party that they reflect on certain conditions that the other party demands. It is indicated that the way the questions are posed by the judge affects the party's approach to mediation and choice of mediation. Asking questions is the best way to somehow get to the bottom of things, to get to the core of the dispute and to the level of conflict escalation, to really get to the essence of the problem. When we ask questions, we show to their addressees that we are interested in solving the case. The justice may actually affect a change in the party's way of thinking, and they may be more conducive to solve their case, their dispute, through mediation. It is only after the will to negotiation is determined should the judge move on to saying a few words about mediation, should dispel their doubts, and speak about the role of the representatives as well as about the role of the mediator, him or herself. During the proceedings, the judge should address directly the representative, stressing their role in the mediation proceedings, and the judge, when showing any concerns or doubts on the part of the representatives, they should address them directly. I understand your doubts because so far you have dealt with the client's dispute in terms of litigation, in terms of a judicial process. I understand that the client might also use another alternative, that is mediation. And the judge may also ask a representative whether they believe that litigation is the best way to proceed. And finally, the questions can refer to the choice of the mediator. The parties themselves may not agree on the person of the mediator, and it is the judge who may indicate to the parties a respectable person who has experience in a given area of disputes. It is said that the choice of the appropriate mediator is a precondition for mediation to be successful. The judge is also expected to show a personal conviction that mediation is the best way to resolve a conflict. The judge also has to indicate that his own professional experience indicates that this particular conflict can be resolved through mediation. It is indicated that only a judge who is really convinced that mediation works and can enthusiastically speak about mediation can successfully encourage the parties to initiate mediation. However, we should not lose sight of the fact that the parties and the representatives are forced by the judge to use mediation. Each party has the right to litigation in the court of general jurisdiction, and not using mediation must be clearly indicated that it will not have an adverse effect on litigation. To sum up, access of citizens to the administration of justice is not only access to litigation in court, but access to a cheap and effective way of conflict resolution. Mediation as a modern way of conflict resolution is seen in many European Union member states as an element of the administration of justice. The advantages of mediation may streamline the entire judicial process, the entire judiciary. The more cases are referred to mediation, the more time the justices have on their hands to recognize cases assigned to them by their courts, those cases that cannot be resolved through mediation. Also remember that the settlement of a case before a mediation will obviate the need for parallel motions and for appeal. We also need to stress that even if the parties do not settle the case in a courtroom, then definitely litigation is easier because the parties have already vented their emotions, have already spoken openly about their alleged wrongs, and now litigation is more streamlined thanks to this. And all of this definitely contributes to the positive image of the administration of justice. That's why we need a change in the idea of dispute resolution. We should not think only about dispute resolution as litigation, but we should think about a way that is the most rational, economic for the parties. Interestingly, at this point, we should indicate the great satisfaction, personal satisfaction of the justices who refer cases to mediation. Justices are especially proud when the parties are initially very skeptical towards mediation and then were still able to resolve a conflict, a prolonged conflict, a protracted conflict during a mediation settlement. Also, the parties, the justices appreciate the fact that they can really support parties in dispute resolution, and something which a litigation may not be able to do. And here we can say, Saint-Exupéry, we can say that the nicest help in the world is to help people reconcile with each other. Courts of general jurisdiction and mediation proceedings should work hand in hand. Justices should encourage parties to choose mediation, and they also should speak about mediation both in writing and orally in a favorable way. The first justice of the Supreme Court in the United States, the first woman there, Sandra Day O'Connor, said that the conflicting parties should first of all themselves avail themselves of mediation, and the court should be seen as a place where a case may be filed for resolution, however, only after the mediation route has been exhausted. I believe that in Poland we will be able to await this change in the way of conflict resolution only after a few or a dozen years of promoting mediation by judges.
Good morning, ladies and gentlemen. I welcome all who have gathered in front of their computer screens to listen to to today's conference. My name is Małgorzata Miszkin-Wojciechowska, and I would like to congratulate Mr. Włodzimierz Brych, President of the Arbitration Court at the Nowy Tomyśl Chamber of Commerce and Industry, as well as Counsel Piotr Nowaczyk. I would like to also give my greetings to my two friends. The topic of our today's meeting, of our today's conference, is whether COVID-19 has dehumanized mediation and arbitration proceedings. Before I attempt to answer this question, and before I tell you what I have considered when analyzing the topic, I must say that the topic is very interesting, is controversial, you may say, subversive, but also has a certain element of threat. And I really feel the shivers. Do you feel the shivers yourselves? I looked up the term dehumanize in a dictionary, and dehumanize means to strip of the human dimension and to become cruel. And we can say that actually COVID-19 has dehumanized all our lives, has made all our lives cruel and callous. This is really an unprecedented time. The generations affected by the COVID-19 pandemic will remember it forever. We all had to change our perception of interpersonal relations. Families of patients, of COVID-19 patients, experience a tragedy. We who can meet with one another today are also affected by some personal tragedy. So you can say that COVID-19 has really made our lives different, has changed our lives. Our kids attend school classes remotely. We conduct arbitration and mediation proceedings remotely. Have they become dehumanized? Well, you can say that they have really become more difficult. All mediators know for a fact that nothing can ever replace in-person contacts, a handshake and a gaze into somebody's eye. A mediator, during his or her work, makes note of things, listens attentively, asks appropriate questions. All of these reactions, ladies and gentlemen, that a mediator experiences during in-person proceedings can be noticed. All of these elements are lost on the mediator in online proceedings. The role of the mediator as the sentinel of the procedure is to make sure that the technological tool works properly. So, well, you can only imagine the gravity of or the size of the work that the mediator has to do during online proceedings. So the mediator, as the sentinel, as the guard of proceedings, has to also take care of technical aspects, has to take care of data protection, and so on and so forth. So there are many more issues to be analyzed as far as mediation, online mediation is concerned, than in-person mediation. Obviously, we still have a lot to do, but the categories of activities are different. So, well, in answer to the question posed by this conference, I do believe that COVID-19 has changed our proceedings and has made our work more difficult. And it has also made this work more cruel because it has stripped us of immediate contact. As a result, in light of the above, I have thought that if a person seeks solutions, if a person is a man of action, I would like to seek something. I'd like to find something to propose to you as a safeguard against dehumanization of proceedings. What is it? I have considered for a longer time that is known in English-speaking countries as the position statement. I have looked up the internet, whether we have any publications on the position statement. I haven't met many. Perhaps it would be interesting to seek your opinion. I believe that our international participants, this is going to be quite innovative. This position statement is not that often used in Poland. It's definitely less frequently used than in the UK or the US. I would also like to refer to a document that can be found on the web page of the International Mediation Institute. You can look up this document, and you can also look up websites of renowned, prestigious mediation institutions or the American Bar Association, where you can find information, where you can find guidelines about how to prepare the position statement. Now, why am I saying this? Apart from many other provisions which are important, the position statement contains a question that is asked by the representative to the client. I'm talking here about commercial mediation, where very often we have representatives. I believe that the representative asks the party about their opinion about the position of their opponent in dispute. What are the expectations of the party to the matter at hand? So what happens when this question is posed? The party is put in the center of attention. A person becomes the center of attention. So in a way, we prevent the dehumanization of mediation proceedings because the parties start to think about each other. But let's come back to the procedure. What is the procedure all about? The position statement can be used in both court mediation and contractual mediation. It is more often used in commercial disputes. Sometimes I have seen on websites of different US institutions, it is also used in family disputes. So I recommend you have a look. And before the first mediation meeting, the mediator can ask both parties to prepare a position statement where there are certain issues, certain data about representation, about the history of the dispute, about past proposals for settlement, and so on and so forth. And then we have the interesting section about the proposal of how the dispute can be solved. What are the expectations of the other party? The representative can also propose to the mediator, because the representative knows the other party and they know the antagonism between the parties. They can also propose the way of conducting mediation proceedings, which is also very important for the mediator. I have repeatedly heard that the position statement introduces order into the dispute and gives us know-how about the parties to the dispute. It educates the parties and prepares them for the mediation proceedings. It is, you can say, a prelude to a settlement. And what happens after the mediator receives the position statement of both parties? They can ask that these be submitted on one day to avoid a leak of data at this early stage, because the position statements are also subject to confidentiality. And after they have learned what the parties have written there, the mediator can identify the zone of potential agreement and can inform and can act on the suggestions, on the proposals of the parties from the positions. They can propose the procedure, and also the mediator can know about the kickoff point for the mediation. So this is the work of the mediator. The declaration, the position of position statement is confidential. We need to remember about it. And let me make a note at this point about the submission for mediation and the claim. The arguments which are in Poland in court proceedings given in the claim can be similar as to the merits of the case. They can be submitted in the position statement because it is also subject to confidentiality. However, I would like to to highlight one thing. In the submission for mediation, in the motion for mediation, very often representatives write down the proposition for the resolution of dispute, And if these proposals are too high, we can say, they anchor the proposal, and from the point of view of the party to which the proposal is addressed, they do not allow to move below this proposal. All mediators and negotiators know what I'm referring to here, even if the representative says and writes in good faith and says that this is only a preliminary proposal and the party that they represent is ready to further negotiate the terms, and this is just a preliminary offer. As I was saying, all who deal with negotiations and mediation know that the anchor has been dropped, and it's very hard to move it and to move one step down or one step back, to take one step back. So this is a real danger, and also a motion for mediation, if this is going to be effective in line with Article 183 of the Code of Civil Procedure, with Index 6, if I recall correctly. If this is going to be effective, then it is served on the other party. So if the motion for a mediation with settlement proposals, too high settlement proposals, reaches the other party to the mediation proceedings, we can say that the mediation has already concluded. And experience shows that in contractual mediations, such a situation may result in the other party not commencing talks. Well, this is because the proposals were too demanding. So I would like to again indicate to you that we must we must be aware of what we can write in contractual mediations. As for court mediation, the writ is already there. We cannot change it. The representatives of the parties read the writs if they are prepared for mediation proceedings. So there are certain synergies when it comes to the claim, the motion for mediation, and the position statement, but only the last document is confidential, and you as representatives of one of the parties can limit the framework within which you want the dispute to be concluded, to be settled. And these frameworks and conditions are subject to confidentiality, and this is the advantage of the party who sends the position statement honestly filled out. As I was saying, the question I mentioned earlier, that is the direction in the position statement of the parties to the needs of their opponents to the dispute, are the most important element that prevents or supports dehumanizing proceedings, mediation proceedings through COVID-19, and it directs attention to the human person, to their needs and their concerns. And that's why I believe that our today's conference is an excellent opportunity to bring to your attention the position statement. I wish you a fruitful discussion. Thank you so much.
A very good morning to all of you. My name is Olimpia Barańska-Maruszek, and I am a judge of the District Court in Gorzów Wielkopolski. I would like to thank you for the ability to participate in this conference, Arbitration and Mediation in Theory and Practice. While working on on my presentation, I was not able to meet with you in person, but thanks to the technology, I can welcome you to my place, and I can actually wear a jacket and slippers. Is technology a threat for us and for our practice so far, or is technology both a challenge and a positive development? Obviously, during the lockdown, we could not close down courts of general jurisdiction. However, thousands of proceedings were postponed, and judicial proceedings were lengthened. We are constantly facing issues that have not been solved. We have paper documents instead of digital ones. We send everything through snail mail rather than email. We do not have the technology in place. Last year, the Polish judiciary was almost completely blocked, but it was only thanks to our own work that we were able to redirect the bureaucracy to a more flexible contact and work with our clients, with citizens. Article 6 of the European Convention on Human Rights says that everybody has the right to have their case recognized in a reasonable time and openly. The same is enshrined in Article 47 in the Charter of Fundamental Rights, and this is also enshrined in Article 45 of the Constitution of the Republic of Poland. It stipulates that everybody has the right to have their case recognized by an independent and impartial court, and the quality of this can be only limited by certain cases enshrined in the Constitution. However, in practice, access to common courts was somewhat significantly restricted because citizens were not allowed access to the court building. Overnight, we had to change the procedure, and as of May 2020, we have been able to have hearings online. However, the criminal cases were exempted from that because we do not have the technical wherewithal to do it. The openness of the case is limited by the new provisions. In April 2011, we had 2021. We had a special, COVID-19 related law, which says that an open proceeding is the rule, and the judge can refer the case to a behind the doors hearing if the parties do not submit any reservations within a specific period of time. It is also, we can have online proceedings, and the president of the court can order online proceedings. In practice, however, we deal with limited access to the court building and access as such to court. Citizens have problems receiving documents and sending documents on time. In 2019, we amended the Code of Civil Procedure. Court fees increased significantly, and the procedure is more formal and more difficult to citizens. And imposed on that is the current pandemic related situation. New solutions like testimony in writing or somehow limit the citizen's right to a court of law. However, the European Court of Human Rights, in its ruling of 2013, said that the right to a court is realized when the citizen has direct access to a court, at least in one instance. Now, when we look at the direction of procedural changes, we are really afraid of of losing this right to direct access to court. What is it that we lose? We lose direct contact with the other human being, something which is the essence of the court. A personal meeting is either in mediation or in a courtroom. The parties very often see each other the first time since the dispute arose. We can also say that under the pandemic, in the lockdown conditions, this interpersonal contact has been really hampered, and it is hard to really have eye-to-eye contact, to meet somebody eye-to-eye when looking in the screen of your computer or a panel. Well, technically this is really difficult to have eye contact with the other party and with all the participants of the proceedings. Add to this non-verbal expressions like facial expressions, rolling your eyes, and so on and so forth. Actually, these seem to be augmented and they seem to be more acute than in reality. As judges, we see that the camera is set on the judge, and when we have contact with the person who is being questioned, all the other parties present in the room do not see this, and can only only the judge can see the screen, and all the other people present cannot see it. So we have a somewhat twisted perception of what's going on in the courtroom and in the mediation room. Mediation allows us to resolve disputes on many different levels, emotional, economic, family, and so on and so forth, just because it is flexible. ODR, or Online Dispute Resolution, has been with us since the 1990s, and through the regulation of the European Commission of 2013, we have been able to use a special ODR platform. So actually this is not a tool that is new, but the commonplace use of this tool that is novel. Also mediation in convention, in family matters, in transborder cases, through lockdown and through ban on traveling, through travel bans, we haven't been able to proceed with certain transborder mediation proceedings, and the contacts between, say, estranged parents and kids are very much hampered. However, there are conventions which recommend for the carers of children from two different parties the participation of two mediators from each of these countries, a pedagogue, a psychologist, and also, if necessary, interpreters. At present, this is actually the only thing. Online is the only environment where we can meet in such big numbers at the same time. And this is the Wrocław Declaration that I'm talking about here. Also, before an online mediation, you need to plan how do we collect the signatures under the mediation settlement. Obviously, you can send a settlement draft to one party, then they print it out, sign, and then send it to the other party, and then it's submitted to the court. But it's also possible to submit to the court two separate documents with signatures of the relevant parties under the settlement. It would be great if we could have e-signatures or using a system. Interestingly, in the US, we can observe a practice where the mediator, a lawyer, and a representative of the parties, a mediator him or herself, can sign the settlement, the mediation settlement. introducing such provisions in civil procedure, the legislator should also allow for the signature of the documents through e-signature and other ways. Hundreds of millions of internet users online. There are hundreds of millions of users of the internet around the globe. So this is a really huge leap forward. I believe we will come back to in-person human relations. However, we do realize that many temporary solutions will remain with us for a long, long time. And lawyers, mediators should be prepared that the new normal can comprise a lot of online activities. And this is a good development. However, I do also hope that the courts will only meet in non-open proceedings, because this is not in line with the right of individuals to have their case heard in open hearings. We need to have interpersonal contact. For mediation, I see a chance for a robust development online through cost effectiveness and time effectiveness. I do believe that we all need to take measures to prepare ourselves and the clients for the permanent changes. Thank you so much for your attention. Hello, very good morning to all of you. At my short presentation, at an unusual conference, the conference that you may have had contact with before, or maybe this is the first time you've been here. So far we've met in Nowy Tomyśl live, in person. However, today we are meeting online, but we simply need to adjust to the pandemic. And this also affects the way we carry out mediation, and this is the topic of my presentation today. I will draw on my experiences in the field of mediation. I would like to thank Mr. President Brich for inviting me one more time to this conference. I accept the challenge, Mr. President, and I would like to address this topic. The topic Mr. President has put to all of us here, whether the dispute resolution has been dehumanized. And I will try to elucidate one of the aspects that we will be able to use to answer the underlying question of the conference. I will focus on two issues: on my practical experience of last year, on how parties resolve disputes through mediation. This is where I am now in my mediation office in Poznań, where together with my partner we carry out mediation. And this is a time when all of us, mediators and all involved in dispute resolution, work. A few technical comments, practical comments at the very beginning on what I have experienced myself and what you can relate to as well. I do hope it will be more interesting than the statistics that I'm going to address in the second part of the presentation. Those of you who are a little bit bored by stats, facts and figures might use the latter part of my presentation to have a coffee break. I'm going to relate to some of the statistics released for 2020 by the Ministry of Justice in Poland. So this is something you would like to, you are gonna see in a minute. The three issues I would like to mention at the beginning related to my experience as a mediator. Three issues. First of all, a few things on online mediation. I know that my colleagues in their papers also address online mediation, so I'm only going to flag some issues and some of the conclusions I have drawn from my practice so far. The second issue is the question of finding solutions in mediation and how parties work today. And the third one is the excuse of the pandemic, that is, the reason why the pandemic has become an excuse for mediation and sometimes for striking a deal, but this I will address in a minute. The first issue, that is online mediation. How do we operate today? And some of the things I have noticed is undoubtedly the number of mediation proceedings, not only online mediations, but also remote mediations, has definitely increased significantly. One of the consequences of the spike, which was forced on us, as well as in many other areas of our life, professional life as well, I have observed an opening up of the mediators to this form of communication, and it seems to me that this is going to be something that will stay with us forever. That is, after the pandemic is over, we are definitely going to be meeting in offices, but the tendency, the trend, is gonna stay with us. I would like to refer to a mediation proceeding where we had one meeting online, and one of the persons was joining us from a building site, from a construction site. One of the parties was in a safety helmet, in protective clothing, and they participated in the mediation proceedings like that. This also shows the strength of mediation. On the one hand, you may say that the attire was very informal, but this also shows the strength of mediation. You spend less time commuting to the mediation site, and let me tell you that this particular mediation ended up in an amicable solution. So this shows to you that the mediator should be flexible, as well as the mediation proceedings should be flexible as well. I have recently heard in an interview that a mediator should be agile in business, and this is perhaps what it should be. So agility and flexibility is the second dimension of remote mediation that allows you to do a lot, and the third dimension seems to be the most disputable, that is the question of communication and emotions. In business, we do realize that emotions can run high and have a meaning, even though they are very often implicit. Only after some time do they surface and affect the resolution of a dispute. But in this context, I would like to draw attention to two things. There are mediations where clients or the representatives of the parties, aware of the essence of the dispute, which differs from a conflict. I always make a distinction between conflict and dispute. I try to make clients and representatives aware of the dramatic differences between the two. The representatives who realize the difference feel that the online formula is not the best one. We do want to meet in person, we do want to communicate, and this is an opportunity for me to share with you a moment from a mediation proceeding from last year. I was told that a representative of the parties wanted to meet in person. There was a breakthrough moment where we also talked about money, but at the end of the day it turned out that the personal touch was also very crucial, and one of the representatives knew that this was really important. Such representatives are very, very crucial, are very important for us. They need to take into consideration the the personal aspect. And during this mediation proceeding, one of the representatives said, having his face mask on, I would like you to know that this is really sincere and that we really that you really want you to trust me and to see me. And he took off his mask, or he pulled down the face mask, and he said something which was very crucial to the essence of the dispute, and I'm certain that this wouldn't have worked had we proceeded online. And on the other hand, however, something that I have noticed, and this is something my clients have brought to my attention, when we meet online in those different windows using different platforms, in a way, our clients are less attentive to those emotional issues. I believe that this online meeting is itself conducive to a lot of white noise, and then maybe the clients want to cut the chase, want to simply move to the core of things. However, whether it does resolve the conflict very deeply is another issue. So these are the things I would like to say about mediation online. One other issue I would like to refer to concerning my experience is a spike in private or contractual mediations, and this is an evident tendency. This is something that stems from the fact that during the pandemic, people try to resolve their disputes, and they seek other tools to do it, because there was a time when the door was closed for mediation. Now we need to learn, we need to adjust to the mediation online. Recently, I was involved in proceedings where we met with representatives, and one of them joined the meeting a bit later, because he was still involved in another proceeding. So this is something that representatives might use as a chance, might embrace as a chance for their clients. This is a new tool that you can be using. And the third remark I would like to make is perhaps a disputable issue, a negative issue, the pandemic as an excuse for participating in a mediation proceeding. Some say that the situation is that I cannot propose anything, but also the pandemic as an excuse for amicable resolutions. Very often they use the pandemic as an excuse. I'm not really delivering a value judgment here, but I'm saying that this can often happen, that the parties use the pandemic as an excuse. And when you hear from clients that I cannot really be part to a mediation, or I cannot offer more than a given amount because the pandemic has made us really almost bankrupt. And the other issue I would like to address now, the second part of my presentation, as I was saying, is facts and figures. Statistics. I have looked into three kinds of mediation: some commercial mediation, labor law mediation cases. In a minute, you will see a graph, and you will be able to see for yourselves. Obviously, you can browse the website of the Ministry of Justice and find the relevant statistics. We can claim a 30% increase of cases referred to mediation by courts in labor law proceedings. This increase is really remarkable, is visible, and this is something I would like to stress. However, we do have fewer minutes of out-of-court mediations. In 2016, we had as many as 69 minutes from out-of-court mediations, from contractual mediations in labor law issues. In 2020, we only had 6 cases like that, so it's only 10% of what it used to be. So the figure is significant, and this is one of the tendencies I would like to draw your attention to. I know that I'm pressed for time, so I cannot really refer to all statistics. I would also like to refer to civil cases, and two tendencies that can be flagged here. One is, unfortunately, a clear decrease in the number of cases referred to mediation at the level of district courts. As for out-of-court mediations, the number of minutes filed, I do realize that there are many private mediations that do not end up in court because the parties do not want this, but out-of-court mediations, the number stays constant. We do see a decrease at the level of district courts, but we do see we do see a decrease in regional courts, but we do see an increase in district courts, in courts of lower instance, and this may indicate that courts think that smaller cases will be referred to mediation, and bigger cases are going to be tackled by the courts themselves. Well, is it the right direction? I do not know. This is something you can all decide upon. However, also the number of resolutions concluded, the number is at around of 25% of cases referred to courts with minutes. I believe that our statistics are a bit higher, and I'm talking here about our mediation office, mine and my partners, and obviously we need to consider the mediators themselves who conduct the proceedings. Many of the resolutions still need to be recognized by courts, and this, at the end of the day, is also in fact responsible for the fact whether the court will verify them. Well, 25% of the cases is not something we read on books. We read in books. Perhaps the stats are not complete, are not comprehensive, but this is what the statistics show. Our experience is a bit different, and commercial issues, economic issues, a very similar trend as in civil cases. In regional cases, we see a decrease in the number of mediation cases, but not as many as in civil cases. However, we have a 25% discontinuance of proceedings in court. However, in district cases, we have an increase in the number of cases referred to mediation. We also see a reverse tendency when it comes to matters assigned to district courses in contractual mediation. In out-of-court mediation, we have an increase in the number of minutes submitted at contractual mediation in regional courts. In district courts, it is a big decrease when we compare with the period 2012 or 13. Well, also we had different provisions, different law in place. So we do have a certain shift, we do have a certain change. How can we account for it? On the one hand, well, contractual mediation is also investment. This is also financial investment that representatives need to consider with the clients, and perhaps it is like that. This investment can be incurred by both clients and representatives only when they play for big money. However, when it is something smaller, the tendency is to have a court proceeding, and district courts refer cases to mediation. And so these are the things that are statistically significant for me. When you browse the statistics, you will find some other elements. And obviously, we would like to have more of these mediations, and we would like our clients to be more satisfied, and we simply want to have more disputes resolved. And this is something I wish to all of us here. I wish all the experiences, also the experience of last year, to teach us to be even more humanistic. And I do believe in that. And I think that as professionals, we might embrace a chance that is offered by the current situation so that our clients have a bigger portfolio of tools apart from arbitration, apart from court proceedings, also mediation proceedings. And I would like all of our clients to see a value in it. And this is something I wish to you and to myself. My best greetings from Poznań. Tomasz Antoszek, thank you so much. See you around.
Hello, my name is Angelina. I represent Belarusian office of Grata International. Today I propose to dive into Belarusian mediation. The topic of my presentation is mediation role in Belarus. Mediation in Belarus is developing in waves. During the pilot project 2011-2012, when judges had the right to refer parties to mediation, hundreds of mediations were conducted. Officially, mediation in Belarus began to operate in 2014, when the law of the Republic of Belarus on mediation came into force. After that, the judges began to indicate the lack of their right to refer the parties to mediation. Since the law on the mediation stipulates that the appeal to this procedure is voluntary, the court has the right only to recommend mediation to the parties. Accordingly, the number of mediations conducted on disputes in court has decreased to several dozen per year. The lack of support from the court has changed the strategy of promoting mediation in Belarus. Today, the strategy is as follows. Focus on developing out-of-court mediation and improving its quality. Introduction of mediation into economic circulation as a trial method of dispute resolution. A proposal to include mediation clauses in commercial contracts that oblige the parties to use mediation before the court. For the development and promotion of mediation in Belarus, a number of organizations have been created, aimed at ensuring that the population and the business community can have a clear idea of what mediation is, in what situations it is possible to use mediation, and what benefits can be obtained using mediation in conflict resolution. The first, Educational Practical Institution Center for Mediation and Negotiation. The second, Informational and Educational Resource about Mediation in Belarus. And the third, Informational Site Mediation Europe-Asia. Sphere of application of the law on mediation is the following. Mediation can be applied to civil disputes between individuals and legal entities, commercial disputes involving individuals and or legal entities, labor disputes, hereditary, housing, neighborhood disputes, and family disputes. Mediation can't be applied to disputes arising from public relations related to the protection of state and public interests, disputes arising from criminal and administrative relations. Mediator status. In Belarus, a mediator has the right to carry out mediation activity after receiving a mediator's certificate from the Ministry of Justice and including in the Register of Mediators. Certificate can be obtained by a person with higher education and who has completed a training course for mediators or who has experience as a judicial conciliator. The mediator has the status of an independent person, and he is also granted witness immunity in relation to information obtained in the mediation process. Agreement on the use of mediation. The agreement on the use of mediation is concluded in written form. An agreement is considered concluded if it is contained in a document signed by the parties, or concluded by exchanging messages using postal communication or other types of communication that provide a written record of the will of the parties, including the submission of a claim, suit and responses to them, in which one party is invited to settle the dispute through mediation and the other party agrees. A proposal to settle a dispute through mediation may be made at the request of one of the parties by the mediator. Parties of the agreement. It is maybe individuals with full legal capacity and or legal entities. The powers of the representative of the party to conclude an agreement must be specified in the power of attorney. Validity of the agreement is determined by the proper form of the agreement, as well as the presence in the agreement, subject of dispute, information about the mediator, the term and place of mediation, and the amount of the mediator's remuneration. Failure to comply with these requirements in form or content may serve as a basis for agreement's annulment. An agreement on the use of mediation is not an obstacle to applying to a court or arbitration, as long as appeal to the court doesn't mean that mediation cannot be applied. Mediation can be carried out both before the parties apply to the court in civil or commercial proceedings and after the initiation of proceedings in court. The mediation agreement must be made in writing. If mediation was conducted in a court dispute, the mediation agreement is not a final document. On its basis, the court draws up and approves a settlement agreement. For commercial dispute, it is possible to enforce mediation agreements. In Belarus, mediation begins after a written agreement concluded between the mediator and the disputing parties. Period. The mediation period may not exceed 6 months. The deadline starts from the date of signing the agreement on the use of mediation. Mediation in disputes before a court of general jurisdiction must take place within the time limit set by the court, but is also limited to 6 months. If an agreement is reached, the parties record it in the mediation agreement. Concerning execution, the law on mediation proceeds from the principle of voluntary execution of a mediation agreement. At the same time, for disputes under the jurisdiction of the commercial court, the possibility of compulsory enforcement of the mediation agreement is provided. In this case, two conditions must be met. The mediation agreement must be concluded with the participation of a mediator included in the state register of mediators, and the mediation agreement must meet the requirements of the procedural legislation for settlement agreements. Special features of the Belarusian mediation. In Belarus, facilitation mediation is established at the legislative level and is being developed. Mediation can be applied both out of the court and in disputes before the court. The norms of the Belarusian law do not establish cases of mandatory mediation or mandatory pretrial meetings with the mediator, except in cases where the parties provided a mediation clause in contract. The court doesn't have the right to send the parties to mediation on its own initiative. It only has the duty to explain to the parties their right to resolve the dispute in the mediation procedure. There is a possibility of enforcement of mediation agreements reached in the mediation procedure for commercial disputes, and there are benefits for paying the state fee. In particular, if the parties have resolved the dispute through mediation, 25% or 50% of the previously paid state fee will be refunded. There was an experience of mediation, remote mediation, by using Skype or using phone. Due to isolation, communication in Belarus was online, but this was not a total lockdown like in other countries. Therefore, mediation was carried out in person. Statistics for the period of March 2020 and January 2021 is 10% online mediation procedures. Were used such electronic platforms as Zoom and Microsoft Teams. Difficulties was connected with communication and paperwork due to electronic specifics. In general, the pandemic has not changed the status of mediation in Belarus, but it has definitely given impetus to the use of remote mediation and the search for approaches to develop an effective online mediation model. It was a pleasure to tell you about Belarusian mediation. Thank you for your attention. Goodbye.
Good morning, I am Jolanta Temura and I'm a mediator in the Mediation Center of the Association of Notaries Public of the Republic of Poland. I'm thankful to be able for the second time show to you a short video about emotions in online mediation. Last year I spoke about online mediation and procedures in online mediation worked out in our center. Were very helpful during the year, during the pandemic, and this is still ongoing. The parties do not want to meet in person because of health reasons, for health considerations, but also because of the emotions that very frequently run high in the mediation proceedings. Emotions, ladies and gentlemen, is a state of great agitation. They are short-lived, however, they stay with us for a long time. That's why we should not take decisions for a long term on the basis of fleeting emotions. In mediation, emotions are a great factor for the settlement between the parties. Very often, the settlement between the parties is not only working out the settlement provisions, but also to stifle emotions, which will later facilitate their mutual relations. Emotions in mediation come from three sides. From the parties to the mediation, from third parties, that is, friends and family members, and the emotions of the mediator, him or herself. We distinguish many emotions, negative and positive ones, but in mediation it is the latter that are predominant. Anger, indecision, sadness, or embarrassment. During mediation, most mediators have no doubt met examples, encountered examples where mediation has been marred by emotions, for example, by anger. I need to punish him or her because of their betrayal. I do not know what I should be doing myself. It's better that the tribunal make a decision. Very often, to stifle emotions in mediation proceedings is not possible. The parties are very much emotionally involved in the case, and that is why a proper emotion management can lead to a significant outcome of the mediation proceedings. The mediator can shift emotions or can redirect emotions from anger to indifference or can disarm emotions to de-escalate the conflict and then to stifle down emotions. Proper emotions management shows that emotions are not that important for the final outcome of the proceedings. On the other hand, we have emotions of third parties. Unfortunately, emotions of third parties are outside and beyond the mediator's will. On my part, I can say that very often the parties asked for a draft settlement and then they consulted it with third parties like friends and family members. Very often these third parties, playing on the emotions of the parties to the proceedings, influence the parties and they make negative decisions or they stick to their guns and they do not want to have a compromise. For example, he has betrayed you. How can you forget and forgive? The court will definitely assign you money. In this way, third parties influencing the mediations of the parties influence the final outcome. How about the mediations? How about the mediator's emotions? The mediator is to facilitate mediation and to help the parties to resolve the conflict. However, you need to realize that very often these are strange cases. Why do I say that? Very often they are surprising to the mediator. They are surprising, they are strange because of the words used, because of the storylines, and the mediator should always keep a poker face and manage the emotions not only of his or his own or his or her own, but also the emotions of the parties. In online mediation, we have a screen where you can see my face and my shoulders. Emotions are also expressed through body movements, the way our posture, the way we sit at a table is also important. In my case, I usually have mediation proceedings on WhatsApp, and still, even though we deal with professional platforms, we do not see the conduct of the parties, but can we really learn the emotions of the parties through the screen? Because emotions, ladies and gentlemen, is not only body language, but also the feelings that we directly experience. If we have the parties within a room, we can, as mediators, know whether the person is embarrassed, sad, angry, or livid. And we do not. The person does not really need to do much. We can sense the air. We can sense the emotions. This is impossible in online mediation. Each switch of mood, each swing of mood is visible on the face, but not always. Often in online mediation, the party that is dissatisfied with the proceedings disconnects and simply notifies the mediator that they have technical problems, and they say that the proceedings should be postponed until they have cooled down. Obviously, we have advantages and disadvantages of that. On the one hand, we cannot manage this emotion, we cannot release it, and this can ultimately lead to negative decisions. On the plus side, this can have a positive effect, because the party may cool down and then they make an informed decision. Another issue I would like to stress in online mediation is the fact that here we do not we don't have much impact on third parties that have, you may say, double the impact on the parties. Obviously, we need to be sure that when we have in-person mediation, then we know that we can guarantee the confidentiality of the proceedings in such a case. However, we cannot do that with online mediation. The parties to mediation often have their parents, their partners, new partners who want to impact what happens in mediation proceedings. So, for example, they want to influence the amount of, say, child support. They also want to influence the division of property. You are not guilty, why do you want to give all to the other party? Third parties to online mediation have a far greater influence than in-person mediation. when we met in person with the parties, the settlement was signed immediately on the spot. In online mediation, the settlement is read out, and then the mediator sends by email the settlement draft to the parties. What happens then? The parties reading the draft settlement consulted with third parties, and very often the settlement is not concluded because it is supposedly not beneficial for one party or the other. In mediation proceedings, you also need to take into account the emotions of the mediator. Very often, in in-person mediation, the mediator can often react to negative emotions. For example, if the parties to the conflict, to the dispute, cannot really stifle their emotions, the mediator tries to do that. This is something which we are deprived of in online mediation. Obviously, in online mediation, the parties are very reserved, very restrained, which does not happen in in-person mediation. In online mediation, I believe that certain things can be recorded, even though we have the confidentiality principle. They believe that the things they say can be used against them, and they do not want to show their true emotions, or they are very conservative with that. That's why I have adopted a practice where I have in online proceedings, I very often meet with both parties eye to eye. In-person mediation, I usually start the first sitting together. However, in online mediation, I want to allow the parties to show their emotions during the meeting with the mediator. They can focus only on the conversation with me as the mediator. They don't need to think about the other party. This is the way I have adopted to deal with emotions in online mediation. One other thing we need to know is that online mediation has its advantages when it comes to emotions. Very often in divorce issues, family issues, child support, we have the dominant party and the mentally weaker party. In online mediation is no doubt benefits those parties that are mentally weaker, because then can safely and in an unencumbered manner express their opinion. They feel more comfortable that the other person will not make them do anything, will not exert any pressure. I know that in in-person mediation, it is the mediator who must control that, but very often the meeting with the other party paralyzes the party. I have noticed that in online mediation, those people find it easier to express themselves freely. And if they are criticized, this is mediated through the screen. On the other hand, the dominant party can be in a way stifled by the mediator much easier. The dominant party is a charismatic person that may also impact the mediator in in-person mediation. In online proceedings, also the mediator feels comfortable that there is no impact of the dominant person. Dear ladies and gentlemen, emotions, both in direct and online mediation, have a major impact on the outcome of mediation proceedings. They are the key element that can help or hamper mediation. Very often, the success of mediation is contingent on how the emotions of the parties to the mediation are managed and how we explain to the parties that an emotional attitude to the proceedings will not guarantee a satisfactory resolution of the dispute. These emotions have to also be taken into consideration during training modalities. Very often emotions are not discussed during these meetings, and yet they are so very important. Thank you for your attention.
Hello? Halo? Teraz widzę pana mecenasa Nowaczyka, panią profesor z flagą. Też widzę, tradycyjnie, że widzimy się i słyszymy, to dobrze. Proszę Państwa, już teraz trzecia część naszej konferencji, dyskusja na tematy związane z arbitrażem i mediacją. Mam taką propozycję, żeby ten panel dyskusyjny podzielić też na głosy związane z arbitrażem i mediacją. Chciałbym poprosić o pana mecenasa Nowaczyka o uzupełnienie oraz ewentualne uwagi do szerokiego opracowania. Myśmy mailem panu Nowaczykowi przysłali uwagi, opinie od pani Tamary Patrycji Tomala. Ja jeszcze raz chciałem panu mecenasowi Nowaczykowi podziękować, bo dzięki niemu takie grono wybitnych specjalistów z arbitrażu i również mediacji się pojawiło. To, że w Nowym Tomyślu taka światowa w tej chwili konferencja zaistniała, to jest jego bardzo duża zasługa, za co mu chciałem serdecznie jeszcze raz podziękować. Jeśli można 2 słowa, panie mecenasie, odnośnie uwag obszernych i opinii pani Tomali, to bylibyśmy wdzięczni.
Nie wiem, czy jestem widzialny i czy jestem słyszalny, bo widzę pana Brycha, a nie widzę sam siebie.
Ja widzę i słyszę.
Wszystko jest w porządku.
Jest.
Lepiej, już lepiej, wszystko jest w porządku. Proszę państwa, wpłynęło do mnie sporo pytań, zarówno telefonicznie.
Pana mecenasa Nowaczyka, panią profesor z flagą. Też widzę tradycyjnie, że widzimy się i słyszymy, to dobrze.
Proszę wyłączyć YouTube.
Teraz trzecia część naszej konferencji. Dyskusja na temat związany z arbitrażem i mediacją.
się dzieje. Piotrze, prosimy, ażebyś wyłączył YouTube'a. Możesz wyłączyć?
Teraz lepiej. Prosić o pana mecenasa Nowaczyka o uzupełnienie oraz ewentualne uwagi do szerokiego opracowania przyszłym mailem panu Nowaczykowi przysłali uwagi, opinie o
Dobra, ale to co
i również
ma tego YouTube'a, czy co? No to trzeba zadzwonić.
Myślę, że to jest tak, że szanowni Państwo prelegenci, jeżeli ktoś z Państwa oprócz Teamsa ma jeszcze otwartą naszą konferencję po prostu na YouTubie, to prosimy, żeby Państwo zamknęli tą przeglądarkę tam, gdzie jest YouTube, bo inaczej na YouTubie jest odrobina opóźnienia w stosunku do Teamsów i stąd będziemy mieli małe problemy techniczne. Więc jeżeli chodzi o Państwa prelegentów, którzy będą odpowiadać na pytania, wystarczy, jak będą Państwo zalogowani na Teamsach. YouTube nie jest potrzebny i wtedy i tak wszyscy będą Państwa widzieć i będą Państwa słyszeć, a inaczej te głosy będą się nakładać na siebie, więc bardzo prosimy wszystkich prelegentów o wyłączenie YouTube'a, zostawienie tylko Teamsów.
telefonicznie pana mecenasa Nowaczyka, panie profesorze.
No co? Teraz. Czy słyszysz nas? Halo, panie mecenasie?
Czy teraz mnie słychać, panie prezesie?
Tak, słychać. Teraz doskonale.
Dobrze, to wyłączałem inne łącza. Dzień dobry Państwu ponownie. Nasza konferencja faktycznie ma... Słyszę pana Brycha.
Ja nic nie mówię. Panie mecenasie, musisz coś wyłączyć. O, teraz jakaś inna pani jest.
Mam wrażenie, że jestem teraz na jednym, jedynym łączu. Chyba, że pozwolicie, że to wyłączę.
Teraz dobrze.
Teraz dobrze?
Tak.
Okej. Proszę Państwa, konferencja nasza ma faktycznie zasięg światowy. Mamy gości od sultanatu Brunei na wyspie Borneo do San Francisco w Kalifornii. Mamy również lokalnych uczestników w Nowym Tomyślu i tego chciałem panu Brychowi serdecznie pogratulować, że mieszkańców swojego miasta zainteresował arbitrażem.
Państwo zalogowani na Teamsach, YouTube nie i wtedy i tak wszyscy będą Państwa widzieć i będą Państwa słyszeć, a inaczej te głosy będą się nakładać na siebie, więc bardzo prosimy wszystkich prelegentów o wyłączenie YouTube'a, zostawienie Teamsów.
Czy mogę mówić dalej? Czy mnie słychać? Zapytam.
Tak, słychać.
Panie prezesie Brych, czy pan mnie słyszy?
Tak,
Słyszymy pana,
Słyszymy.
tylko że jest cały czas problem nakładających się wcześniejszych wypowiedzi.
Dobrze, to wyłączamy.
Może od pani profesor.
I źródłem tego problemu jest pan prezes Nowaczyk, ponieważ jak jest wyciszony, to nie słychać tych opóźnionych reakcji.
Spróbujemy od pani profesor.
Czy ja jestem wyciszony?
Teraz dobrze.
No bo teraz pan prezes jest wyciszony, to jest dobrze, ale musi przemówić.
Pani dyrektor Małgorzaty Miszkin-Wojciechowskiej, taka sugestia, bo bardzo blisko pani mecenas ma kamerę i właściwie widzimy tylko oczy pani mecenas. Tak, absolutnie, tak, natomiast odrobinkę dalej, to wtedy będzie pani dyrektor bardziej widoczna dla nas wszystkich i jeszcze nie widzimy nawet całej twarzy. Jakieś odrobinkę obniżenie kamery. Nie, widzimy już prawie. I gdyby kamerka poszła odrobinę w dół, to wtedy byśmy widzieli panią dyrektor w całości. Tak to widzimy tak mniej więcej od górnej wargi.
Teraz już... Nie tu, tam chcemy tamtego. Panie mecenasie, czy już możemy prosić?
Ja bardzo chętnie. Potwierdźcie tylko, że mnie widzicie i słyszycie.
Ja was widzę i słyszę.
Dobra. Proszę Państwa, wstępnie muszę pogratulować panu prezesowi Brychowi, że że zebrał znakomitych prelegentów i to od sultanatu Brunei na wyspie Borneo do San Francisco w Kalifornii, ale również zainteresował swoich współmieszkańców, sąsiadów i mieszkańców Nowego Tomyśla. Dostałem bardzo ciekawego maila od pani Angeliki Marcinkowskiej z Nowego Tomyśla, która podzieliła się swoimi uwagami. Na ciekawą rzecz zwróciła uwagę, mianowicie na tło, na którym występuje. Pani Angelika zauważyła, że bardzo często mówcy dobierając sobie tło po to, żeby samemu się lepiej poczuć. To nasunęło mi tutaj pewne niedawne wspomnienie, kiedy miałem naradę z kolegami arbitrami. Jeden z nich wystąpił na tle szumiących palm na jakiejś plaży egzotycznej. Gdy zapytaliśmy go, gdzie ty jesteś, no powiedział, że na Karaibach. Później przyznał się, że żartował. A ja powiem szczerze, że to ja poczułem się bardzo niezręcznie w tym momencie, bo ja byłem wtedy na Karaibach. Ale żeby nikogo nie denerwować, to zdjąłem karaibską koszulę, ubrałem się w garnitur, pozasłaniałem wszystkie okna, żeby nie było widać żadnych palm, a w pokoju hotelowym pozapalałem wszystkie światła elektryczne, symulując, że jest wieczór taki sam jak tego dnia w Warszawie. Myślę, że mój kolega czuł się komfortowo i ja też czułem się komfortowo, chociaż każdy z nas urządził inną symulację. Osób, które do mnie napisały bądź telefonowały, mógłbym wymienić kilka bardzo ważnych osób w świecie arbitrażu i mediacji. Większość z nich stoi na stanowisku, że arbitraż online, czy też mediacja online jest czymś zastępczym wobec arbitrażu i mediacji tradycyjnej. Ktoś wyraził się, że jest to rodzaj protezy, którą musimy nosić przez ten czas pandemii i używać jej trochę wbrew naszej własnej woli. Pan mecenas Sylwester Pieskowski wyraził taką myśl, że chodzenie o kulach jest możliwe, ale jest smutne i żałosne. W tym kontekście chyba jednak większość środowiska arbitrażowego ma głęboką nadzieję, że kiedy ten cholerny wirus się skończy, wrócimy do normalnych sal rozpraw i narad. Honorowy przewodniczący Polskiego Stowarzyszenia Sądownictwa Polubownego twierdzi, że brak kontaktu wzrokowego, brak ściskania dłoni wręcz kastruje mediację i arbitraż z tego, co miał on do zaoferowania najważniejsze. Że w końcu rozprawy prowadzone przez przed ekranem na swój sposób sprowadzają się do jakichś deklaracji i sprawdzania numeracji faktów złożonych do. Mam również pewne sugestie napływające odnośnie sztucznej inteligencji. Czy sztuczna inteligencja jest w stanie wydać wyrok ex aequo ex bono, czyli na zasadach sztuczności? Pytanie to zadał Colin z Brunei, a odpowiedzi na to wyraźnie nie ma. Sztuczna inteligencja może zeskanować profil arbitra. To prawda, że jeżeli pozwolimy sztucznej inteligencji wejrzeć we wszystkie nasze dane, które znajdują się w sieci, przejrzeć nasze publikacje, wcześniejsze wyroki, wypowiedzi konferencyjne, takie jak na dzisiejszej konferencji, to zaletą miałoby być zbudowanie profilu kandydata na arbitra. Ale mam tutaj dwie wątpliwości. Pierwsza wątpliwość. To jesteśmy wszyscy ludzie. Ktoś zeskanuje nasze poglądy wyrażone w naszych dotychczasowych publikacjach. A co, jeżeli nasze poglądy uległy w międzyczasie zmianie i myślimy dzisiaj co innego, niż myśleliśmy i publikowaliśmy 10 lat. Druga moja wątpliwość bierze się stąd, że nie wiemy, do jakich granic może posunąć się sztuczna inteligencja. Jak głęboko może sięgać zbiory danych dotyczące kandydata na arbitra. Czeka nas teraz spis powszechny, w którym nasze państwo oczekuje, że będziemy ujawniać wszystkie szczegóły na temat naszego życia rodzinnego, osobistego, majątkowego i tak dalej. Jeżeli przez nieostrożność, przez jakiś błąd zabezpieczenia sztucznej inteligencji pozwolimy dowiedzieć się o nas za dużo, to ona może sięgnąć do naszych deklaracji podatkowych, do naszej dokumentacji lekarskiej, poznać nasze preferencje dietetyczne, krąg znajomych na Facebooku i tak dalej, i tak dalej. Pytanie, czy nie boimy się przekroczenia takich granic. Wreszcie bardzo ciekawą wypowiedź miała pani Weronika Pawłowska, nasza koleżanka z Białorusi, mówiąca tak pięknie po polsku. Przy okazji nasi goście zagraniczni mogą się przekonać, że język polski jest również znany poza Polską. Po polsku mówi również pan Nekrokius, język polski jest językiem międzynarodowym. Ale pani Pawłowska zwróciła uwagę na to, że robot nie może być arbitrem, że zarówno w prawie polskim, jak i białoruskim powiedziane jest, że arbitrem może być tylko osoba fizyczna. No i wyobraźmy sobie teraz, że w większości państw na świecie regulacje są takie same. Ale różne państwa, różne kraje, różne terytoria gonią za tym, aby stać się dla arbitrażu atrakcyjne. Wystarczy zmiana przepisów w jednym z państw, które uchyli taki przepis, że tylko osoba fizyczna może być arbitrem, a już takie państewko czy terytorium może stać się bardzo atrakcyjnym miejscem rozstrzygania sporów przez robotów. Państwa konkurują ze sobą pod względem atrakcyjności. Ci z nas, którzy pamiętają rok 2000 albo nadejście nowego stulecia, pamiętają zapewne wyścig, jak tutaj najatrakcyjniej spędzić Sylwestra 2000. A najciekawszym Sylwestrem na świecie ponoć jest Sylwester w Sydney pod mostem wokół sławnej opery. Ale w momencie, kiedy zbliżał się rok 2000, po to, aby przyciągnąć turystów, różne malutkie państewka w archipelagu wysp położonych na oceanie spokojnie zaczęły ustawowo zmieniać swoją sferę czasową. Tylko po to, aby być pierwsze, które powitają nadejście nowego tysiąclecia. I tak konkurowali ze sobą prezydenci archipelagu Tonga, archipelagu Tuwalu, żeby przyjąć datę nadejścia XXI wieku jako pierwszy. Jeżeli będziemy dłużej mówić o tym, że tylko osoba fizyczna może być arbitrem, to obawiam się, że prowokujemy zmianę przepisu w jakimś kraju, który pozwoli na zrobotyzowanie arbitrażu. Żeby nie być za bardzo abstrakcyjnym, przytoczę przykład Mary. Mary to robot w kształcie kobiety, który przypomina kobietę pod każdym względem. Ma twarz, która może wywołać aż 80 najrozmaitszych grymasów. Mówi różnymi językami, zaprogramowany jest wszechstronnie i kiedy w Wiedniu w czasie wiedeńskich dni arbitrażowych zaprezentowano, co Mary potrafi, na sali zapadła cisza i większość z nas wręcz osypiała, widząc autentyczne zagrożenie dla nas ze strony robota. No ale wówczas jedna z koleżanek, może nawet jedna z najmłodszych, podniosła ciekawą kwestię. Przecież obywatel, przecież arbiter musi mieć narodowość, musi mieć jakieś obywatelstwo. Bez tego trudno go w ogóle zaangażować. No i co się stało? Nie uwierzycie. Król Arabii Saudyjskiej, albo któryś z jego ministrów, nadał robotowi Mary obywatelstwo Arabii Saudyjskiej. Jeżeli w tym kraju, mówię o Arabii, ktoś zmieni jeden jedyny przepis, wykreśli dwa słowa z przepisu, który mówi, że arbitrem może być tylko osoba fizyczna, doczekamy się robotyzacji arbitrażu. Ale proszę Państwa, to są znowu projekcje, które wynikają z naszych błędów, z naszych nawyków myślenia o przyszłości jako o potęgowanej rzeczywistości. A przyszłość może być zupełnie inna. I skoro moją rolą jest prowokować do dyskusji, to powiem tak. Możemy sobie wyobrazić, że nastąpi jakieś wydarzenie kosmiczne, że uruchomi się szyszynka w naszym mózgu, o której nic nie wiemy, do czego ona w ogóle służy. Mamy ponad 80% starych komórek, które nie wiadomo, co tak naprawdę robią, bo są pewnie śpione. Ale gdyby je ożywić, to moglibyśmy na przykład wypracować pozazmysłowe sposoby komunikowania się, porozumiewać się telepatią, a być może wydając wyroki skierować się bardziej intuicją. Jeżeli tak się kiedyś stanie, to obiecuję, że nowy tomik będzie pierwszy, który zrobi na ten temat konferencję.
Dziękuję panie mecenasie. Trochę było problemów technicznych, ale sądzę, że większość rzeczy zrozumieliśmy i było słyszane. Dziękuję za dobre słowa dla nowego tomyśla. Ja obiecuję, jeżeli wszystko będzie dobrze, w sensie zdrowotnym i innym, to na pewno ta tradycja będzie utrzymana. Chciałem panią profesor Flagę ze Szczecina poprosić o uzupełnienie ewentualnie wypowiedzi pana mecenasa Nowaczyka. Ja też pozwoliłem sobie do pani mailowo przesłać pytanie odnośnie właśnie tematyki sztucznej inteligencji. Gdyby pani profesor była uprzejma i może uzupełniła, ale swój pogląd na ten temat wyraziła, byłem bardzo wdzięczny. Dziękuję też pani profesor za to, że pomaga nam też w organizacji konferencji, nie tylko ze Szczecina, ale pomaga z Litwy, za co jestem bardzo wdzięczny.
Dziękuję serdecznie, dziękuję bardzo za zaproszenie, już nie wiem nawet które zaproszenie do Nowego Tomyśla. Niestety w tej sytuacji nie mogliśmy przyjechać, a bardzo żałuję. Szanowni Państwo, trochę się zgadzam z panem mecenasem, a trochę nie. Dlatego, że owszem, nie możemy bezkrytycznie podchodzić do sztucznej inteligencji, dlatego że jest ona tyle warta, ile uczyni dla niej człowiek, więc chociażby odnosząc się do tej wypowiedzi pana mecenasa odnoszącej się do tworzenia profilu arbitra, tak naprawdę kluczem jest nakarmienie sztucznej inteligencji wiedzą i faktycznie jeżeli będzie tak, że będziemy aktualizować maksymalnie wiadomości o tym, kim jest arbiter i jakie poglądy wyraża, to ten profil będzie odpowiednio aktualny i będzie wartościowy. Natomiast jeżeli tego zaniechamy, to sztuczna inteligencja niekarmiona wiedzą jest kompletnie bezużyteczna. Natomiast nie możemy w żaden sposób mówić, że trzeba jej wierzyć bezgranicznie, dlatego że sztuczna inteligencja ma ten problem, że doskonale sobie radzi z niezliczoną ilością informacji, natomiast nie ma rozwiniętego tego, co potrafi dwulatek, czyli tej inteligencji emocjonalnej, czy też sposobu poruszania się. I tutaj też nawiązując do wypowiedzi pana mecenasa, to prawda, że sztuczna inteligencja największe problemy ma z mimiką i nie tylko z własną mimiką. Badania pokazują, że wyraz twarzy, który pokazujemy, nie jest wystarczający do tego, żebyśmy mogli zdefiniować, osoba trzecia mogła zdefiniować, co czujemy, bo przecież płaczemy z radości, płaczemy z bólu, płaczemy z bezsilności, ze złości, a sztuczna inteligencja, nawet ubrana w skórę pięknej dziewczyny, widzi tylko, że płaczemy. I to powoduje, że zwłaszcza gdybyśmy na obecnym etapie rozwoju sztucznej inteligencji próbowali uczynić z niej mediatora, to z pewnością nie byłaby ona wartościowym partnerem dla stron w zakresie odczytywania ich emocji, podejścia do sprawy. Natomiast padło do mnie pytanie, czy sztuczna inteligencja może być sędzią. Proszę Państwa, to zależy. Dlatego, że z jednej strony mamy badania przeprowadzone na doświadczeniach sądów państwowych, między innymi w Stanach Zjednoczonych był prowadzony taki projekt odnoszący się do wieloletniego orzecznictwa Sądu Najwyższego i okazało się, że sztuczna inteligencja ma wyższą trafność przewidywania tych orzeczeń, które już zapadły, na przykład w porównaniu z panelem wybitnych prawników, ale ludzi. Z drugiej strony mamy doświadczenia z Europejskiego Trybunału Praw Człowieka, gdzie też wybrano w ramach projektu jakiś tam czas i liczbę orzeczeń i okazało się, że sztuczna inteligencja była w stanie przewidzieć orzeczenia na poziomie, z tego co pamiętam, chyba 74%, w każdym razie gdzieś tam między 70 a 80%. I powstaje podstawowe pytanie, czy to, że nie miała 100% trafień, to oznacza, że ludzie zawiedli, a ona wskazała prawidłowe rozstrzygnięcia? Nie, bo powstaje też druga możliwość, że ona po prostu nie potrafiła wychwycić niuansów, które potrafi wychwycić człowiek, odnosząc się do chociażby pobudek działania strony, stopnia zawinienia itd., itd. Czyli to nie jest tak, że sztuczna inteligencja jest idealna. Ale z drugiej strony, proszę Państwa, są kategorie spraw, w których sztuczna inteligencja dałaby sobie doskonale radę. Jak popatrzymy na nasze polskie elektroniczne postępowanie upominawcze, w pewnym momencie rozwoju tej procedury były prowadzone badania, ile czasu poświęca na decyzję sędzia czy też referendarz sądowy w tym postępowaniu i okazało się, że w szczytowym momencie powodzenia tego postępowania wydanie nakazu zapłaty zajmuje od 2 do 5 minut. Czy ten sędzia zagłębia się w stan faktyczny? Nie, ponieważ są to standardowe, powtarzalne, stosunkowo proste w warstwie faktycznej rozstrzygnięcia. Ale możemy to stosować, proszę Państwa, tylko wtedy, kiedy będzie tak jak w elektronicznym postępowaniu upominawczym, że jednozdaniowy sprzeciw strony spowoduje, że takie orzeczenie zniknie z obrotu prawnego. Czyli każdy, czyich praw i obowiązków będzie dotyczyło to orzeczenie, będzie mógł je zakwestionować. I to jest w zasadzie taki obszar, w którym można by było bezpiecznie mówić, że sztuczna inteligencja może być sędzią, choć sędzią z bardzo ograniczonymi możliwościami, w sytuacjach prostych, rozliczeniowych, w takich, gdzie człowiek staje się de facto kalkulatorem, gdzie analizuje schematyczne dokumenty i gdzie bardzo łatwo jest usunąć takie orzeczenie z systemu prawnego. Więc tak jak powiedziałam, sztuczna inteligencja tak, ale pod kontrolą człowieka i bardzo uważnie wprowadzana, dlatego że niestety zachwyt czasami nowoczesnymi technologiami powoduje, że nie dostrzegamy tego, że jednak my jesteśmy istotą najbardziej skomplikowaną, a przy tym ciągle jeszcze myślę, że najmądrzejszą, zwłaszcza w sferze emocji. Dziękuję bardzo.
Dziękuję bardzo za ciekawą wypowiedź i uzupełnienie do wypowiedzi pana mecenasa Nowaczyka. Kolejna problematyka, która zainteresowała naszych uczestników, to temat, który podejmuje pan Michał Wiśniowski. Nie, to jest do pana Antoszka, przepraszam, to nie mój. Ewentualnie przechowywania wyroków wydanych online. Arbitraż to mamy w ogóle problem z przechowywania w materialnej postaci wyroków, ich archiwizowania. Natomiast
pytanie brzmi, to jest od pani mecenas Beaty Kozakowskiej-Burdzińskiej i pytanie jest kierowane do pani doktor Joanny Kisielińskiej-Garncarek. Czy pani doktor jest z nami? Znaczy, jeżeli nie, to byśmy prosili panelistów z tego panelu arbitrażowego o odpowiedź albo państwa sugestie. Pytanie brzmi, co z przechowywaniem wyroków arbitrażowych, które zostały wydane online? W jaki sposób je przechowywać?
No to jest zagadnienie i prawnicze, i bardziej już informatyczne. Ja nie potrafię, nie mam wyobraźni informatycznej, żeby do tego się odnieść. Sądzę, że temat jest bardzo ciekawy i w praktyce on musi być jakiś rozwiązany.
Jest pani wyciszona.
Łapka za mała. Jeżeli mogę pomóc, to chciałam zwrócić uwagę na to, że przechowywanie wyroków wydawanych online, ale w ogóle nawet dokumentacji zdigitalizowanej jest zdecydowanie łatwiejsze niż formy papierowej. Natomiast co jest ciekawe, to jednym z problemów w warstwie wykonywania orzeczeń sądów i państwowych, i sądów polubownych w drodze przymusu państwowego jest problem fałszowania ich na etapie tytułu egzekucyjnego, czy idąc dalej na etapie tytułu wykonawczego. I wydaje się, że takim ciekawym atutem elektronizacji postępowania arbitrażowego, ale też ugód zawieranych przed mediatorami, to jest stosowanie tak zwanej technologii blockchain, czyli rozproszonej sieci, która pozwala po pierwsze zabezpieczyć wyroki przed ewentualną modyfikacją, ponieważ na przykład, mówiąc w uproszczeniu, kilka sądów arbitrażowych może sobie stworzyć taką sieć i nawzajem na swoich serwerach przechowywać te orzeczenia, przy czym nie mając do nich dostępu, tak? Czyli na przykład jeżeli jest to orzeczenie sądu A, to sąd B widzi to orzeczenie w formie nic nieznaczących ciągów znaków i to powoduje, że nie ma możliwości modyfikowania tego typu orzeczeń, a poza tym można stworzyć katalog podmiotów, które będą miały dostęp do takiego orzeczenia i na przykład jeżeli komornik sądowy otrzymawszy taki tytuł będzie miał wątpliwość, czy on w ogóle funkcjonuje w obrocie, albo też czy powinien funkcjonować w takiej treści, w jakiej jest, mógłby otrzymać dostęp do takiego orzeczenia na określonych zasadach technicznych i on widzi, że to orzeczenie rzeczywiście istnieje, więc to jest ogromny obszar zastosowania technologii blockchain, która została wypracowana na gruncie walut wirtualnych, ale coraz częściej mówi się o tym, że ta technologia ma doskonałe zastosowanie w odniesieniu do wszystkich rejestrów, które są wielopodmiotowe, tak jak na przykład również kwestie notariatu, a które borykają się albo z fałszowaniem dokumentacji, tudzież jej przerabianiem co do zawartości. Także myślę, że to jest tylko i wyłącznie plus, ta forma elektroniczna, czy też prawidłowo powinniśmy powiedzieć postać elektroniczna, bo tu mogą być również dokumenty zdigitalizowane, które w pierwotnej formie miały formę pisemną. To jest jutro, z którym będziemy się musieli zmierzyć, bo w końcu nam archiwów na papier zabraknie. Dziękuję bardzo.
Dziękuję. Proszę Państwa, mamy też pytania do występujących z Singapuru i pani z San Francisco. My z racji różnic czasowych nie możemy z nimi się połączyć. Natomiast te osoby, które zadały pytania, dostarczymy drogą mailową do tych występujących i poprosimy o ewentualnie ustosunkowanie się mailowo, natomiast my pocztą też mailową roześlemy odpowiedzi. A что в Украине? Кто-то не будет есть или нет już? Kogo nie? Są też pytania do Ukrainy, wobec tego do pani wiceprezes Sądu Arbitrażowego przy Izbie Przemysłowo-Handlowej w Kijowie. Prześlemy z załączeniami, co też również zdrowia dla pana prezesa Sądu Arbitrażowego, który mam nadzieję jest już zdrowy i nabiera sił. I inna gdzie wy? Ja nie widzę. Здравствуйте, Инна. Вы слышите? Ничего не слышит. Ja wижу, nie słyszę. Niestety nie widzę, ani nie słyszę. Proszę Państwa, także te pytania dla tych zagranicznych prelegentów wyślemy mailem. Mam nadzieję, że Ukraina wróci, a Moskwa jest. Здравствуйте, Москва. Ты слышишь? Ничего не слышит. Dobra, no wobec tego bardzo dziękuję. Gdy jeszcze pytania ze strony Państwa się pojawią w trakcie kolejnej serii pytań, ale już dotyczących mediacji, to jesteśmy do dyspozycji. Cały czas mamy stronę internetową do dyspozycji, no i drogą mailową też również możemy się kontaktować. Bardzo proszę, panie mecenasie, oddaję głos.
Bardzo dziękuję. Jeszcze mamy parę pytań związanych z tą częścią mediacyjną. Niektóre są adresowane do konkretnych prelegentów, natomiast są też takie pytania czy komentarze adresowane ogólnie do wszystkich, więc wtedy ja będę prosił Państwa, żeby się Państwo zgłosili albo ewentualnie gdzieś tam będę sugerował kto potencjalnego odpowiadającego na to pytanie. Pozwolę też sobie na jakieś swoje komentarze. Moderator to taka niewdzięczna rola, gdzie bardzo chcę coś powiedzieć, a jednak mam ograniczone możliwości, więc odrobinę. Chce Pan jeszcze tak? Dobrze, natomiast tutaj, że tak powiem, takim naturalnym mostem pomiędzy tymi dwoma tematami, czyli arbitrażem i mediacją jest pan mecenas Nowaczyk, który zahaczał również w swoim wystąpieniu o kwestie mediacyjne i ten komentarz taki długi, który się pojawił, który pan mecenas dostał, też zahacza o kwestię mediacyjną i może ja pozwolę sobie na jeden bardzo krótki komentarz, może taki wprowadzający również do dalszych pytań do naszych już prelegentów. Jest taki, że ja mam taką serdeczną prośbę i również postulat, żeby tej mediacji online nie demonizować. To znaczy, żeby po pierwsze się jej aż tak bardzo nie bać. Myślę, że również i pani sędzia potwierdzi, że te rozprawy odmiejscowione to też nie jest takie wielkie zło i to wszystko jest możliwe do zrobienia i podobnie z mediacją online. Tutaj na przykład pojawiło się takie zdanie w tym komentarzu, że to nigdy nie zastąpi tradycyjnych spotkań. Ja myślę, że to też jest odrobinę krótkowzroczne patrzenie, ponieważ były już takie sprawy mediacyjne na daleko przed samą pandemią, gdzie ze względu na przykład na odległość pomiędzy stronami, strony się nie spotykały. Była wykorzystywana technologia, było wykorzystywane te spotkania na platformach internetowych i jest to jak najbardziej możliwe. Natomiast przechodząc w zasadzie, proszę Państwa, już do pierwszego z pytań, tylko proszę, pierwsze z pytań, do którego pan doktor Antoszek już po części odpowiedział na czacie na YouTubie. Tam były w zasadzie dwa pytania związane z statystykami i pierwsze z nich to jest jaki wpływ pandemia COVID miała na mediacje sądowe. I czy istnieją dane, ile w czasie pandemii sądy skierowały spraw do mediacji? I tutaj niestety jest tylko z wyrazami szacunku, ale nie mamy podpisu, kto zadał. I drugie jest podobne pytanie, czy dysponuje pan danymi na temat tego, jakie są statystyki co do mediacji na etapie przedsądowym tym razem i jaki odsetek tego typu mediacji kończy się zawarciem ugody? Jaki wpływ na statystyki w wyżej wymienionym zakresie miała pandemia w 2022 roku? I tym razem już mamy podpisane panią mecenas Ewę Leśnikowską. Panie doktorze, bardzo prosimy, oddaję głos.
Dzień dobry Państwu. Czy mnie widać i słychać, tak? Kłaniam się. Ja przepraszam, ja już trochę w takich domowych warunkach. Piątek jest takim świętym dniem, gdzie spędzam je z dziećmi, więc formuła nagranego wystąpienia bardzo mi odpowiadała, ale udało mi się w ostatnim momencie do Państwa teraz dołączyć. Ja tak naprawdę nie wiem, czy jest w tej chwili celowe odpowiadanie na to pytanie, bo ja je omówiłem w tym moim wystąpieniu, takie mam wrażenie, te kwestie, które są tutaj poruszone. No i jeszcze raz chyba podkreślę, że jest ciekawą, acz myślę, że niepokojącą tendencją ten spadek liczby mediacji w sądach okręgowych, jeśli chodzi o statystyki, które są dostępne na stronach Ministerstwa Sprawiedliwości. Natomiast jest wzrost w sądach rejonowych i to może być, myślę, że trochę związane z tym, o czym ty, Cezary, w swoim wystąpieniu mówiłeś, to znaczy o tym, że istotne jest uświadamianie klientom, że mediacja jest narzędziem tak samo celnym, oczywiście w zależności od przedmiotu sporu, od stron, w niedużych sprawach, czyli w sprawach, w których wartość przedmiotu sporu jest nieduża, oraz w tych, które właśnie są kierowane do sądu okręgowego. Ja już pomijam kwestię, że często te sprawy, które z sądu okręgowego są kierowane do mediacji, to jest sprawa na przykład o naruszenie dóbr osobistych, czy związana ze sprawami autorskimi, gdzie tak naprawdę ta wartość przedmiotu sporu jest bardzo niska albo żadna, bo jest to sprawa na przykład o ustalenie albo o zaniechanie naruszenia, a potem w mediacji oczywiście okazuje się, że poszerzamy ten zakres przedmiotu sporu o kwestie znacząco inne i szersze. No i wtedy rozmawiamy o czymś zupełnie innym, ale ta tendencja tutaj wydaje mi się, że jest gdzieś tam widoczna i to chciałem podkreślić. No, omawiałem też to, jaka jest skuteczność na poziomie tych statystyk, około 25%, co jest dosyć małym procentem, tak bym odpowiedział. I chyba na teraz tyle z mojej strony. Jeżeli wyczerpałem, a jeżeli pan moderator uzna, panie Cezary, drogi, że jeszcze coś powinien powiedzieć, to oczywiście proszę śmiało.
Ja może
dalej.
tylko dopowiem, panie Tomaszu drogi, to co jest pana doktora na YouTubie, że wszelkie te statystyki są na stronie Ministerstwa Sprawiedliwości. Ich nie wiem, czy już są za 2020 rok, chyba już są. Więc przynajmniej w zakresie mediacji sądowych one są statystykami oficjalnymi i dostępnymi w zasadzie dla wszystkich na stronie Ministerstwa Sprawiedliwości. Tomku, jesteś wyciszony.
Teraz mnie słychać? Tak. One są również dostępne odnośnie tych pozasądowych mediacji, ale wyłącznie co do protokołów, które zostały złożone do sądu, bo w tej chwili już nie ma obowiązku składania protokołu, który kiedyś też nie był wykonywany przez mediatorów, tak sądzę, ale w tej chwili to są tylko te mediacje, gdzie protokół został złożony. Zakładam i wierzę w to, że jest też gro mediacji, które się kończą ugodą, ale gdzie strony nie mają tej potrzeby, aby przedkładać ją do sądu, ponieważ ugoda jest albo wykonana możliwie szybko, albo po prostu no, strony na tyle sobie ufają, że na danym etapie nie przedkładają protokołu wraz z ugodą do sądu, więc pewnie to będzie się wymykało tym statystykom.
Super, bardzo dziękuję i widzimy, że pani Olimpia Barańska od razu. Bardzo proszę.
Dziękuję bardzo. Dzień dobry. Witam Państwa
Dzień dobry.
serdecznie. Hello, привет. Witam Was, słuchajcie, z samochodu, bo dojechałam już na mój weekend wypoczynkowy z nad jeziora, więc dzięki całej technologii możemy również w ten sposób się komunikować. Ja bym chciała tutaj dodać co do tych statystyk, danych statystycznych, rok 2020 w sądach był absolutnie rokiem zaburzonym. Jedyne, co możemy stwierdzić, to co powtarzają sędziowie i pełnomocnicy również występujący w sądach, że wzrosła liczba spraw rodzinnych, to znaczy alimenty, opieka, wzrosły też rozwody w sądach okręgowych, a także wzrosły sprawy, gdzie jest przemoc. I teraz jeżeli mówimy o tych ugodach sądowych, to w normalnych warunkach, jeżeli ludzie mają możliwość rozmawiania, tak, no to oczywiście oni idą w czasie tego rozwodu również na postępowania mediacyjne na przykład. Natomiast w tej chwili, jeżeli to się łączy też ze wzrostem przemocy, aczkolwiek to musi być naprawdę jeszcze porządnie zbadane, niestety po fakcie, tak, ale takie sygnały odbieram, chociażby dzisiaj, że dużo tych spraw, jeżeli chodzi o opiekę nad dzieckiem, wyprowadzenie się, czy te wszelkie wstępne ustalenia przed rozwodem, które obejmują również opiekę nad dzieckiem, one faktycznie zaczęły lądować w mediacji i zarówno w sądach rejonowych, bo ludziom zależy na czasie, ale też w tych ugodach pozasądowych, w postępowaniach mediacyjnych, ale poza sądem. Natomiast jeżeli już dochodzi do kwestii rozwodu, tam ludzie po prostu przestają rozmawiać, bo niestety zdaje się na dzień dzisiejszy, tak, z tych informacji od pełnomocników, mediatorów, sędziów i również psychologów, wychodzi na to, że przemoc wzrosła o kilkadziesiąt procent. Natomiast to będzie na pewno bardzo, no, ja nie chcę powiedzieć ciekawy, tak, ale to będzie temat i jest już temat do badania, natomiast co do wniosków, no to wszystko przed nami. Niestety. Dzisiaj spotkałam mediatorkę rano w pracy, która właśnie mówi, że ma masę spraw rodzinnych przede wszystkim, pozasądowych. Ludzie zamiast do sądu idą do mediacji i to jest kwestia mieszkania i opieki nad dziećmi. Natomiast decydują się na złożenie pozwu rozwodowego i tam już są przygotowani na walkę. I może dlatego tutaj odwraca się ta proporcja. Witam serdecznie, Panie Tomaszu.
Witam. Pozdrowienia dla Gorzowa, dla wszystkich mediatorów utytułowanych nagrodami.
Super, bardzo, bardzo dziękuję. To może ja, żeby troszeczkę zrównoważyć, też powiem na gruncie małopolskim, akurat statystyki musiałbym powiedzieć, że są bardzo dobre. To znaczy ilość spraw kierowanych do mediacji, ja jeszcze nie mam tych statystyk oficjalnych, ale zarówno w sądzie okręgowym, jak i w sądzie, mogę powiedzieć o sobie, tak, bo mogę powiedzieć, że rzeczywiście ja bym powiedział, że ilość spraw kierowanych do mediacji z sądu okręgowego i rejonowego i to ja przede wszystkim dostaję sprawy gospodarcze z wydziałów gospodarczych, ale rodzinne też zacząłem dostawać w pandemii. Po sobie bym powiedział, że to wzrosło 4-krotnie. Albo nawet może 5-krotnie, w zależności od miesiąca. I rzeczywiście łącznie z tym, że z sądu były telefony, czy rzeczywiście my robimy te mediacje online. Znaczy my, mówię, Centrum Mediacji przy Naczelnej Radzie Adwokackiej, bo to była część takiego dużego projektu ogólnopolskiego, gdzie my wysyłaliśmy taką propozycję i prośbę do sądów, żeby kierowały sprawy i strony do mediacji, te strony, które oczekują na wyznaczenie terminu rozprawy, żeby spróbować troszeczkę to rozładować i wykorzystać mediację online i rzeczywiście odzew był bardzo duży. Więc taki nawet przerastający nasze oczekiwania. Ja mogę powiedzieć o sobie, ale wiemy też w Płocku, że na pewno się zdecydowanie tam zwiększyła ilość mediacji. Wiemy o Białymstoku, wiemy o Gdańsku. To są takie może pojedyncze, nie prowadzimy oficjalnych statystyk, bo niestety mediacja ma trochę problem ze statystyką, bo mimo wszystko, zwłaszcza ta mediacja pozasądowa jest poufna i czasami, o ile rzeczywiście, tak jak Tomek powiedział, nie trafi protokół do sądu i wtedy zostanie ujęty w tych statystykach już oficjalnych, no to ze względu na poufność po prostu my nie wiemy, ile jest mediacji prywatnych, bo wiedzieć nie możemy. Więc stąd też te mediacje Nigdy te statystyki nie będą w pełni oddawały prawdziwego obrazu mediacji, bo nie wszystko jesteśmy w stanie w nich ująć. I tak płynnie przechodząc do kolejnego pytania, ja może zrobię tak, że mam jeszcze jedno pytanie, które jest kierowane do konkretnego panelisty, a później już są pytania ogólne, więc wtedy będę Państwa prosił o zgłaszanie się po prostu, jeżeli ktoś z Państwa będzie chciał odpowiedzieć. Tym razem jest to pytanie do pani sędzi Moniki Włodarczyk. Pani doktor, dzień dobry, gratuluję wystąpienia, jak zwykle bardzo wartościowego. I pani sędzio, pytanie brzmi, czy kwestionariusz, czy mediacja jest dla mnie, jest gdzieś dostępny? To bardzo ciekawe narzędzie, z którego chciałabym skorzystać. To jest pani Anna Wołowiec, ja przeczytałem dosłownie oczywiście, więc może zarówno pierwszą, jak i drugą część tej wypowiedzi bardzo byśmy prosili panią sędzię o komentarz.
Jako polska sekcja Europejskiego Stowarzyszenia Sędziów na Rzecz Mediacji opracowaliśmy zarówno wzór listu sędziego do stron, do pełnomocników i kwestionariusz. Te dokumenty zostały opracowane na bazie takich samych dokumentów opracowanych w ramach projektu, któremu patronowało ŻEM w 2014 roku. Ponieważ nie mamy aktualnie swojej strony internetowej polskiej sekcji i walczymy cały czas, żeby ją mieć, pracujemy nad tym, więc zostały one umieszczone na stronie internetowej Sądu Rejonowego w Chrzanowie, gdzie ja orzekam, w zakładce mediacja. Zostały rozesłane do koordynatorów do spraw mediacji w całej Polsce i z prośbą, mam nadzieję, że rozesłane również do sędziów i również wysłałam je do Państwa organizatorów konferencji, jeżeli byłaby taka możliwość ewentualnie udostępnienia na stronie internetowej konferencji albo rozesłania do panelistów. Ale na tą chwilę najpewniejsze źródło to jest strona Sądu Rejonowego w Chrzanowie, zakładka mediacje. I tam znajduje się właśnie list zarówno sędziego do stron, do pełnomocników i ten kwestionariusz. I chciałam serdecznie zachęcić przede wszystkim tutaj sędziów, jeżeli są i nas słuchają, do korzystania z tych listów i z tego kwestionariusza. A ten kwestionariusz dodatkowo mógłby być takim narzędziem do pracy pełnomocników procesowych ze stroną, jak i również do omawiania na spotkaniach informacyjnych mediatora ze stronami. I ten kwestionariusz, ponieważ na przykład w Szkocji są prowadzone teraz badania nad zmianą prawa mediacyjnego i tam ten kwestionariusz, oni wprowadzają właśnie obligatoryjne posiedzenia wstępne o mediacji i pomysł jest taki, że ten kwestionariusz miałby być wykorzystywany na tym spotkaniu informacyjnym i być po prostu takim zalążkiem do rozmowy na temat różnic pomiędzy mediacją i postępowaniem sądowym. Na takie spotkanie informacyjne strona przychodzi z wypełnionym już formularzem i wówczas mediator może pomóc zanalizować, dlaczego pan odpowiedział tak, nie wiem. Także bardzo serdecznie zachęcam do pobrania tych dokumentów ze strony na razie Sądu Rejonowego w Chrzanowie. Mam nadzieję, że koordynatorzy do spraw mediacji również roześlą do poszczególnych sędziów te wzory i listy. Także to jeżeli chodzi o to pytanie. Czy jeszcze zawierało ono jakąś dalszą część i nie usłyszałam, czy...
Myślę, że pani sędzia tak dokładnie odpowiedziała na to pytanie. Ta pierwsza część, gdzie jest dostępny, jak i później, że to bardzo ciekawe narzędzie i pani sędzia dokładnie je opisała. Myślę, że wyczerpała pani w całości, chyba że chce pani oczywiście jeszcze coś dopowiedzieć.
Jeżeli tylko chcę dodać, że właśnie te listy, no bo to nie jest pomysł polskiej sekcji, tylko to jest wykorzystywane i tak jak wszędzie mówię, dokumenty zostaliśmy zainspirowani tym, co dzieje się w innych państwach Unii Europejskiej, także one są wykorzystywane w innych państwach Unii Europejskiej i naprawdę służą takiemu bardziej czytelnym i bardziej jasnym informacjom o mediacji, no a też pokazują, bo w tych listach jest to zdanie, że my jako sędziowie popieramy mediację, a to chyba jest najważniejsze w całej idei promocji mediacji, że teraz do głosu powinni dojść w Polsce sędziowie i oni powinni wypromować tą mediację, bo państwo jako mediatorzy świetnie wypromowaliście mediację i wszystko o niej świetnie wiecie, a teraz chyba przed nami jest bardzo trudne zadanie, żeby do tej mediacji przekonać sędziów i żeby oni publicznie popierali mediację i w przystępny, jasny sposób zarówno stronom, jak i pełnomocnikom o tej mediacji mówili i zachęcali. I przy okazji, jeżeli mogę skorzystać, to chciałam wszystkich bardzo serdecznie zaprosić na webinar prowadzony i organizowany właśnie przez sędziów, który odbędzie się w najbliższy czwartek, 20 maja. Informacja o nim jest na stronie sądu. Czwartek.
20 maja.
Czwartek.
Okej.
I temat jest, czy w sprawach frankowych możliwe jest zawarcie ugody. I będą prezentowali właśnie sędziowie, zarówno z Warszawy, Gdańska, i będziemy rozmawiali na temat mediacji w sprawach frankowych. I tutaj naszą właśnie ideą jest to, żeby sędziowie również w tych sprawach kredytów frankowych, a później planujemy kolejne webinaria, żeby sędziowie wypowiedzieli się i promowali mediację. Także na stronie Sądu Okręgowego w Warszawie znajduje się link i zapraszam wszystkich serdecznie na to webinarium, czy ugody i czy mediacja są możliwe teraz w tych sprawach frankowych. Dziękuję bardzo.
Bardzo dziękuję. Bardzo dziękujemy. I proszę Państwa, teraz są takie pytania już skierowane do wszystkich, żeby Państwu pokazać skalę tego, to pan Fabisiak zadał pytanie do Państwa mediatorów z Polski, więc dosyć ogólnie zostaliśmy określeni. Moje spostrzeżenia są takie, iż w sporach pracowniczych nadal niechętnie korzysta się z mediacji, mówi pan Fabisiak. Jeżeli pani Fabisiak, to przepraszam, bo mam tylko inicjał imienia. Jaka jest tego przyczyna? I teraz są też wskazane możliwe odpowiedzi. Mniejsze zaufanie do mediacji, a może pracownicy są niechętni tej formie, bo słabo ją znają. O, Rafał Fabisiak na końcu się podpisał, więc już wiem, że nie przekręcałem, więc jeżeli ktoś z Państwa chce skomentować kwestię mediacji w sprawach pracowniczych, to bardzo proszę, najlepiej przez zgłoszenie i łapkę w górę. To tak, oczekując na to, że ktoś z Państwa będzie odważny, ponieważ ja nie mam żadnego doświadczenia praktycznego w sprawach pracowniczych, jakoś to prawo pracy mnie omija, to tutaj rzeczywiście, dlatego ja bym wolał, żeby ktoś z Państwa się wypowiedział, bo myślę, że samo prawo pracy jest odrobinę problematyczne, jeżeli chodzi o kwestię mediowania, bo jest tam dużo norm bezwzględnie obowiązujących, których nie da się zmienić na mocy ugody, czyli umowy. I na przykład chodzi mi o prawo, o zrzeczenie się prawa do wynagrodzenia, które bardzo często jednak te sprawy w jakiś sposób dotykają na przykład tej sfery, a również dotykają sfery ustalającej, która również, jeżeli chodzi o kwestie mediacji w tych powództwach o ukształtowanie, mediacja nie zawsze jest może w pełni rozwinąć swoje skrzydła. O, tak powiem dosyć dyplomatycznie. I dlatego ja bardzo tak liczyłem na to, żeby ktoś z Państwa to powiedział, ponieważ ja w zasadzie się zastanawiam i to jest teoretyzowanie, bo tak jak powiedziałem, już widzę, że Tomek się zgłosił, więc zaraz oddam głos. To jest teoretyzowanie i to jest jedyne, co jestem w stanie na ten temat powiedzieć, natomiast rzeczywiście gdzieś tam mam taki troszeczkę dysonans, jeżeli chodzi akurat o sprawy związane z prawem pracy i ich mediowanie, czy to, co niektórzy nie znoszą tego określenia, zdatność mediacyjną. Tomku?
To króciutko, najpierw odnosząc się do statystyk, ja o tym wspominałem, ale jeszcze raz przypomnę, że trochę w kontrze do postawionej tezy w tym pytaniu, ilość mediacji, jak się wydaje w sądach rejonowych, no bo tylko o takich mówimy tutaj, wzrosła, bo z 2600 w 2019, w 2020 do 3500. Oczywiście ten rok 2020 jest szczególny i tak jak pani sędzia wspomniała, no, po prostu trudno jest nawet znaleźć jakieś wskaźniki, które by taki czy inny kierunek determinowały. Natomiast wyraźny jest spadek mediacji prywatnych w sprawach pracy. tych pozasądowych, o tak to nazwę, czy umownych. Tutaj pik taki mieliśmy w 2016 i 2017 roku, a teraz i to było około 70 spraw protokołów zatwierdzonych, natomiast teraz mamy tylko i wyłącznie 6 w tym 2020 roku, więc jest to znacząca zmiana. Natomiast odnosząc się do tej drugiej części i Twojego komentarza, to ja mam zgoła inne doświadczenie. Być może to jest właśnie tak, że te bezwzględnie obowiązujące normy bardziej motywują strony do zawierania ugód. Ja przez lata nie prowadziłem mediacji pracowniczych i się w ogóle o nie nie starałem, a z jakiegoś powodu one właśnie w ostatnim roku zaczęły intensywniej spływać. Ja mam takie doświadczenie, że ja byłem zaskoczony, jak one są proste, te mediacje. Jak niewiele zaawansowanych narzędzi mediacyjnych musiałem wykorzystywać, żeby skłaniać strony do ugody. I myślę, że to wynika właśnie ze świadomości tej nieuchronności wyroku i tego, co się wydarzy, tej szczególnej pozycji pracownika. Natomiast co do samej ugody, rzeczywiście jest tam trudność. Tu na dwie kwestie chciałbym zwrócić uwagę. Pierwsza to ta szczególna norma w KPC dotycząca tego, że ugoda nie może naruszać słusznego interesu pracownika. I to dotyczy ugód w ogóle, ale oczywiście również ugód mediacyjnych. I teraz w związku z tym, że mamy tę szczególną normę, no to oprócz tego, że ugoda nie może być sprzeczna z prawem, to oczywiste, obchodzić prawa nie może być sprzeczna z zasadami współżycia społecznego, to jeszcze mamy szczególną normę, czyli jakby szczególną normę interpretacyjną tych zasad współżycia społecznego w kontekście pracownika. I tu rzeczywiście trzeba być uważnym, ale całkiem niedawno właśnie ugoda, którą zawieraliśmy, dotyczyła tego, że strony się umówiły, to było zaskakujące. Pracownik, tak naprawdę doszliśmy gdzieś tam głęboko do interesów. Nie chodziło mu o pieniądze, chodziło mu tylko i wyłącznie o to, że z nim nie porozmawiano w należyty sposób, że przekazano mu informacje nie tak jak trzeba i to go bardzo gniotło i bolało. I on się zgodził, znaczy w ogóle to była taka też bardzo ciekawy case, gdzie pełnomocnik był zaskoczony, jak szybko w negocjacjach, tak strategicznie, negocjacyjnie z punktu widzenia technik, pracownik odpuścił kwestię finansową, więc potem ta praca polegała w dużej mierze na powrocie do tego, żeby on jednak jakieś roszczenia finansowe postawił, ale te roszczenia się przekierowały na dofinansowanie jednostki, w której on pracował w tym zakładzie pracy, do sprzętu. No i była wątpliwość pełnomocników, jak i również moja, dyskutowaliśmy na ten temat, czy sędzia zatwierdzi taką ugodę, gdzie pracownik się zrzeka swoich roszczeń, a tak naprawdę pracodawca sam sobie do własnej jednostki nabywa za określoną kwotę ugodzoną sprzęt dla kolegów, byłych kolegów tego pracownika, który już odchodził z tego zakładu pracy. No i udało się skonsultować z panią sędzią i powiedziała, że absolutnie taką ugodę zatwierdzi i może ona pójść do przodu. Więc to taki przykład z życia, że tak powiem, wzięty, jak daleko taka ugoda może wykraczać poza te bezwzględnie obowiązujące normy, o których Cezary przed chwilą wspominałeś. Dziękuję.
Super, bardzo dziękuję. I to teraz ja przejdę do jeszcze jednego pytania, bo myślę, że troszkę nas czas goni. I to jest bardzo konkretne pytanie o jedną kwestię związaną z zawartością protokołu. Zadał to pytanie pan Michał Wiszniowski i ono brzmi dokładnie tak. W drodze wyjątku informacja o odebraniu od stron oświadczeń, iż żadne osoby postronne nie są obecne w ich miejscu przebywania oraz że nie przysłuchują się posiedzeniu mediacyjnemu online, może zostać ujęta przez mediatora w protokole. I oczywiście z podziękowaniami. Kto z Państwa by chciał podzielić się tym, czy to może być do protokołu wpisane, czy nie, mediacji. W protokole z przebiegu mediacji, tak, używając kodeksowych stwierdzeń. Mam nadzieję, że to jest kwestia opóźnienia na łączach. Proszę Państwa, dobrze to, żeby...
Ja już oddaję głos tak. i podłogę, jak to mówią w Anglii, innym.
Proszę bardzo, pani Pańska.
To tak na pierwszy rzut ucha, tak. Skoro protokół tworzy mediator, to obejmuje tak naprawdę jego spostrzeżenia, jego oświadczenia i jego ustalenia, tak? I oczywiście one są wskazane w kodeksie postępowania cywilnego, co tam się ma znaleźć. I chyba nie ma przeciwwskazań do tego, aby znalazło się takie stwierdzenie, aczkolwiek jak najbardziej, gdyby jednak doszło do konieczności badania tego, czy brał ktoś trzeci udział, no to jest droga otwarta, tak, bo to w żaden sposób nie zatwierdza. To ma wartość tylko i wyłącznie stwierdzenia, że padło takie oświadczenie, natomiast nie jest to ustalenie stanu faktycznego. No, chyba tak bym to rozumiała.
Znaczy w ogóle w protokole nie ma ustalenia stanu faktycznego, tak, więc to...
O to, że to jako pewne takie dodatkowe oświadczenie, które no jest niejako poza KPC, tak, bo nie jest określone, pozakodeksowe, może się znaleźć, aczkolwiek jego wartość jest, wydaje się, niewielka, tak. Tyle, że na chwilę zawierania tej ugody wszystkie strony są w tym przeświadczeniu. O, ja bym tak to odczytała.
Widzimy, że jeszcze 2 łapki w górę. Bardzo dziękuję. Pani mecenas Miszkin-Wojciechowska, dzień dobry i jak najbardziej prosimy o komentarz i odpowiedź.
Dzień dobry Państwu. Ja myślę, że to jest pytanie dotyczące tego protokołu, który zostaje sporządzany w mediacji, czy po przeprowadzeniu mediacji online, tak? Bo tego dotyczy ta dzisiejsza nasza konferencja, więc podejrzewam, że mediator chciałby tutaj, bo czuję, że to jest pytanie, które zostało skierowane do nas przez mediatora i mediator chciałby poinformować sąd, więc właśnie pytanie jak sąd i tutaj pani sędzia już z Gorzowa nam odpowiedziała, pozdrawiam Gorzów oczywiście, więc jeśli chodzi o to ja bym to traktowała trochę, proszę Państwa, na zasadzie paralelnej, czy też równoległej do tego pytania, które zadaje mediator stronom w trakcie mediacji, czy wyrażają zgodę na osobę mediatora, czy wyrażają zgodę na to, ażeby mediacja prowadzona została drogą online. I jeżeli strony wyrażają zgodę na takie kwestie, to również mogą wyrazić zgodę na to, żeby oświadczyć, że nikt inny nie przebywa w trakcie tego spotkania prowadzonego online w tym pomieszczeniu. Ja bym tak to rozumiała i nie widziałabym przeciwwskazań, żeby, bo pytanie chyba dotyczy, jeśli dobrze rozumiem, klauzuli poufności, czy w ogóle poufności i co może się znaleźć w protokole z takiego spotkania mediacyjnego, więc ja oceniłabym, że tak, może się znaleźć taka informacja, że strony złożyły tego typu oświadczenie, że nikt inny nie przebywa w tym pomieszczeniu. I proszę Państwa, wydaje mi się, że niezależnie od oceny i interpretacji prawnej takiego oświadczenia, ono jest istotne o tyle, że strony stwierdzając czy oświadczając publicznie wobec tego świadka interakcji, jakim jest mediator, i wobec drugiej strony zupełnie inaczej podchodzą do tego, co się w tym spotkaniu online dzieje, zadarza i faktycznie składają tutaj oświadczenie o prawdziwości i o dobrych intencjach swojego uczestnictwa w tym spotkaniu. Tak ja bym to zrozumiała i tak bym na taki protokół wyraziła zgodę, oceniając taki protokół. Tak mi się wydaje. Dziękuję bardzo.
Super, dziękuję bardzo. Pan mecenas, pan doktor Antoszek, czy też, bo widziałem łapkę w górę przez chwilkę, a teraz widzę już jej brak. Nie?
To była po prostu nieopuszczona łapka z poprzedniej części.
Rozumiem. Dobrze, to ja też mam jedno zdanie do powiedzenia odnośnie tego protokołu, bo ja rzeczywiście nawet swoją mowę wstępną odrobinę zmieniłem w stosunku do tych mediacji online i jakby dodałem tam coś, co działa. To znaczy, ja, zwłaszcza jeżeli są pełnomocnicy obecni na mediacji, to tam tym bardziej, jeżeli się powie o KPC, to rzeczywiście może przynieść to efekt, czyli o kodeksie postępowania cywilnego. Powiedziałem, że po prostu zmienił się kodeks postępowania cywilnego w 2015 roku dotyczącym kwestii poufności, że teraz tam to już nie są tylko strony i mediator, ale wszystkie osoby uczestniczące w mediacji są zobowiązane do zachowania poufności. Jak one usłyszą coś takiego, to ja mówię, więc mam nadzieję, że u Państwa nikt więcej poza tymi, których widzę na kamerce, nie ma. I oni nagle, nie, jesteśmy tylko my. I rzeczywiście to naprawdę takie coś, no może bez aż takiego teatru podczas mediacji, ale rzeczywiście w ten sposób to zmieniłem. Natomiast z drugiej strony, jeżeli by były inne osoby uczestniczące, to po prostu powinno być wskazane jako osoby uczestniczące w mediacji, tak mnie się wydaje, bo rzeczywiście my mamy zmianę w tym KPC, wcześniej były tylko strony, no więc wtedy można by się dopytać o kwestię pełnomocnictwa, o wszystkie tego typu formalności, żeby faktycznie te osoby biorące udział w mediacji mogły się wykazać jakimś umocowaniem i to też myślę, że w dużej mierze zapobiegnie osobom postronnym w pomieszczeniu, ale ja też wrócę do tego, od czego zacząłem naszą dzisiejszą moderację, czyli niedemonizowaniu mediacji online. Oczywiście, że nie jesteśmy w stanie w 100% sprawdzić tego, co się dzieje w tym wąskim wycinku, które widzimy na kamerze. Oczywiście, że nie jesteśmy w stanie zobaczyć tego, co się dzieje za tym białym ekranem, który jest za mną i nie wiedzą Państwo, ile tam jeszcze jest osób. Więc pewnie, że rzeczywiście nie wszystko jesteśmy w stanie zrobić, więc jedyne co, to możemy tylko przypomnieć tak, że nawet te osoby za tym takim prawie, że już przysłowiowym ekranem usłyszą, że jeżeli ktoś tam jest za tym ekranem, on też jest zobowiązany do poufności w mediacji, to wtedy rzeczywiście może to odnieść swój skutek i możemy nagle usłyszeć, jeszcze to mi się nie zdarzyło, ale możemy usłyszeć to, że nagle się drzwi zamkną i ktoś z tego pokoju jednak wyjdzie, którego od samego początku nie było widać na kamerce. I teraz, proszę Państwa, ja mam jeszcze jeden taki komentarz, tylko on jest dosyć długi, więc też nie jest skierowany do konkretnego panelisty, więc ja będę znowu prosił Państwa o po prostu rączki w górę, żebym wiedział, kto z Państwa chce się wypowiedzieć. Ja niestety, jeżeli będę czytał, Państwo w trakcie będą się zgłaszać, nie będę widział kolejności, więc pozwolę sobie jakoś tę kolejność po prostu ustalić. Po pierwsze wszyscy usłyszeliśmy, a właściwie organizatorzy usłyszeli gratulacje, czyli gratuluję organizatorom konferencji podjęcia istotnego i aktualnego problemu badawczego oraz zaproszenia do udziału tak wielu znakomitych prelegentów. Ze względu na mój zakres badań naukowych jest to komentarz od pana doktora, to są właściwie pytania, od pana doktora Pawła Witkowskiego z Wydziału Organizacji i Zarządzania Politechniki Śląskiej. Ze względu na mój zakres badań naukowych interesuje mnie w szczególności problem mediacji w toku postępowań w sprawach administracyjnych, cywilnych, gospodarczych i rodzinnych, czyli w zasadzie nie ma tylko spraw karnych. Z moich badań i obserwacji wynika, że najmniej postępowań mediacyjnych realizowanych jest w ramach postępowań administracyjnych. Oczywiście jest tego wiele powodów, na przykład obowiązkowość mediacji w niektórych sprawach. Moim zdaniem głównym powodem jest to, że czas oczekiwania na orzeczenie sądowe jest znacznie dłuższy niż termin załatwienia sprawy administracyjnej. I to jest ciekawe, no bo oczywiście jakby od razu troszeczkę dopowiadając, no u nas jedyna mediacja obowiązkowa na razie w Polsce to jest przy sporach zbiorowych sprawa pracy, bo inaczej strajk byłby nielegalny, jeżeli nie ma próby mediacyjnej, tak? Bo innej obligatoryjnej mediacji na razie u nas, obligatoryjnej próby mediacji na razie w naszym porządku prawnym nie ma. W zeszłym roku były zakusy w sprawach rodzinnych, ale w końcu zostało ten przepis usunięty. Czy Państwo prelegenci potwierdzają, że też z Państwa doświadczenia najmniej tych postępowań mediacyjnych jest realizowanych w sprawach w ramach postępowań administracyjnych? Próbuję to przeformułować, ja jestem dopiero w 1/3 tego bardzo dużego komentarza. Z Państwa w ogóle, jeżeli chodzi o sprawy administracyjne? O, pani Małgosia, bardzo proszę, pani dyrektor. Nie słyszymy, chyba wyłączony mikrofon.
Tak, już włączyłam, już pani sędzia mi tutaj pokazała. Dziękuję bardzo, że mnie nie słychać. Czuję się wywołana do odpowiedzi poniekąd ze względu na to, że pani mecenas Maria Młotkowska, która jest dyrektorem Departamentu Prawnego Miasta Stołecznego Warszawy, która otrzymała notabene między innymi za to przedsięwzięcie tytuł ambasadora mediacji w 2020 roku. Dzięki jej staraniom doprowadzono do podpisania porozumienia o wprowadzeniu mediacji administracyjnej do Urzędu Miasta Stołecznego Warszawy. To porozumienie zostało podpisane przez Urząd Miasta Stołecznego Warszawy w osobie pana Rafała Trzaskowskiego i Konfederację Lewiatan w osobie pana Macieja Wituckiego. I to zostało podpisane w 28 lutego 2020 roku. Po czym nastąpił duży blok szkoleniowy. Były to szkolenia, które ostatecznie podczas których przeszkolono około 230 urzędników Miasta Stołecznego Warszawy. I proszę Państwa, muszę Państwu powiedzieć, że mimo tych właśnie dużych starań i takiej ciężkiej pracy, inwestycji, tłumaczenia urzędnikom, na czym to będzie polegać. Procedurę, proszę Państwa, z procedurą możecie się zapoznać również na odpowiednich stronach Urzędu Miasta Stołecznego Warszawy. Można zadzwonić pod numer 915 i dowiedzieć się, w jaki sposób ta procedura zostanie przeprowadzona. I mimo tej takiej intensywnej pracy i starań muszę stwierdzić, że na razie tych postępowań w Urzędzie Miasta Stołecznego Warszawy zbyt dużo nie ma. I myślę, że jest to faktycznie, tutaj odpowiadając panu badawczowi na to pytanie badawcze, lata wymagają pewnej zmiany struktury myślenia urzędnika o swoich obowiązkach. Cały czas pokutuje jednak to obciążenie, że społeczeństwo, obywatel przychodzi do urzędu jako petent, który chciałby załatwić jakąś sprawę. I niestety jest w ten sposób trochę traktowany. Dochodzi oczywiście do tego ta kwestia odpowiedzialności urzędnika czy kierownika w danej jednostce, w odpowiedzialności z tytułu dyscypliny finansów publicznych. Oczywiście wprowadzono do tej ustawy w artykuł 54a ustawy o dyscyplinie, o naruszenia dyscypliny finansów publicznych, natomiast który to artykuł pozwala na przygotowanie opinii w zakresie celowości czy też przydatności, efektywności prowadzenia postępowania sądowego w danej sprawie i w takim razie można by przyjąć, że jeżeli nie ma, czy nieefektywne byłoby prowadzenie postępowania sądowego w danej sprawie, to mógłby ten urzędnik decyzję korzystną na rzecz właśnie petenta, czy też korzystną dla urzędu, proszę Państwa, bo ugoda ma ostatecznie satysfakcjonować obie strony w postępowaniu takim administracyjnym, więc tutaj powinnam poruszyć wiele wątków, na co dzisiaj prawdopodobnie nie mamy po prostu czasu. Jest to bardzo skomplikowana kwestia. Były przecież przepisy, które wprowadziły możliwość prowadzenia mediacji w postępowaniu sądowo-administracyjnym. Jeśli Państwo zwrócicie uwagę na statystyki, było ich po prostu nawet nie promil procenta, tylko jakieś bardzo minimalne liczby. Następnie w 2017 roku wprowadzono artykułem 96a do literki bodajże N przepisy, które wprowadzają postępowanie mediacyjne, mediację do kodeksu postępowania administracyjnego i to jest możliwe i na bazie tego właśnie została podjęta to przedsięwzięcie, czy podpisanie tego porozumienia właśnie z Urzędem Miasta Stołecznego Warszawy, mając na celu w zasadzie nauczenie urzędników poprzez miasto, lidera, stolicę w Polsce, prowadzenia tych postępowań. Ja liczę na to, że to z czasem ugruntuje się. Wiecie Państwo, wydaje mi się, że z mediacją to jest, która dla mnie jest królową wszystkich ADR-ów, jest trochę tak, że musimy się jej nauczyć i konsekwentnie edukować zarówno siebie, pełnomocników. Teraz przyszedł nam z pomocą sąd, czy też sędziowie. Dziękuję bardzo pani Monice Włodarczyk i wszystkim sędziom, którzy nas dzisiaj słuchają, za zaangażowanie się w tą promocję tych alternatywnych metod do rozwiązywania sporów. I działajmy, po prostu trzeba pracować i edukować zarówno siebie, jak i kolegów pełnomocników, jak i obywateli. Także myślę, że i na mediację administracyjną przyjdzie czas. Dziękuję bardzo. Ja dosyć długo na ten temat mówię, ale dziękuję bardzo.
Ale naprawdę czytasz moich myślach, Małgosiu, ponieważ rzeczywiście bardzo chciałem Ciebie właśnie wywołać do tablicy, bo właśnie ze względu na tę wiedzę, którą nam przekazałaś, faktycznie, jeżeli chodzi o postępowania administracyjne, ja też mogę jedynie dopowiedzieć, że to jest promil, ale też ja chyba takim staram się być tutaj zwiastunem dobrych wiadomości. Przynajmniej wiadomości, które płyną z Krakowa, są takie, że być może się ruszy coś, może nawet nie w samym urzędzie miasta, ale no, ja rzeczywiście dostałem już nie jako mediator, ale akurat jako pełnomocnik strony pismo w zakresie takiej, że ze względu właśnie na bardzo wydłużony okres czasu i oczekiwania na rozstrzygnięcie, samorządowe kolegium odwoławcze zwróciło się z propozycją w zasadzie, czyli tym poinformowaniem w świetle tego 96, już nie pamiętam z którą literką, KPA, poinformowaniem o tym, że jest możliwość tej mediacji. Z KPA tu też jest jeden taki problem, że co podnoszą komentatorzy, że te artykuły wprowadzające mediację z 1 czerwca 2017 roku, one są nieskorelowane z tą ugodą administracyjną, która już była w KPA, czyli 114 do 121. I tam faktycznie jest jakby trochę dualizm ugody, bo z jednej strony, jeżeli mamy tę mediację pionową, czyli pomiędzy organem a stroną, i widzę, że pan mecenas Nowaczyk się zgłasza, więc ja tylko dokończę zdanie i oddaję głos, to tam no, nie mamy ugody, tylko są te ustalenia, które stanowią podstawę dla później wydanej decyzji, czy rozstrzygnięcia przez organ, a w poziomej mediacji mamy ugodę pomiędzy stronami, jeżeli jest więcej niż jedna strona, i tutaj jest takie nie do końca skorelowanie tych przepisów właśnie z tymi już o ugodzie administracyjnej 114 do 121, dodany jeden, tylko 121 chyba ze znaczkiem 1 albo i 121a, nie pamiętam, ale to wszystko, jeżeli chodzi o KPA, i tam też faktycznie ja bym tylko był tym echem, które dopowie, musimy się chyba jeszcze trochę tego nauczyć i wtedy wszystko będzie działało jak najbardziej. Oddaję głos panu mecenasowi.
Ja chciałem dodać tylko króciutki komunikat, mianowicie udało mi się poprowadzić pierwszą w historii mediację przed Urzędem Patentowym Rzeczpospolitej Polskiej. Miejsce dość niezwykłe do zawierania ugód. Do tej pory nikomu to się wcześniej nie udało. Pierwsza ugoda z urzędem przejdzie do historii, a rezultat jest taki, że Wojewódzki Sąd Administracyjny w Warszawie wyznacza mnie mediatorem w każdej następnej sprawie, którą ma z Urzędu Patentowego. Dziękuję.
Bardzo dziękuję panie mecenasie. Przechodząc dalej do tego komentarza, jednym z celów mediacji jest szybsze uzyskanie rozstrzygnięcia sporu. Cel ten w perspektywie terminów załatwiania spraw można uzyskać w sporach rozstrzyganych przez sądy, a rzadziej w sprawach administracyjnych, które są załatwiane sprawniej. Inną okolicznością mającą wpływ na ilość postępowań mediacyjnych w danym rodzaju spraw jest stosunek kosztów mediacji w stosunku do ogólnych kosztów postępowania, pisze pan dr Witkowski. W postępowaniach administracyjnych stosunek jest najbardziej niekorzystny dla mediacji. Uważam, to jest oczywiście, ja cytuję pana doktora Witkowskiego, że istotną wartością mediacji jest czynnik ludzki, w cudzysłowie, ludzkie podejście również w cudzysłowie. Nowe technologie w określonych okolicznościach, na przykład w czasie pandemii lub ze względu na bardzo duże odległości uczestników mediacji, są pomocne i wręcz nieodzowne. Jednakże odhumanizowanie procesu mediacji, nawiązanie do tematu całej konferencji lub arbitrażu w nawiasie, na skutek stosowania sztucznej inteligencji powoduje, że moim zdaniem należy ją stosować tylko w wyjątkowych okolicznościach. Dziękuję za możliwość wzięcia udziału w tak interesującej konferencji. Czekając na Państwa zgłoszenia co do jeszcze dodatkowych tych czynników, dlaczego czy skomentowania tych czynników, dlaczego w tych sprawach administracyjnych tych mediacji jest na razie tak mało. I poza tymi wskazanymi właśnie przez panią dyrektor Miszkin-Wojciechowską odnośnie zaangażowania Urzędu Miasta Stołecznego Warszawy, pana mecenasa Nowaczyka odnośnie Urzędu Patentowego Rzeczypospolitej Polskiej. Ja jedyne, co bym dopowiedział też tym razem będę tym negującym, to znaczy na szczęście nasz porządek prawny jeszcze nie dopuszcza sztucznej inteligencji jako na przykład mediatora. Tam jest mowa wprost, nie pamiętam czy jest napisane dokładnie osoba fizyczna, czy jest powiedziane kto może być, inaczej, w inny sposób to sformułowane, ale rzeczywiście musi to być osoba, nie może to być na przykład sztuczna inteligencja, ale z drugiej strony przecież mamy kwestię tego big data, gdzie właśnie PayPal, to PayPal i eBay to są chyba te dwa koncerny, to są dane, które czytałem chyba w 2016 roku, ze względu na ilość sporów, które zostały u nich rozstrzygane z udziałem konsumentów, rzeczywiście potrafili wyprowadzić algorytm, który potrafił tę pierwszą fazę wstępną przeprowadzić bez udziału czynnika ludzkiego, gdzie dopiero w momencie, jeżeli konsument, który kwestionował coś, się na to nie zgadzał, dopiero wtedy przychodziło do tego właśnie czynnika ludzkiego. Ja już nie pamiętam, czy to było zrobione na zasadzie arbitrażu, czy to jednak były mediacje, ale faktycznie coś takiego jest. Być może de lege ferenda, jednak powinniśmy się nad tym zastanowić. Ja oczywiście mówię to teraz wbrew mediatorom, osobom fizycznym, ale to jest raczej coś do zastanowienia się i ewentualne pytanie, które bym dołożył od siebie w temacie dzisiejszej konferencji, bardzo licząc na Państwa komentarze. I Małgorzata Miszkin-Wojciechowska się zgłasza od razu. Proszę bardzo.
Ale to było pytanie, panie mecenasie Cezary, bo ja w zasadzie tylko jako kontynuację wypowiedzi tutaj z poprzedniej części pomyślałam sobie, czy to jest dobry moment, żeby powiedzieć, kto został w tym roku uhonorowany nagrodą ambasadora mediacji przez Krajową Izbę Radców Prawnych. Mam nadzieję, że tak.
Na to zawsze jest dobry moment, bardzo proszę.
Więc ambasadorem mediacji w roku 2021 nagrodzona przez Krajową Izbę Radców Prawnych została pani sędzia Sądu Okręgowego Agnieszka Owczarewicz, Wydział Gospodarczy, która bardzo jest zaangażowana we wszelkiego rodzaju promocję mediacji w Sądzie Okręgowym w Warszawie, ale nie tylko. Sama podczas posiedzeń przygotowawczych kieruje strony do mediacji, przekonuje pełnomocników do tego, że to jest dobra metoda, także jest przede wszystkim członkiem ŻEM i jesteśmy szczęśliwi, że właśnie pani sędzia Agnieszka Owczarewicz została nagrodzona tą nagrodą, bo myślę, że właśnie sędziowie są tymi osobami, które mają szacunek u obywateli, u stron podczas postępowań sądowych i mogę tak powiedzieć, słuchają się sądu, składów orzekających. Także jeżeli sąd kieruje strony do mediacji, to ma w tym jakiś ukryty cel i myślę, że szanują zdanie sędziego. Także bardzo się cieszę, że mogłam to Państwu dzisiaj powiedzieć. Dziękuję bardzo.
Super, bardzo dziękuję. Również dołączam do gratulacji. Dla pani sędzi gratuluję rzeczywiście pięknego wyróżnienia. I proszę bardzo, jeszcze ktoś z Państwa chce powiedzieć coś na temat tej mediacji online, czy pani Miszkin-Wojciechowska, rozumiem, że to już jest łapka z poprzedniej wypowiedzi. opuszczona. Jeszcze po prostu nie opuszczona. No pewnie, proszę bardzo.
Proszę Państwa, w uzupełnieniu co do mediacji nie ma fizycznie nagrań innych krajów, a dotyczących mediacji, a mianowicie chodzi o Gruzję, gdzie współpracujemy z kolegami z Tbilisi, z Batumi. Obiecają, że opracowanie prześlą. Opracowanie będzie dostępne na naszej stronie internetowej. Również mamy, i to będzie też udostępnione, opracowanie na temat arbitrażu i mediacji z Uzbekistanu. Profesor Nazarow z Taszkentu przesłał opracowanie, natomiast miał techniczne problemy z nagraniem wystąpienia. No cóż, te opracowanie zostaną również udostępnione. Państwa, nie wiem, Państwa, bardzo dziękuję. Proszę Państwa, ta konferencja to jest zasługa pana mecenasa Nowaczyka i współpracujących osób, których chcę wymienić personalnie. To jest pan Krystian Mularczyk, prodziekan Izby Radców Prawnych Wrocławia. To jest pan Robert Cichusz ze Szczecina. Te osoby były zaangażowane i dużo nam pomogły. Chciałem podziękować również tym panom, których dzielnie nas wspomagają technicznie, a bez których pomocy nie udałaby się ta konferencja. To są panowie Torchała, którzy tu siedzą i cały czas obsługują technicznie. Dzięki nim to sprawnie i coraz lepiej niż w ubiegłym roku ta konferencja się udziała. Dziękuję tłumaczom, którzy też tłumaczyli. Nie ma ich obecnie, natomiast to już od lat pomagają nam i sprawnie tłumaczą na te języki konferencyjne, bo mamy rosyjski i mamy język angielski. Dziękuję też wszystkim, którzy nam pomagali, władzom samorządowym Nowego Tomyśla, które nam wspierają, promują arbitraż i mediację. Mam na myśli pana starostę nowotomyskiego, pana burmistrza Nowego Tomyśla. Między innymi dzięki nim ta konferencja może się odbyć. Raz jeszcze, że Państwo dotrwaliście do tej godziny i słyszeliście rzeczywiście, co się dzieje w światowym arbitrażu, no i co się dzieje w mediacji, która, jak widzimy, bardzo się rozwija w różnych dyscyplinach. Trochę mamy w Polsce gorzej z arbitrażu. Ta konferencja ma być przykładem tego, że należy współpracować i jednoczyć swoje siły, zarówno w mediacji, ale jak w arbitrażu, tak, żeby sytuacja, która jest zła w arbitrażu, się poprawiła. No ale żeby się poprawiła, to trzeba ADR-y promować. To nie jest tylko Nowy Tomyśl, ale to jest też zadanie dla wiodących sądów warszawskich, które powinny popularyzować arbitraż. Dziękuję jeszcze raz Państwu za obecność, za wytrwałość. Bardziej, że osoby, które nas pomagają, to już kilka lat z nami współpracują. Mamy 14. konferencję. Mam nadzieję, że do 15 żyjemy i nie będzie już wirusa. Rzeczywiście te kontakty osobiste, równo w mediacji i arbitrażu. Stawmy roboty na bok, niech nam pomagają, ale niech nas nie zastępują. Dziękuję bardzo za uwagę. Dziękuję.
Również bardzo dziękuję. Również bardzo dziękuję za zaproszenie, że mogłem też przyjechać do Nowego Tomyśla i z wszystkimi Państwem się spotkać w tej formie online. Mam nadzieję, że może za rok już w formie tradycyjnej. Wszystkiego dobrego. Gratuluję Państwa wystąpień.